everyone. Hi, everyone. For those who don't know me, my name is Mike Clausen. I'm the spokesperson at the U.S. mission to the EU. The delegation is running just a few minutes late, but we're shortly going to be asking you to take your seats. And then afterwards, the delegation has a flight to catch, so I'd appreciate if everyone could remain seated until they've left the room. Thank you, and I'll be back up here soon. Hi, everyone. I'm sorry for the delay, but we expect that the speaker will be up here in just a few more moments. So if you could take your seats, we're going to close the doors. So it should just be 2 more minutes. Thank you.
guess it's still morning. Good morning, everyone. Very honored to be here with a very distinguished delegation from the Congress of the United States. This is only part of the representation of our country that has been in Europe in the past several days. We began our visit in Munich, where around 10% of the Congress was present, Democrats and Republicans, members of the House, members of the Senate, all of them here reaffirming our commitment to the transatlantic alliance, our commitment to NATO, our respect for the European Union, and our ability and desire for us all to work together to strengthen the alliance and all of our institutions connected there. In Munich, we had the opportunity to meet with the NATO Supreme Allied Commander, with German and Canadian foreign officials, with the President of Afghanistan, because that, of course, is a NATO connection for all of us, and had important meetings here in Belgium with the Secretary General of NATO, the Prime Minister of Belgium, the President of the European Union, High Representative Mogherini, and we've had opportunities to share our views, ask our questions, and make some observations, which you're going to hear from. I'll just close by saying, now that we're all gathered, that when President Truman signed the NATO agreement 70 years ago, he spoke of and I quote, long step toward permanent peace in the whole world. That was quite an ambitious undertaking, and 70 years later, we celebrate it and we support it as we go into the future for peace in the whole world. With that, I'm pleased to yield to the distinguished, well, he'll introduce himself. We're going to be as brisk as possible so we can get to your questions. Mr. Engel.
Yes. Thank you, Madam Speaker. I'm Elliot Engel. I'm chairman of the House of Representatives Foreign Affairs Committee in Washington. I'm a representative from New York. We are all here speaking with one voice, led by our speaker, to say that the alliance, the Atlantic Alliance, is strong and long and doing well, and we all feel very, very strongly about it. And, you know, in a family, there are ups and downs and disagreements and whatever, but we are of the same family. We share the same worldview, we share the same views, and we have, as our speaker has pointed out, a very large percentage of the American Congress, first in Germany for the Munich conference and here now in Belgium, because we think that things sometimes are bumpy, but they straighten out, and we want it to straighten out. We want to really work together, and it's really so important, and we can only do it together. So I just want to tell you that we're of different parties here. We all feel the same way. We know that the future of America and Europe is intertwined, and we're going to do everything we can to make sure that future is a bright one indeed. Thank you very much.
Good afternoon. I'm Adam Schiff. I'm a member of Congress from California and chair of the House Intelligence Committee. We came to Europe in great numbers, probably the biggest numbers that have come to the Munich conference or come to NATO, to show our bipartisan support for NATO, our resolute commitment to NATO, but also our commitment to Europe and the European Union. Whatever differences we have are transient. Our shared interests and our shared values are indelible and longstanding and as strong as ever. We came to talk about our commitment to democracy, our commitment to human rights, the necessity that we stand together in the face of the threat posed by Russia and others. And I think we had some very important and meaningful discussions, but at the end of the day, our most important purpose in being here on a bipartisan basis is to voice our unequivocal support for NATO and for Europe and for this enduring partnership that is so important to the future of liberal democracy. Thank you.
Good morning. I'm Congressman Gregory Meeks from New York. I serve on the Foreign Affairs Committee. I'm the co-chair of the EU caucus. And again, I reiterate that the strongest alliance that we have is with our cross-Atlantic partners, the EU and NATO. And we wanted to make sure that we were here to demonstrate that commitment that the members of the United States Congress will never, ever allow small differences to cause a divide between us. That ocean doesn't divide us. That ocean is actually going to unite us. We're building a bridge across the Atlantic Ocean so that the world can see that we share the same values, we are together, we may have a squabble, but those squabbles will dissolve, and we will stand together to lead the world with our values.
Hello, my name's Steve Lynch. I'm the chairman of the National Security Subcommittee on Oversight. And I'm a son of Ireland and a son of Germany. And I come from a nation of immigrants, and many of those European immigrants. The bond between the United States and Europe is unbreakable. And our presence here, hopefully, is a demonstration of our commitment to that relationship. I want to really thank Speaker Pelosi for her commitment to the alliances between our country and the nations of the EU and of NATO. The basic freedoms that we all enjoy are threatened by Russia, by interference with our democratically conducted elections, and it's important that we are stronger now than ever. But and we also want to thank the way we were embraced in Munich and the way we were embraced here in Brussels during our visit. Thank you.
Good morning, I'm Jackie Spear. I'm from California. And I think the simple message we want to leave as we depart is that we are family. We are family and will continue to be family. We may have sibling rivalries from time to time, but we are joined together with blood. And on this trip in particular, what has crystallized for me is the importance for all of us to listen to our family members, to remain united, and to go forward realizing we are so much stronger together than apart.
Good morning. My name is Jerry Connolly. I'm Congressman from Virginia, and I head the U.S. delegation here to the NATO Parliamentary Assembly. It's a great privilege to stand here with my colleagues and especially with Speaker Pelosi. It is a powerful statement that the third highest official in the United States government, the Speaker of the House of Representatives, has chosen to come to Europe at this time, both to the Munich Security Conference and here to the Parliamentary Assembly in Brussels. I think it speaks for itself what that commitment represents. It is a firm, full-throated, unequivocal reaffirmation of the United States' commitment to collective security, but more importantly, to the reassertion of Western liberal values. And we want to thank Vladimir Putin for bringing us all together to reaffirm those values. If there's any doubt in our adversaries' minds about our collective will to fight for those values, I hope today clears that up. Thank you, Madam Speaker, for having us here today.
I'm Bill Keating from Massachusetts. Good afternoon. I'd like to tell you that this week these few days have been special. I come from grandparents who are from Europe. I'm very proud of that. I have an uncle who lost his life and was killed on French soil defending our countries. We face common enemies right now and challenges. We face challenges from terrorists, from Russia, from China, but we have something they don't. We have a coalition, and that's what makes us strong. That same coalition is necessary as well with other challenges we have: climate change, human rights, the threat of nuclear proliferation. All these things can't be done by one country alone, but together we'll be able to meet those challenges. And that's what these days are about, reaffirming that historic coalition. Thank you.
Yeah, my name is Philemon Vela. I'm from Texas. I want to first thank Speaker Pelosi for inviting us to join her here in Europe this week. It is my belief that the future of world peace depends on the strengthening of the NATO alliance. As great of a threat that Russia might be, an even greater threat is a weakened NATO alliance. And on that note, I must say that we, as members of NATO, must speak as one against aggressions such as those against Russian citizens in London and against the murder of James Khashoggi in Turkey. Thank you.
Hello, I'm Katie Hill. I am one of the new representatives to Congress. I'm the freshman representative to leadership. My great-great-grandfather served here in World War I, my great-grandfather in World War II, my grandfather during the Cold War, the height of the Cold War, and my father right before the Berlin Wall. He left the Air Force right before the Berlin Wall fell. And here I am entering this new generation where we have to affirm our alliances more than ever, where we are facing new threats, and together we must work to eliminate those and to fight them. And as part of this new Congress, as the future is dependent upon all of us, we are here, we're standing with you, and we look forward to working with you as we go forward. Thank you.
Bonjour, je m'appelle Rick Larson. Je suis de l'État de Washington et c'est tout le monde français. So thank you for being here, and thank you to Speaker Pelosi for allowing me to say briefly. I'm a member of the House Armed Services Committee in the U.S. Congress, and I have been on that committee now for over 18 years. Throughout that time, the House Armed Services Committee, both Democrats and Republicans, have been consistently pro-NATO, and much has been made of the things that have been said in the United States about our support for NATO. I would only ask that you look at what Congress does. Budgets pass by the U.S. Congress that continue to show strong support for our commitment to NATO and our commitment to our NATO allies. And that is the basic message I'm delivering to the NATO Parliamentary Assembly friends that we have downstairs as well. So thank you very much.
Bom dia, amigos. I am a third-generation American of Portuguese descent, and I am honored to be a part of this tour de force with Speaker Pelosi. This bipartisan delegation is among the largest ever to come to the Munich conference. Over 10% of the Congress to Munich and to Brussels to reaffirm our strong support for NATO. Last month we passed a resolution 357 to 22 reinforcing that long-term commitment as we celebrate the 70th anniversary of NATO and the 30th anniversary of the fall of the Berlin Wall. Make no mistake about it, the majority of Americans, and I should say probably Europeans, do not realize this is the longest peacetime period in Europe in over 1,000 years. Think about that. This last 70 years is the longest peacetime period in Europe in over 1,000 years. And NATO and the structures that we in the United States and Europe together with the European Union and the other efforts are the pillars, the glue of the maintenance of this strong relationship that is so crucial. As a member of the Transatlantic Legislators Dialogue, and thankfully, Madam Speaker, to chair the Transatlantic Legislators Dialogue, we have a host of organizations here that are part of our ongoing efforts to maintain the strong vitality of this partnership. Thank you very much.
Thank you, my colleagues, for your comments, but also for your great leadership, the depth of experience and knowledge, legislatively and otherwise, that you bring to this meeting have made a very big difference and commanded great respect. When I first came to my first North Atlantic, was called North Atlantic Assemblies then, now it's North Atlantic Parliamentary Assembly, the Berlin Wall was still up. It was in the late 80s. The Berlin Wall was still up, and that was the big challenge, of course. Since then, over the years, other issues have emerged, other challenges have emerged. The war against terrorism, issues that relate to cybersecurity, just so many issues of money laundering, the rest, exploitations that would not have even been possible then because technology wasn't where it is. But in any event, all the more reason for us to have a reinforced relationship with our NATO allies and to support the mobility and infrastructure that the EU is injecting into that security. Now more than ever, we need NATO as we go forward because the challenges are more complicated than a bipolar relationship with the Soviet Union. It's now much more diverse, and therefore the friendships that we have much more important. My colleagues would be happy to take any questions you might have.
So the delegation has to leave very quickly, but we'll take a question from Lauren Cook, Associated Press.
Yes.
Speaker Pelosi, in some ways your mission seems a little like damage limitation. Working here in Brussels, we very much have the sense that NATO allies no longer quite understand the messages that are coming out from the United States. Yesterday, a Belgian journalist, I believe, asked you whether Belgium is an ally of the United States.
Of course.
How do you go about repairing that damage and sending clear messages?
Well, I think our message is a very clear one. When 10% of the Congress comes to Europe for the Munich Security Conference, as well as continuing on here with even more additional members present. One of the parliamentarians just asked me as I was leaving, why did you only now just pass this resolution about NATO that has such strong bipartisan support? I said, well, because we just got the majority. And then we can control what goes on to manage what goes on to the floor. But once our Republican colleagues had the opportunity to vote on this H.R. 676 NATO Support Act, which Mr. Costa referenced, what was it, 357 to 22 no. I think that sends a very clear message. We're also we're not a parliamentary government, even though we're parliamentarians. We have Article 1, the legislative branch, the first branch of government, co-equal to the other branches, and we have asserted ourselves in that way.
All right, last question, Michael Burned on Washington Post.
Where's Michael?
Michael Burned on Washington Post. I just wanted to ask, in your meetings with your European colleagues just now, was there specific advice that you gave them about what they can do to interact with the United States and its branches of government now that Democrats control the House that they weren't able to do when there was full Republican control of Washington?
Well, I'm going to yield to my colleagues, but I don't think that there's any difference between Democrats and Republicans on our relationship with NATO. This is not partisan in any way. But let me defer to Jerry Conley. Did he leave us? Oh, here he is. I looked there. Who is our chairman of our delegation to the
Thank you, Madam Speaker. Look, Republicans as well as Democrats in this last 2-year period have been working diligently in these organizations as one. When it comes to affirming our support for the Western Alliance, expanding it, and deepening our commitment to those values and to that collective security, I don't think there's any doubt. As the Speaker said, I think this resolution, this is when do we ever get votes that overwhelming in the United States Congress? And this is on a foreign policy issue. And I think it absolutely is sending a message. And in terms of the question of, is this a reassurance tour? I think it's a reminder tour that the United States government is not just one branch. And that, as the Speaker said, Article 1, the first article in the Constitution of the United States deals with the powers of the legislative branch, not the executive branch. And those powers include war and peace and even direction of the armed forces. So there's implied foreign policy. And the power of the purse, of course, always important, as the Speaker said. So I think we're here to reaffirm and remind our colleagues at a time where maybe some doubts have been planted to clear those doubts up.
I just may conclude by saying, when you asked, were we giving them any advice, that we came here to listen. And yesterday, when we started our meeting with the president of the EU, he said, "I'm here to listen." I said, "Well, we're here to listen. This could be a very silent meeting." However, it wasn't. And it went on for an hour and a half of our learning from each other, and that's what this is about. It's about one word. It's about respect. It's about not only how we discuss our differences, but how we do so in a manner that recognizes the importance of all parties to the discussion. Thank you all very much. Thank you. Okay, thank you, John.
Describing Mr. Westgate as a purported expert. There's that word purported again, the word that people use when they don't want to believe the truth. What's his expertise? The court has his report in front of it, but I'll just read it out for the benefit of India in case my learned friend never read it. Paragraph 3. In the course of my work, I've examined many thousands of travel documents. Specifically, I have experience of Indian travel documents due to my 3 years' experience in the region and the follow-up work I conducted while serving at the NDFU, National Document Fraud Unit of the United Kingdom, which is the centre of knowledge and information for the UK Home Office for all travel documents. Paragraph 5. I'm presently engaged in forensic analysis and business support for a major international company that produces passports and identity cards. Paragraph 7. On 7th of November 2017, I conducted a physical examination of the passport in London, United Kingdom. The document was handed to me. During the course of my investigation, I used a long-wave UV light source and magnification, not throwing it up in the air with a coin at the same time. Heads it's authentic, tails it's fake. Paragraph 9, details of the passport. The document that was presented to me purports to be an Indian passport of the L series, which I'm very familiar. He says purports because he hasn't examined it yet. That's the chronology of events. Although I held no comparison material, from my knowledge, expertise and familiarity with these documents, I can state that it is a genuine document and not a counterfeit. The document contains various security elements which together make the document what it is. I noted the presence of a high-quality cylinder mold watermarks throughout the document, random UV fluorescent fibers and high-quality print. I should point out that in the counter memorial, the court will find that the ICAO guideline 9303, 7th edition, 2015, identifies the standard pursuant to which travel documents ought to be issued by states if they want their nationals and those who are masquerading as their nationals for legitimate and illegitimate purposes to travel. And these are the characteristics from there. The main portrait in the document is inkjet printed, and there was no evidence to support that this image has been manipulated. There is an additional ghost image which is made up of personal data in a wave pattern, which adds further confirmation to the authenticity of the image and data. The laminate is a security print on the inside, which I found to be clear and undamaged. I find no evidence that the image is not original to the document. And what did he say? He'd served as part of the UK Home Office in Immigration Intelligence for more than 27 years. The UK Home Office and Intelligence. He's been a member of the Heathrow Terminal 4 forgery team for 11 years, and then served on attachment to the Foreign and Commonwealth Office as Immigration Airline Liaison Officer based in New Delhi. Yes, New Delhi. Serving the whole of northern India and Nepal, advising airlines and border security control officials on forgery and fraud in travel documents. And then what did he do? He left the Home Office in 2017, but he served as Chief Immigration Officer at the National Document Fraud Unit. The NDFU is the Centre of Knowledge and Information for Travel Documents. He's provided evidence in both Crown and Magistrates' Courts representing the Home Office in cases involving document fraud. To describe him as a purported expert 4 months after having read his report is galling. To describe him as a purported expert after he'd spent 3 years in India as Immigration Intelligence Liaison Manager, where his CV also tells us he'd worked closely with Indian intelligence officers, police, UK security services, and the visa sections across the whole of North India and Nepal, advising Indian and Nepal border control on documentation and security. To describe, nevertheless, the position in the light of this report as propaganda, as farcical, as mischievous, as part of a litany of false allegations which India will not respond to, is disgraceful. And we say it's reached the level of disgrace for this court, for the first time ever, to conclude that India is guilty of egregious illegal conduct in providing Commander Jadhav with an authentic passport and false identity and dispatching him to carry out acts of espionage and terrorism in Pakistan in contravention of the Charter of the United Nations. The Attorney General gave the court an insight. And of course, it's all too often the case that there are complaints and counter-complaints, allegations and counter-allegations. Here, perhaps for the first time, we have a court which is presented with clear, compelling, uncontradicted evidence of the turpitude of a state, abusing the facility of provision of a passport to provide one of its agents of destruction and terror with a facility to be able to wreak havoc in Pakistan. Havoc that, thanks to the sterling work of the Pakistani security services, he was prevented from continuing. Havoc which must have consequences, not just for India, but for Commander Jadhav. The idea that he can be immune in the way that India suggests it is immune for its actions is obnoxious, I'm sorry to say. And we say, as a consequence of all the evidence that's before the court, the burden of proof shifted to India in December 2017. After all, India asked for a further round of pleadings to fully rebut the facts and the law. And what did it do? It didn't. The burden of proof shifted to explain the passport issue and explain India's conduct. It just wasn't acceptable to avoid doing that. The second aspect of India's conduct, which is unsavory and which I'm forced to bring before this court, is the report of the military experts and India's doctoring of it. India doesn't like the truth, I'm sorry to say, and I'm not going to varnish it, because the truth has to be heard. Yesterday, we heard Mr. Salve's mealy-mouthed explanation for doctoring the experts' report, and yesterday, the experts had, by way of a supplemental report, sought to make it absolutely clear what they intended in their report, lest anybody who doesn't understand the English language in the way that it's meant to be understood was under a false impression. And India tried to block that. It wasn't an unabashed attempt to lead further evidence. It was to address misrepresentations, but of course that's not what India wanted. What was impermissible was not allowing the experts to come before the court and say, unlike Humpty Dumpty, we used plain English. We didn't give India a license to add or delete words. India didn't want you to hear that, honourable members of this court. But I'm telling you now. The military experts, the distortions, the shocking distortions. The first one is the typographical error that my learned friend says entered into paragraph 154. But he couldn't stop himself, because yesterday, paragraph 222 of the transcript, he said, in paragraph 3D of the report, the experts state their conclusion that manifest failings can be remedied by judicial review. India relies on this statement as an acknowledgement that there are manifest failings. I don't see how, given that they use the word potential. But there you have it. We obviously have been using different languages and different dictionaries in different parts of the world. It does so in paragraph 19 of the reply. Pakistan does not suggest there is any misquotation in this paragraph. I say he couldn't help himself because if he'd bothered to look at our rejoinder, page 4, part 2, paragraphs 24 to 26, we made it clear we were taking issue with paragraph 19 and paragraph 154D. So, sadly, with respect to my friend, we did. But this is yet another example of a catch me if you can type attitude towards legal proceedings. Well, we have caught you. Deletions and additions of words is the order of the day. Deleting the word often was the second distortion. And then, wanting to pretend that the experts, as objective, independent bystanders, with their expertise and credibility, were not trying to help the court by referring to the fact that courts which tried terrorism offences both in India and Pakistan had both been subject to general criticisms. They gloss over the reference to India and Pakistan and create the irresistible impression that the experts were only referring to India. Now, if one mistake had been made, one could understand its perhaps carelessness, incompetence. If two, troubling. Three, deliberate. Even worse. As the court knows, we have repeatedly written to India to ask India to correct. In June of last year, before we were finalizing our rejoinder, we asked India to correct to check the contents of the rejoinder, and we were brushed aside when the rejoinder was filed. Subsequent to that, India could have corrected. We were brushed aside, told, take it up with the court. We took it up with the court on the 19th of January of this year. And what happened? India maintained its position. Then I, as a matter of professional courtesy, drew it to the attention of my friend Mr. Salve on the 7th of February, because some of us still believe in professional courtesy, some of us believe in professionalism. I'm sorry to say I never received a reply from Mr. Salve. I pointed out 14th of February would be an opportune date to provide me with a response so that we could take stock. So to say that the experts have been deployed before this court late, as India has done in its letter of yesterday, fails to prepare the court and provide the court with a full picture. Unsurprisingly, we were trying to give India every single opportunity to correct, to clarify, to apologize. And it's only at the last moment that we wanted the court to be made aware exactly of what the experts had said, and that is why the experts were keen to ensure that there was no misunderstanding and to file a supplemental report. Each and every opportunity India was given, arrogantly, it dismissed. Well, you can't dismiss the truth. It's here now. And each and every one of those opportunities just adds to the edifice of deliberate conduct. Because if you're given 4 opportunities to correct the position and you don't, it's difficult to conclude other than you're being cavalier, you're being arrogant, but you're also being very insulting. And that won't work. There may be some courts in this world where it's possible to get away with a license of this nature, but this court is not a court where any litigant, let alone a state, or any advocate can be allowed to play fast and loose with the truth. And it's important for this court, even if this is the first time ever in the court's history, to identify what the red lines are for conduct. Sadly, we're living in a world in which the rule of law is coming under increasing threat. And it's important for this court, as it has done historically throughout its existence, to inform the world where the lines are and not to allow them to be erased or blurred by states that believe that alternative facts, fiction, fantasy, fallacy, are the order of the day. And then we move on to the second category of misleading. It wasn't enough to doctor the military experts' report. India had to then try and disavow its own handiwork. The 2008 Agreement on Consular Access India's reply said, this has no bearing on the present dispute. I remind myself the title was Agreement on Consular Access. But now it says it does have meaning. It does supplement and amplify the understanding of the parties vis-à-vis the Vienna Convention in some ways, but conveniently not in this case. Why? And this is where the distortion comes in, because what India does is totally misreads deliberately the terms of the convention, the bilateral agreement. Pakistan's not relying on Article 4 or 5, it's referring to standalone provision, Article 6, which I shall take the court to. What does Article 6 say? I'll explain that full stops have a meaning, commas have a meaning. This is not a lesson in punctuation, this is a lesson in accuracy. Article 6 says the following: in the case of arrest, detention or sentence made on political or security grounds, each side may examine the case on its merits. That's pretty clear language. What does India do? In its memorial, paragraph 92. The 2008 agreement was entered into for furthering the objective of humane treatment of nationals of either country, arrested, detained or imprisoned in the other country, and by which the two signatory states, India and Pakistan, agreed to certain measures. No qualms with that. These included the release and repatriation of persons within 1 month of confirmation of their national status and completion of sentence. No qualms with that. The agreement recognized that in case of arrest, detention or sentence made on political or security grounds, each side may examine the case on its merits. Absolutely right. That's Article 6. But then what happens? The text, the mischievous comma, and the addition of the words "and that," what I describe politely as India's creative addition, others may say deceit. In special cases which call for or require compassion and humanitarian considerations, each side may exercise its discretion, subject to the laws and regulations, to allow early release and repatriation of prisoners. India does not seek early release or repatriation of Jadid, as contemplated by the 2008 agreement. What utter nonsense. By simply, I say simply, adding a comma and the words "and that." And no doubt Mr. Salve eventually, when pushed, will tell us that was yet another typo. It's a simple fact that the 2008 agreement was negotiated over a period of 3 years. Indeed, it expressly sought to replace an earlier agreement, operating since 1982, no less. Article 3 of that agreement, which the Article 6 sought to replace, was much more detailed. Each government shall give consular access on a reciprocal basis to nationals of one country under arrest, detention or imprisonment in the other country, provided they're not apprehended for political or security reasons offences. Requests for such access and the terms thereof shall be considered on the merits of each case by the government arresting the person or holding the detainee's persons prisoners, and the decision on such request shall be conveyed to the other government within 4 weeks from the date of receipt of the request. It's exactly the same language, consideration on the merits, political security reasons offences. Somehow, unfortunately, when it comes to this case, India's answer is, but Pakistan never referred to it. Well, you did, as I'll show shortly. And when did you refer to the Vienna Convention on Consular Relations, as my dear friend reminded us yesterday, in your regular missives about consular access? Did you invoke the Vienna Convention on Consular Relations? Was it necessary? You're saying it's an agreement between the parties. So was it necessary to refer to it? Was it equally necessary to refer to this 2008 agreement? And we'll come to the 2000 agreement subsequently. And the third category of misleading, which I have to say I am much more disappointed about, because I would have wanted Mr. J.P. Singh to be available for this court. He submitted what he described as a 7-page report dated 26 December in the aftermath of the visit to Commander Jadhav of his wife and mother. Now, if it's being suggested that Commander Jadhav's visit was evidence of impropriety on the part of Pakistan, we're very happy to share the entire video, unedited, of the interaction between Commander Jadhav and his wife, with J.P. Singh looking on to ensure that matters were dealt with properly. And the video will show that Commander Jadhav's mother commented on his excellent health. We referred to the report as being materially inaccurate. And we asked Mr. Singh be tendered for cross-examination. India refused and said we should take it up with the court. We asked, by note verbal, 5th of June, for India to check the accuracy of the contents of the reply. And again, we were told, in essence, as is characteristic of India, this is inappropriate, irrelevant, by letter dated 27th of June 2018. So much for wanting to help. Sadly, even in this day and age, sadly, even a handshake seems to be misunderstood. On one side, it's a sign of respect. On the other side, it's a sign of shame, decorum. That's all we're asking for. So we asked the court on the 18th of January for Mr. Singh to be available for cross-examination. And the reply was a model of evasion. Well, he didn't give a witness statement. He gave a report. And then what happened? Oh, by the way, he's corrected his report. The date wasn't the 26th of December. It was the 5th of January. And this is the marvel that we were presented with, purportedly dated 8th of August 2018, provided by way of attachment to a letter dated 23rd of January from Dr. Mittal. Why, one asks, when we were raising this with you in June of 2018, when you had notice from us that there may be issues about inaccuracy, why is it that Mr. Singh is writing this letter in August 2018? Was it the monsoon heat that got to him, that made him remember the date of the letter? Because what he says is, I know it's dated the 26th of December, eligibility is not quite right, for whatever reason, happy to see the original, but you should read it as 5th of January 2018, sent to Dr. Mittal. Now, I'm sorry that he's not here, because this letter can be easily demonstrated to be a concoction, to use India's words, a manufactured. Melodrama is added to this letter by the use of the word secret at the top right-hand side. Bizarre that a letter that is supposed to be secret finds its way as an annex to a reply, to a plea, to a case before the International Court, and is now being seen by the world at large. We will see at the bottom that J.P. Singh arrived in Delhi at 3:45. It's dated 26th of December 2017. It's 7 pages. And he says, at the bottom, he signed it in New Delhi. Well, actually, he didn't. He says himself, he didn't. So, the date's wrong. The date of the letter, when he signed it is wrong. Where he signed it is wrong, because on the 28th of December, he went back to Pakistan, where he's the Deputy High Commissioner. And what else was there in this letter that is objectionable? It's written to Dr. Mittal, and I'm reminded that he's sitting next to me. Of course, he's the agent for India. If anybody knows about Indian culture, it's Dr. Mittal. And what does he say to him? While the government of Pakistan had assured a security check with full dignity, the Pakistani security official removed all the ornaments and bangles, including Mangal Sutra and Bindi, which are of immense religious sensitivity in Indian society and a symbol of a married woman. Did Dr. Mittal really need to be told that? Did he really need to be told that? Please. You may fool yourselves, but you don't fool the rest of the world. And then what does he say? The appearance of Mr. Kulbhushan Jadhav. While I could not hear the conversation of Jadhav and family members because of 2 glass partitions, the physical appearance, gestures and body language indicated the following. His face was looking...
Mr. Qureshi, the interpreters are having a lot of difficulty to follow you.
I apologize.
So if you can please slow down for their sake.
I can only apologize. I'm conscious and anxious to ensure that the material is... We have a time limit. I want to stick to the time limit. I'm not one for elongating time limits, so I apologize for going through this at my normal canter speed. I shall refrain. I'll move into walking trot, shall I? Yadav's face was looking puffy and swollen. He was very hyperactive. Seemed as if he was not in his senses, was under the influence of something. Shorthand. He'd been tortured. He'd been drugged. This is an independent medical expert, no less, Dr. Nilsson, a German national, not a Pakistani national, based in Dubai at the Saudi-German hospital, a consultant who produced a 14-page medical report, independent medical examination on the 22nd of December, concluding that Commander Jadhav was in excellent healthy condition. 3 days later, we're told he was looking puffy and swollen. He's not in his senses. Now, I have to make the following observation. It means this, that up until the doctor saw him, Commander Jadhav was healthy, and in the interim, he was tortured and sedated. Now, I don't mean this in jest, but was that necessary for him to see his mother and his wife? Is that the reason? It just illustrates the absurdity of the proposition. And then paragraph 15, KJ's video released by Pakistan side after the meeting. The court hasn't seen this, but I may as well tell everybody what the video says. It's Commander Jadhav, untutored, unprompted, exasperated at the fact that JP Singh was shouting at his mother and wife. This video was released on the 4th of January 2018, not a few days after the meeting. So you see the entire narrative of JP Singh breaks down, because it wasn't a few days after. So much for truth and accuracy. I do wish JP Singh well in his future career as a fantasy fiction writer. But the next time he wants to produce a document which is going to be put before court, I hope he'll make himself available for cross-examination. Third point, at no material time, even now, has India furnished any evidence that Commander Jadhav is an Indian national, despite repeated requests. The gateway point that I mentioned at the outset. Is this a convenient moment?
Yes. It's the moment for a break, and therefore the court will observe a 15-minute break. The meeting is adjourned.
I mean, it's not going to get me involved.
Please be seated. The sitting is resumed. I invite Mr. Qureshi to continue his presentation in view of the longer coffee break taken by the court. Mr. Qureshi, on behalf of Pakistan, may go a little bit beyond 1 o'clock. And I hope that will enable him also to allow the interpreters to follow him and not to rush too much.
Well, Mr. President, I ought to make it clear that Fanny Ubella and Catherine Lamadic have both received a personal apology from me. And not by way of inducement, they should also receive a box of chocolates. And if necessary, we should also provide a box of chocolates to the interpreters, who do a wonderful job and are hidden from view, but it's thanks to them that the record is created for posterity's sake. So thank you very much, and I apologize. Now, before I move on at a slower pace, I should make reference, in fairness to the experts who've been blocked by India from providing the court with their emphatic denunciation of India's doctoring of their report, who've been blocked by India from referring to the 18th of October 2008 Peshawar High Court decision confirming the observations they had made on the 29th of November 2017 as to the effective nature of review and reconsideration pursuant to Article 199 of the Constitution of Pakistan, and been blocked by India from pointing out that less than 8% of those convicted by military courts have in fact been executed. But I put that before the court now, and that statistic is available from the International Commission of Jurists report of January 2019. And it's a pity that India didn't seek to update the court about the Peshawar High Court decision of 18th of October, and it's a pity that India didn't seek to update the court about the International Commission of Jurists report of January 2019, but to help out my learned friend, I've done it for him. Now, the experts' report is at tab 4 of the judge's bundle, but all I'm going to do is to refer to it very, very summarily. The experts, for many of us, need no introduction. They are individuals whose background is one that speaks clearly, not just of independence and impartiality, but also expertise. Professor Charles Garraway, who hasn't been prohibited from sitting in this court because he wasn't going to seek to give evidence in any event, has served for 30 years as a legal officer, had served for 30 years as a legal officer in the Army of the United Kingdom. He was appointed as CBE in 2002, and he was the general editor of the United Kingdom Manual on the Law of Armed Conflict from 2008-2013. He's the consultant editor of the Practitioner's Guide to Human Rights Law in Armed Conflict, published by Oxford University Press. And Brigadier Anthony Perfiti, who's been locked out of court, but is able, thanks to the miracles of modern technology, to watch these proceedings in the adjacent room, is a lawyer who was in the army and was the first legal advisor to the NATO Allied Command Europe Rapid Reaction Corps headquarters. He's also the author of the Military Justice Handbook for Court-Martial Practitioners, 2013. So one would have thought that when they approach the subject of state practice regarding the jurisdictional basis, process, and procedure for military courts, and when they reviewed the state practice of 10 UN member states, including the United Kingdom, the USA, Israel, New Zealand, Nigeria, Pakistan, last but by no means least, India, that their report might be given some respect. Because they asked themselves what the practice was of states regarding the jurisdictional basis, process, and procedure for military courts. Are military courts vested with jurisdiction to try the offence of espionage? This is in their summary of instructions, paragraph 1. Paragraph 2, the context for the report, the proceedings before this court. And they asked themselves whether examination of open source materials, India has made much of military courts being shrouded in secrecy, open source materials, is the jurisdiction, practice and procedure of the Pakistani military courts manifestly unfair? Or does it reflect practices and procedures common to military courts generally, having reviewed 10 different jurisdictions, common law and otherwise, and the conclusions, which India couldn't resist doctoring, were as follows. Paragraph 3. Whilst most military courts do have jurisdiction to try the civilian offence of espionage and terrorism, in relation to related military offences of a similar nature, this is often limited to offences committed by persons already subject to service jurisdiction. Modern state practice in most jurisdictions is that the civil authorities of the state will undertake any prosecution of these offences where there is concurrent jurisdiction. B, that the military courts of Pakistan are soundly based in statute, which provides the substantive legal basis for their jurisdiction, and India couldn't resist deleting the following words, practice and procedure. Important points, because there are so many jurisdictions where the law provides for rights, but the law is so often violated. But it's the practice and procedure that Professor Garraway and Brigadier Pafiti were looking at. Article 10 of the Constitution of Pakistan guarantees a defendant the right to consult and be defended by a legal practitioner of his choice. This constitutional right is reflected in Rule 23 of the Pakistani Army Rules 1954. This jurisdiction is not inconsistent with the practices and procedures common to military courts generally, and does not appear to us to be manifestly unfair. C, we do not consider that the espionage jurisdiction of the military courts of Pakistan, finding its source in a statute law of 1923 during the British India period, is per se unfair or otherwise improper. D, in the case of Pakistan, the judicial review function of the civilian courts, as identified in the Zaman Supreme Court decision, they refer to paragraph 32 of their expert report, appears to provide a potential effective safeguard against manifest failings in due process. India decided that potential meant actual by adding the word the manifest failings, which we're supposed to believe was a typographical error, upon which the edifice of nonsense was constructed by India to justify saying, well, there you have it. Pakistan's own experts are corroborating, confirming our position about an absurd a proposition as one could think. Did India really expect that no one would read and compare its reply with the contents of the expert's report? Is it that brazen conduct? Shameless? Military courts in other jurisdictions are vested with jurisdiction to try terrorism matters. E. F. We're aware of general criticisms made of the courts which try terrorism offences both in India and Pakistan. We're not in a position to consider whether those criticisms are valid without further extensive research and review. What's wrong with that? That's not what they were being asked to consider. They were being asked to consider the questions that they did consider. Moving on. Third fundamental point. It's not good enough for India to say, well, you called him an Indian spy. You referred to the passport that he had in his possession for your internal investigations as establishing that he'd been sent by India. You convicted him of espionage, obviously, as a spy sent by India, and therefore you can't say that we needed to furnish you with evidence as to his nationality. That simply is unsustainable, because, as this court made clear in the Avena case, a state that wishes to avail itself and provide its national with diplomatic protection has the obligation to furnish evidence of nationality, commonly by means of passport, birth certificate, as we saw in the Avena case, where the court upheld the United States of America's objection on the basis that Mexico had failed to identify and positively establish the nationality of one of the individuals in respect of whom it was demanding diplomatic protection. And lest it be said by India that Pakistan has somehow represented in a clear and unequivocal manner to India that it's not going to bother with evidence of nationality, that's simply not the case. There's no proposition of law advanced before this court with reference to any authority, the Temple of Bihar case, for example, to suggest that there is the doctrine of estoppel at large. There's nothing. The memorial and the reply of India are shamelessly devoid of substantive legal content. If India wants to argue estoppel, it's too late, but I'll make the argument for them, shall I? There is no clear and unequivocal representation made directly to India with the intention or effect that India detrimentally relies upon it, such as to constitute a waiver of the requirement for India to establish the Indian nationality of Commander Jadhav. State practice. The proposition I advanced, the proposition that none of the 177 states party to the Vienna Convention on Consular Relations disagrees with, because if they did, the others, because there are two here, they had ample opportunity, pursuant to the invitation of this court, to present themselves and take issue with the proposition that I seek to advance. But they don't, because this is an issue which states have refrained from becoming visible upon and adopted a position that I described as being one of studied ambiguity. With the consequence that it cannot be said that there is a general practice accepted as law, opinio juris, by states to provide consular access in cases where espionage was reasonably suspected, such as to evidence that any such practice was undertaken with a sense of legal right or obligation, which I respectfully observe is the essential requirement for a customary international law principle to have crystallized and to be evident. The ILC draft conclusion 9 with the rapporteur, Sir Michael Wood, provides us with ample understanding in this regard. And it's the state practice position as at 1963 that we're concerned with. And we know, I wasn't alive at that juncture, but we know that at this point in time, the world was troubled, sadly, as it seems to be now. All the more reason for the rule of law to be upheld, because those who were participating in this exercise to ensure that a convention could be adopted were describing the task in 1963 as thankless, because distrust and suspicion reigned everywhere, and almost all states had recourse to emergency laws and regulations. Two pivotal figures in international law, certainly for somebody like myself, I can't speak for India, and I daren't try to speak for India in its present incarnation. Sir Gerald Fitzmaurice, former UK Foreign and Commonwealth Legal Officer Advisor and then a judge of this court, had observed that national security would be the only reason with sufficient weight to justify restricting communications between foreign nationals and their consular officials. Grigory Tunkin, then head of the legal department of the USSR Foreign Ministry, in the negotiation process, as can be seen from the travaux, had made it absolutely clear that the USSR took the view that in case of espionage, and as an exception, there was no obligation to provide consular access which would otherwise be available. This was with reference to the language of without delay, subsequently undue delay. And he was calling for that language to be deleted, with emphasis being placed upon this particular issue. And what was the response of the chairman? A statement of general principle could not possibly cover all conceivable cases. If the Commission went into the question of whether cases of espionage should be made an express exception, the whole principle of consular protection and communication with nationals would have to be reopened. Now, India reads this as it reads anything in the English language in a somewhat topsy-turvy manner, but what does it mean? Three propositions. The USSR, in plain and simple language, is making it clear, At this juncture, espionage was a special case outside the general approach to questions of consular access. And second, the chairman agreed by stating that the general principle could not cover all conceivable cases, far from India's exhaustive rubric. There's a lot of flowery language in India's pleadings, but there's not much by way of substance. And further, the only way to read the chairman's comments is as follows. Any attempt to open up the espionage exception so as to include express language would throw the entire process of formulating the draft convention into disarray. How else do we read this? If the Commission went into the question of whether cases of espionage should be made an express exception, the whole principle of consular protection and communication with nationals would have to be reopened. He's not saying, don't be silly, there is no such an exception. He's saying, let's not touch that, shall we? Because if we do, we're not going to get anywhere. Of course, that's how I read it from my understanding of English, but if somebody else has got an understanding of English which is intelligible, logical, then I welcome them to explain otherwise. And perhaps, to some extent, this is why the preamble of the Vienna Convention on Consular Relations states as follows, affirming that the rules of customary international law continue to govern matters not expressly regulated by the provisions of the present convention. And that's consistent with Grigori Tunkin's observation. That's also consistent with the way in which their major powers were behaving at this material point in time. Now, of course, it's very rare for espionage cases to appear on the public radar, and this is the first time ever the Vienna Convention on Consular Relations is being considered in the context of espionage. 4 examples we have given: the counter memorial and the rejoinder provide authoritative references. We're not talking about references from newspapers in some provincial town somewhere in the middle of nowhere. We're talking about US State Department official documents. We're talking about texts produced by authorities on this era. Mikhail Gorin, USSR national, 1938, despite a bilateral treaty on consular access of 1933 between the USSR and USA, he was only allowed access in the presence of a US naval intelligence officer, Colonel Abel. Many people will recognize him from the Hollywood treatment, Bridge of Spies, a USSR national, 1957, no consular access sought or provided, convicted of espionage activities. Gary Powers, USA national, 1960, no consular access, convicted by the USSR of espionage. 2 and 3 were swapped in Berlin. Mark Kaminsky, USA national, 1960, no consular access, convicted by the USSR of espionage. That state practice, such as one's likely to see in an era as shrouded in secrecy, as subject to subterfuge as this. But what have academics who have reviewed this got to say about it? Professor Lee, the leading authority on consular law on practice in 1961, 2 years before the negotiation was taking place, a frequent exception to the consular right to protect nationals and visit them in prison is in the case of spies. Clear. Even better, Bishwanath Sen, 1965, 2 years after the convention was adopted. India's honorary legal advisor, 1954 to 1964, 10 years. In his textbook, A Diplomat's Handbook of International Law and Practice, no less, says as follows: a frequent exception to the consular rights to protect nationals and visit them in prison is the case of persons who are held on charge of espionage, as evidenced by the practice of states. Of course, customary international law being customary international law, being based upon state practice and an understanding as to obligation, states are free to modify their own practice. India put before the court 2 examples of state practice yesterday, recent state practice, China and the detention of Canadian nationals, but there is an express agreement, detailed agreement between China and Canada on consular access, and Russia also. But we could give the court many other examples, but we haven't littered this court with examples of what's happened subsequently, because what matters is what the understanding was in 1963, so far as customary international law is concerned. That's what matters, because that was preserved. India's main point, which I have to accept has some force if it had any substance, is that if an exception exists as a matter of state practice for consular access in the context of espionage, some states could manufacture an allegation of espionage. It says deprive an individual of consular access. We only have to look at that proposition to see how nonsensical it is. Why? Well, this is the first case before this court where the Vienna Convention on Consular Relations is being considered since 1963. So it's worked effectively for more than 50 years. There hasn't been abuse. Not a single one of the other 177 states is before this court, unless I'm missing something, to raise an argument against the proposition that I'm advancing, which they could. None of the permanent members of the Security Council is present before this court to take issue with the observation that I'm advancing. Why? Because they have to maintain, understandably, a position of studied ambiguity. So we have to thank India in its infinite wisdom for wanting to help clarify the law as to espionage. We have to thank India for placing these issues before the court as to consequences of illegal conduct, the proper interpretation of the Vienna Convention. And we're grateful to India because the legal community needs clarity. But allegations of espionage are extremely rare. And in this case, the notion that this is an allegation, it's not. It's proven. Commander Jadhav's confession is highly credible. It's corroborated by, at the very least, those 3 independent Indian, highly respected journalists and their investigations. The position of India, in stark contrast, is to disavow through language which is hollow, concoction, propaganda, litany of false allegations. And the passport, we mustn't forget the passport. What is India's explanation for this passport? The expert is a purported expert, a gentleman who trained the Indian authorities for 3 years, who was one of the foremost authorities in the United Kingdom until 2017 on travel document fraud detection, is a purported expert. What a ridiculous suggestion. And then, last but by no means least, the optional protocol, which India sought not to engage, through Articles 2 and 3, allows for what I would describe as multi-tiered dispute resolution. And anybody who drafts commercial contracts or has to engage with them will know that those who seek to avoid disputes will try negotiation, mediation, arbitration, and then eventually go to court. Articles 2 and 3, the discussion is illuminating because these were the subject of discussion by no less than the Indian delegate, as you will see from our rejoinder and counter memorial. And the Indian delegate was at pains to point out that states ought to be encouraged to resolve their disputes through dispute resolution mechanisms. But what did India do in this case? When was the first time India actually sought formally to notify a dispute? 8th of May 2017. Did India, before that, on its case, when it was entitled to consular access, on its case, on the 25th of March 2016, notify a dispute? No. Did India suggest negotiation, mediation, arbitration? No. What did India do? India came to this court on the 8th of May, demanded provisional measures without a hearing, ambushed Pakistan, perhaps in the hope that Pakistan wouldn't appear. Well, it did. And understandably, this court granted provisional measures, perfectly understandably. And much as India wants to scrape the barrel of the internet and try and find one of those who no doubt still believes that the earth is flat to provide some justification to criticize Pakistan, a population of 220 million. There is no official statement from anybody in Pakistan which is other than respectful of this court. So why, oh why, India, from 25th of March 2016, didn't you notify Pakistan of a dispute? Why come to this court for provisional measures without a hearing and tell the court that premeditated murder was about to take place, which is the language that you used, and a hearing was not necessary? When, even now, Commander Jadhav, that video of late November 2018, which you viewed, shows that he's in very good health. And you also knew, India, with respect, about the existence of the 2008 agreement. Because on the 21st of March 2017, before judgment was pronounced on the 10th of April by the military court trying Commander Jadhav for espionage, you were reminded that your request for consular access would be considered in the light of your response to the request for assistance in the investigation process and early dispensation of justice. Not sham trial, not premeditated murder, not lynch mob, execution or death sentence within 3 days, early dispensation of justice to be afforded to a man who was given a 3-week adjournment to prepare his case on the 21st of September in a situation where there were 4 stages of trial. What's Pakistan asking India to do? Reasonably, in an obligatory manner, assist. And what does India say? They note the willingness of the Pakistan side to provide consular access. This is 31st of March 2017. It's in the bundle. What else happens? Never mind the sophistry and the contortions that my friends are engaged in. By now, we're all too used to it. On the 13th of April 2017, the official spokesperson for the Indian Ministry of External Affairs said this: both India and Pakistan also have an agreement on consular access bilaterally. So we're not merely speaking about an international practice. We're speaking here of a bilateral agreement. Suddenly that's vanished when it comes to this court. It can't any longer. And what is that agreement? Article 6 of the agreement could be simpler, could be clearer. My friend pointed to Article 31 of the Vienna Convention on the Law of Treaties yesterday, but all of a sudden, he doesn't want to accept the plain and ordinary meaning of this provision. He doesn't want to accept that it must be interpreted in good faith, in the light of its object and purpose, within its context, namely, as its title suggests, to address consular access. In case of arrest, detention, or sentence made on political or security grounds, each side may examine the case on the merits. And what's the argument? Oh, the merits, that's problematic. Political or security grounds, that's problematic. More than 35 years after this language was used, India's language, because India was pivotal in the drafting exercise, the conclusion of this treaty, India is now saying it's terribly difficult to understand the language national security. It's terribly difficult to understand the language, the merits. This is at best being respectful and delicate to India, highly disingenuous, and as far removed from a good faith requirement as could be. And then India says, but the 2008 agreement was meant to deal with nomads and fishermen, of which there are apparently many people crossing because of the border that is 1,000 miles plus, which again raises this bizarre question that I'd raised on the 15th of May. Why choose somebody sitting in Chabahar in Iran, 9 hours drive from Pakistan, to kidnap, to drag him into Pakistan, to force him to give a confession? Why choose somebody of that nature? You've got so many people on the border. If you want to create a fictitious story, why go for him? Article 6 means what it says. Moving on to the next part. India's claim for at least acquittal, release and return is outlandish. By which I mean it occupies a different legal universe. Because this legal universe, in fact, this very room has adjudicated on this question not once but twice, in the Legrand case and the Avena case. But what this court is being invited to do now, I assume because it's Pakistan, and because it seems, sadly, that the present incarnation of India cannot view Pakistan save through a warped, closed-minded perspective, it's being told that, in this case, make an exception for Pakistan. Well, the rule of law applies to all. And as the Attorney General has pointed out, Pakistan's before this court because it's supremely confident in the ability of this court, the world's highest court, the court that upholds international law, that declares international law where necessary, to ensure that international law is upheld. And India, unfortunately, couldn't help itself in its shameless misrepresentation of the experts. India, I'm afraid, can't extricate itself from, at the very least, the credibility, if not the powerful veracity of the confession of Commander Jadhav. India can say as much as it likes about premeditated murder. It no doubt looks good on social media, which is no doubt ablaze at the moment, which is fine. But to talk about premeditated murder in respect of an individual who confessed before a judicial magistrate with stringent safeguards in the context of a trial for espionage that took place over 4 stages over a period of 6 months, allowing him 3 weeks for an adjournment, is a little unfair. Well, let's be charitable to India. A little unfair to call that premeditated murder. Some might suggest that saying that rapists ought to be hung, if not sentenced to death within 3 days, is a little bit unfair. But we'll leave that to Mr. Modi to explain. India simply fails to answer serious questions which could be exculpatory. But more likely, and that's the explanation why India won't answer them, are damning and implicatory. India invokes 10 reports of the UN Human Rights Committee concerned with the alleged violations of the ICCPR. Not only is this irrelevant, but not a single one of those reports concerns Pakistan. India quotes from reports of an NGO, the International Commission of Jurists. And in case my friend hasn't seen it, there's a recent report of January 2019, which refers to the recent case from the Berkshire High Court, where more than 70 convictions and death sentences rendered by military courts were annulled by the High Court. But the International Commission of Jurists' observations of 2016 and 2017 were premised on the misunderstanding that the High Court and Supreme Court of Pakistan couldn't undertake a review of the military court decisions, which is plainly wrong. The experts said it, and their position was confirmed subsequently by the Berkshire High Court overturning those convictions. And then, in a flourish of enthusiasm, no less than the decisions of the Inter-American Commission on Human Rights are invoked by my learned friend. Now, I could understand why they were invoked as against the United States of America in the Beard, Paraguay, in the Legrand, Germany, and in the Avena, Mexico cases. What are they doing here? But even worse than that, the quotation that my friend puts before the court is incomplete. Now, as a member of the English bar, I know only too well that what I ought to do is to ensure that the court isn't inadvertently misled. I'm not suggesting my friend was doing that, but it might have been helpful to also put before the court paragraphs 104 and 105, because what my friend was contending for was some process which I've yet to understand, whereby there's some sort of cross-fertilization, he puts it. And what he says is that the IACHR decisions of the Commission, which are recommendations, ought to be given weight before this court. But what did the court do, the Commission do in that case, where the Commission was concerned with individuals who were also featuring in the Vienna dispute before this court? The court was asked whether or not the individual applications before it were precluded because those individuals were also featured in the ICJ case. Well, the answer of the Commission was the individuals weren't appearing before this court qua individuals. They didn't have locus. And also the Commission went on to say as follows: the central issue before the ICJ was whether the United States violated its international obligations to Mexico under Articles 5 and 36 of the Vienna Convention, based upon the procedures of the arrest, detention, conviction, and sentencing of 54 nationals on death row. The issue before this Commission, on the other hand, is whether the United States violated the individual's rights to due process and fair trial under Articles 18 and 26 of the American Declaration, based upon the alleged Article VCCR breach, Article 36 VCCR breach. In the Commission's view, the claims brought before the Commission raise substantive issues that are distinct from those decided upon by the ICJ. Moreover, paragraph 105, the function of the ICJ, and I ask for forgiveness for saying this to the court knows full well what its function is, but I may as well refer the court to this provision, given that my friend didn't. The function of the ICJ, as defined through Article 1 of the optional protocol to the VCCR, is to settle as between states disputes arising out of the interpretation and application of the VCCR. The IACHR, on the other hand, is the principal human rights organ of the OAS, charged with promoting the observance and protection of human rights in the Americas, which includes determining the international responsibility of states for alleged violations of fundamental rights of persons. Even in that case, as can be seen from the decision, despite the fact that 2 of the applicants had been executed prior to the IACHR's determination, in the Medellin case, a retrial was recommended, even in that situation. Nevertheless, as I said, India's position rests upon this wonderful image that I have of cross-pollination of jurisprudence, of rights recognized across treaties and judgments of these institutions. Let's forget about jurisdictional distinct and separateness. Let's forget about treaty arrangements. Let's enjoin the world to cross-pollinate. And then, India's arguments as to minimum due process, the Vienna Convention on Consular Relations, having the character of a human right, annulment of conviction and sentence being the only effective reparations, have been ventilated repeatedly. This is where the abuse comes in. There comes a point in time where to come before a judicial institution to ask for relief that the court has stated repeatedly is not available becomes abusive. I appreciate there are those who wish to push the metaphorical jurisprudential envelope, and I'm sure there are many members of the bench who are anxious to do so, but within limits. Because judicial activism, with respect, has to take place within the appropriate context. And the context here, as the court made clear, all too clear in the Avena case, is as follows. Paragraphs 119 to 124, which I'm afraid my learned friend failed to draw to the court's attention, so I do it now. In the Legrand case, the court made a general statement on the principle involved as follows. The court considered in this respect that if the United States, notwithstanding its commitment to ensure implementation of the specific measures adopted in performance of its obligations under Article 6(1)(b), pausing there, the USA promised to make sure consular access was provided in the future, as the court is all too aware. Since the Avena decision of 2004, there was a UN General Assembly resolution of last year, which was less than complimentary of the position of the United States of America. I say no more, save to refer to the fact that both India and Pakistan were parties to that resolution. However, should the USA fail in its obligation of consular notification to the detriment of German nationals in the future, An apology would not suffice. Sorry, we executed somebody, we won't do it again, which is what happened in the Legrand case. Provisional measures ordered on the 2nd of March 2009, execution on the 3rd of March 1999. In the case of such a conviction or sentence, it will be incumbent upon the United States to allow the review and reconsideration of the conviction and sentence by taking account of the violation of the rights set forth in the Convention. This obligation can be carried out in various ways. The choice of means must be left to the United States. The choice of means must be left to Pakistan, not to India. The internationally wrongful acts committed by the United States were the failure of its competent authorities. Assuming there was such a failure, and I say there wasn't, but even assuming, giving India the benefit of the doubt, which it's not entitled to, in the face of clear, overwhelming evidence of its contumelious conduct. Assuming there were failures to inform, as aforesaid, and the Convention was engaged, the remedy to make good these violations should consist in an obligation on, we say, Pakistan, to permit review and reconsideration by the courts of Pakistan. Because if it's good enough for the United States, why isn't it good enough for Pakistan? Does India want Pakistan to be treated differently? Why? Isn't it a member of the United Nations? Isn't it subject to the rule of law in the same way that India is? So the court reaffirms that the case before it concerns Article 36 of the Vienna Convention and not the correctness as such of any conviction or sentencing. The question of whether the violations are to be regarded, assuming there was a violation of the requirement to provide consular access, as having, in the causal sequence of events, ultimately led to convictions and severe penalties, is an integral part of criminal proceedings before the courts of the United States, the courts of Pakistan, and it's for them to determine in the process of review and reconsideration. In so doing, it's for the courts of the United States, Pakistan, to examine the facts, and in particular the prejudice and its causes, taking account of the violations of the rights set forth in the Convention. Paragraph 123. It is not to be presumed, as Mexico/India asserts, despite this judgment, that partial or total, India isn't going for partial, total annulment, and India is not just going for annulment. It wants him to be sent back to India, and wonders why. Terrorism? Is India afraid that the legal processes of Pakistan have yet to be engaged as far as its terrorist activities are concerned? Has India got something to hide once that comes out into the public domain? I can understand why India would want him back as soon as possible. Partial, but that would be wrong. Partial or total annulment of conviction or sentence provides the necessary and so remedy. That assertion is wrong because it's not the convictions and sentences which are regarded as a violation of international law, but the breaches of treaty obligations which preceded them. And then we move on to the Article 36 is in the nature of a human rights argument. Well, that's been gone through before, believe it or not, Mr. Salve. Article 124 says, Mexico has further contended that the right to consular notification and consular communication under the Vienna Convention is a fundamental human right that constitutes part of due process in criminal proceedings and should be guaranteed in the territory of each of the contracting parties to the Vienna Convention. It's almost as if that's been cut and pasted into India's submissions, which we were treated to a repetition of yesterday. According to Mexico, this right as such is so fundamental that its infringement would ipso facto produce the effect of violating the entire process of the criminal proceedings, conducted in violation of this fundamental right. Sounds very familiar. Whether or not the Vienna Convention rights are human rights is not a matter that this court need decide. Quite right. But, importantly, this court would, however, observe that neither the text nor the object and purpose of the Convention, nor any indication of the travaux support the conclusion that Mexico/India draws from its contentions in that regard. Effective review and reconsideration, and I have to refer to the proposition simply to illustrate how absurd it is. India's reply, paragraph 157, makes the bold assertion as follows. Pakistan does not have an appellate procedure by which a trained independent judge dispassionately review the findings of a military court. In the absence of an independent procedure of trial or review of the evidence de novo by an independent appellate court, India claims that the relief should be granted as has been sought in the memorial. Offensive, patronizing, false, contradicted by the experts' reports, and contradicted by the decisions of the Pakistani courts themselves. As recently as the 18th of October, the High Court of Peshawar set aside more than 70 convictions and sentences handed down by military courts. That court didn't shirk from demonstrating appellate procedure. That court didn't shirk from showing dispassionate review. That court had no fear of being independent. It set aside more than 70 convictions and sentences. It didn't hesitate to identify flaws in the processes and evidence leading to the convictions and sentences. The decision is in the public domain. It's a detailed decision, and I'm disappointed that my learned friend didn't have access to it. The Indian team is perfectly capable of finding scraps, slender scraps, of information to suggest there's institutional bias and hostility towards Mr. Jadhav, and a rather laughable reference, which keeps on repeating itself, is to the Lahore High Court Bar Association and the Secretary of the Lahore High Court Bar Association, having said he would condemn any lawyer who acted for Jadhav. What is the Lahore High Court Bar Association? Is it an organ of the state? And who is this individual? Is he one of those who, with respect to him, still believes that the earth is flat? Well, you found your flat earther because the rest of the world in Pakistan was there for you to investigate. No one else said that. But why didn't you find this decision and put it before the court? There's a reason why. Because upon proper examination, what's the court said? The court has been absolutely clear that it will exercise review jurisdiction if there's insufficient evidence, if there's no evidence, if there's absence of jurisdiction, if there's malice of facts and law. All of the underlying convictions and sentences were set aside for insufficiency of evidence. Orders were granted for release. The matter is subject to appeal. Concluding observations. I'm reminded that, of course, the supervisory body in Pakistan is no different from my supervisory body, the Bar Council of England and Wales. It's the Pakistan Bar Council that has disciplinary function, not the Lahore High Court Bar Association. But it shows you how desperate India is, that its reference for institutional bias it finds in the utterance, which isn't accepted in any event, of an individual who occupies the modest role of a secretary of a provincial bar association. Now that tells you a lot with respect. Concluding observations, Mr. President. Thank you for your indulgence in wanting me, in providing me with the opportunity to go a little over 1 o'clock, but I doubt I will. I have 9 points to make by way of conclusion. And again, I make them in the light of the observations I made right at the outset. The court has my detailed written submissions. The court has this document before it in the judge's bundle with the references. And I say unhesitatingly, based upon the evidence, as follows. First, India's application should be declared inadmissible. I appreciate this is the first time this is going to happen, but sadly there's a first for everything. But we have to thank India for that, because India is the first state to come before this court to abandon studied ambiguity and in its breathtaking arrogance to try to continue to persuade the court that the evidence that is before the court is concocted. It's a litany of false allegations. Well, it isn't. And it's not good enough to keep on invoking the same mantra of concoction, irrelevance, propaganda. The burden of proof shifted to India. That burden has not been discharged. As a consequence, the evidence before the court, sadly, manifests abuse of rights, lack of good faith, illegality, lack of clean hands, and misrepresentation. Any one of those would militate against relief. All of them together, not least those brazen attempts during the course of these proceedings to doctor the military experts' reports, to engage in linguistic contortions so as to wish away the 2008 agreement, and this ridiculous document, headed secret, 7-page memo, which couldn't possibly have been created on the 26th of December, all to try and persuade this court of the position of India, taken together, requires this court, with respect, to declare the application inadmissible, or militates against the grant of any relief. Third, the Vienna Convention on Consular Relations is not engaged, as India has not established, for its own reasons, that Commander Jadhav is an Indian national, nor was consular access refused prior to commencement of these proceedings. Customary international law provided for an exception to consular access in the case of an individual reasonably suspected of espionage, not suspected on the basis of manufactured evidence. This remained unaffected by the VCCR. Fifth point, even if the VCCR was engaged, India's conduct in sending Commander Jadhav to engage in acts of espionage cannot but constitute a brazen, blatant violation of Article 5A, a violation of international law, as well as Article 55, non-interference in internal relations of a state. The absurd proposition that's being advanced is officials who have diplomatic immunity ought to be able to go and see Commander Jadhav, to glean from him which of their assets, their tools of terror are still safe, and be able to continue with impunity until they're declared persona non grata. That isn't what the Vienna Convention was intended for, as Grigory, Tunkin, and others pointed out in 1960. And to allow that to happen in this case would provide a fundamental obstacle to the pursuit of the objective of the Vienna Convention on Consular Relations, namely the promotion of friendly relations between states. A red line exists, and that red line has to be shown in clear and simple terms. Sixth point, further in the alternative, India and Pakistan entered into a clearly worded agreement on consular access, operative in material terms since 1982, and amended in 2008, which identified the basis upon which consular access would be considered in the case of an individual reasonably suspected of espionage. The said agreement, at Article 6, must be given legal effect in accordance with its plain and ordinary meaning. And objective. It's not suggested that India and Pakistan haven't applied the agreement for decades. I respectfully submit it's perfectly consistent with the VCCR, either because it amplifies the terms between the two states, or because it elaborates how they will deal with espionage cases in the context of the absence of any customary international law requirement to provide consular access in such cases. Seventh point, India's claim, which it continues to persist in, for at least, goodness knows what more they want, beyond acquittal, release, return, annulment of the conviction, is being charitable to India yet again, misconceived, being more realistic, at worst, made in bad faith, in the light of the court's previous decisions, consistently rejecting such a claim. And there's a reason why, and I'll come to it with my final point. Because India has made no other claim for relief. And therefore, if its all or nothing strategy fails, it should not be entitled to relief. Penultimately, even if the court were to hold that the Vienna Convention on Consular Relations, Article 36, engaged, and a right to consular access was denied, the appropriate remedy is amply provided for by effective review and reconsideration before the Pakistani High Court, in accordance with Article 199 of the Constitution of Pakistan. This remedy has been available to Commander Jadhav and his family at all material times since his conviction. And that is an important point, because India has studiously avoided invoking this. India, Commander Jadhav's family, have not invoked this. It was open to them to do so after the 10th of April 2017. Why not? And I come back to the point that I made before this court on the 15th of May 2017. This case is not about consular access. This case has at all material times, I'm sorry to say, been political theatre, grandstanding, a platform for India to engage in rhetoric. This incarnation of India, I'm sorry to say, not the India that I'm familiar with, and as such, it's an impermissible use of this court. The court can be confident that Commander Jadhav has the entitlement that, even if the Vienna Convention was engaged, would otherwise flow. And it's vital for the rule of law, not least in these times, for the court to review the conduct of India for what it is. And I invite the court to dismiss the application of India accordingly. Thank you, Mr. President.
I thank Mr. Qureshi. Your statement brings to an end today's sitting. Oral argument in the case will resume tomorrow, Wednesday, 20 February 2019 at 3 p.m. for India's second round of pleadings. At the end of that sitting, India will present its final submissions. Pakistan will present its second round of oral argument on Thursday, 20 February 2019 at 4:30 p.m. At the end of that sitting, Pakistan will also present its final submissions. Each party will therefore have a maximum of 1.5 hours to present its arguments for the second round. I would like to recall that in accordance with Article 6, Paragraph 1 of the rules of the Court, the oral statements of the second round are to be as succinct as possible. The purpose of the second round of oral argument is to enable each of the parties to reply to the arguments put forward orally by the opposing party. The second round must therefore not be a repetition of the arguments already set forth by the parties, which moreover are not obliged to use all the time allotted to them. The sitting is now adjourned. Thank you.
Ladies and gents, if you could grab your seats for me, we're going to begin this session now. So, bit of a treat for you. We've managed to duplicate our ministers. So we now have Greg Clark and Richard Harrington who are going to be speaking to you, because that is how important manufacturing is to this country. We've got, and rightly so. So, Right Honourable Greg Clark, Secretary of State for Business, Energy and Industrial Strategy, is going to start us off. He's going to give us a speech and hopefully get a chance to be asked some questions as well. He's then got to head to make a statement in the House, so got to be back for that. So he'll be here for about 20 minutes. Obviously, we're grateful that he's managed to squeeze it in before that. And Richard Harrington will be here to pick up any extra questions. Of course, Richard Harrington, Minister for Business and Industry. So can we welcome them both to the stage? Thank you.
Richard? Right, both going on? Am I straight on the stage? Straight up? Richard, come and Well, Steph, thanks for that introduction, and colleagues, thanks for putting up with two ministers. You'll have noticed that there is an important announcement today that Honda has made. I've got to go and make a statement to the House. I thought it was going to be right now, but I have a few minutes, so I hope you'll indulge me by saying a few words to you, taking a few questions, and then handing over to my esteemed colleague, Richard Harrington, to pick it up from there. But before I go any further, I just wanted to comment on the announcement made by Honda this morning that their Swindon plant will close in 2021. Now, I'm not going to pretend to an audience of manufacturers that this is anything other than a very bitter blow. And I think the thoughts of everyone in this room are with the dedicated workforce and the suppliers of what has been a phenomenally successful business and has done so much for UK manufacturing during its time here. And with the town of Swindon, whose proud manufacturing tradition, as everyone knows, dates way back to Brunel and the days of the GWR, and which has been home to one of the best car factories in the world during Honda's time there. And so our message to everyone affected by Honda's closure is that we value intensely your skills. We completely understand the challenges that you face, and we will do everything that we possibly can to support every single person in the community, in the workforce, in the supply chain, to make sure that their skills and their ingenuity will find expression and application in the years ahead. Now, of course, this news comes on top of months of uncertainty that you as manufacturers have had to endure about Brexit and about our future relationship with the EU. And just spotting in the audience so many people that I and Richard meet during the course of our work, and I know how important it is to you that we should find an early resolution of what our relationship with the rest of the European Union is going to be. Because you know that every decision that you make on prices, on cash flow, on logistics, and investment has real consequences for the hundreds of thousands, indeed millions of people that you employ. And I've been always quite clear that a situation in which our manufacturers don't have the certainty that they need about the terms under which over 2/3 of our trade will be conducted in less than 40 days' time is unacceptable. It needs to be brought to a conclusion and without further delay. I'm immensely grateful to Stephen Phipson and the EEF, now Make UK, for the advice and the support that they've given on your behalf. This is a membership organisation, and I want you to know that the views that you express to the headquarters are deployed forensically and consistently by Stephen on your behalf. Richard and I meet with Stephen every Wednesday morning for a full hour's discussion of what he's found from his interactions with you during the previous week. And it really makes a difference. I can't understate the importance of the evidence and the intelligence that you supply through Stephen to us in our roles. And it's with the help of the EEF that we made, first of all, and won the argument for a significant transition period, recognising that you need time to adjust to a new regime, whatever it is. A period during which your ability to trade with the rest of the EU remains as now, time to adjust to new arrangements. it was also based on the evidence. And I think there's been a national education in the realities of just-in-time production and integrated supply chains that the whole country has learned, but very much pioneered through the evidence that you've supplied to Stephen and has been deployed through the EEF. That shaped the crucial objective of maintaining frictionless trade, and that remains front and centre in our aims for the future economic partnership with the EU. And I and Richard will continue to work with you and to listen to you, the manufacturers and the employers, to make sure that your voice is decisive in this crucial debate. And yet, as important as all this is, I can't stand here today and claim to you that all of your requirements have been resolved. To do that, we need to have a deal, because leaving the EU without one would, in my view, be a disaster for the whole country. In the survey that EEF, Make UK, published just last week, 2/3 of manufacturing employers said that no deal would result immediately in price increases on products, whilst almost 1/3 of manufacturers said that no deal has implications for jobs. Now, some people, when you voice these concerns, describe this as Project Fear. But for me, as knowing the familiarity that you have with the reality of running manufacturing operations and employing millions of people around the UK, I think it is better described as Project Reality. And your evidence needs to be acted upon. And I know from talking to many of you yourself of the consequences from the logistical problems caused by new customs checks to potential limitations on sending skilled workers to the UK to install, to maintain and service your products. There is I think, a lack of adequate understanding historically in this country as to how intrinsic manufacturing is to the success of our service economy. Many of your products, many of your revenues, I know, derive from the service contracts that you have in support of the manufacturing operations that you have in this country. And I also know and entirely understand the importance of having this resolved much more quickly than I think has been in prospect. The reality is that yesterday, the first freighter that will arrive after the 29th of March set off from Felixstowe, bound for Japan, with no clarity on the terms under which its cargo will be admitted when it reaches its destination. That is, I know, unacceptable to you, and it's unacceptable to me. And for me, this shows how absolutely essential it is to conclude the arrangements with a deal in the weeks ahead. And not on the last minute, on the 28th of March, but as soon as possible. Because no one should regard waiting to the last moment when you are making decisions now that have consequences for many weeks and months ahead as acceptable. I've always thought, and my colleagues in government have, that an orderly Brexit, one that implements the outcome of the referendum, but in a way that protects prosperity, growth and jobs, is what we should insist on. No one wants to be poorer at a time when the opportunities that we have in manufacturing specifically are greater than ever before. So we will go on making sure that the argument that manufacturers put for a deal to be concluded swiftly is something that is heard loud and clear. The deal that has been proposed is by no means perfect, but it does meet, in the view of many of you here, the needs that you've expressed, and in particular provides more certainty in a time of great uncertainty. But of course, decisions like Honda's this morning demonstrate starkly how much is at stake. Honda's announcement they have described as not being related to Brexit, but to the changes that are taking place in the automotive sector. And there are many people in this room that are aware of that and participate in that. And that's why this is such an important time to build on the foundations that we have in our economy, to make sure that we profit from the opportunities, especially in areas in which the UK has a stunning reputation. A few months after the EU referendum, I had a conversation with someone known to everyone in this room, the Siemens UK CEO, Jürgen Meyer, which gave birth to the idea behind Made Smarter, making sure that smaller firms have the ability to access the cutting edge of new technologies that sometimes are taken for granted by the larger OEMs and some of our research institutions, encouraging and helping smaller firms to adopt new technologies that can help them become competitive in this time of global change and to create more jobs. The idea struck a chord, and many people in this room are involved with the Made Smarter Commission that resulted from that. And based on Jürgen's work and supported by you, we have had a huge response right across the UK from the manufacturing community, from companies big and small in every nation of the United Kingdom. We've made substantial progress already. In September, I chaired the first meeting of the Made Smarter Commission, attended by many companies in the room today. The very next month, in October, we announced £120 million to make sure that this diffusion of the technologies that we have in this country to supply chains in every part of industry should be able to be supported. And at the heart of Made Smarter will be what I know is manufacturers' number one priority, skills. There are so many lingering misconceptions that I'm sure you as I are frustrated about, that people have the wrong view of manufacturing. The EF under Stephen asked the British public to guess how UK manufacturing ranked globally. The average guess was 56th. Actually, we're 9th in the world and can rise more strongly. Kazakhstan is 56th. But the perception needs to be countered. And one of the big purposes of Made Smarter, and EF's chair, Judith Hackett, I know here today, is a formidable leader of that initiative to change perceptions of what manufacturing and engineering is about, to show the reality of modern manufacturing as being one of the most exciting vocations that exist in Britain today. We should be proud of the world-class manufacturing talent that we produce in this country, and we need to produce more. And whenever I meet apprentices, whether it's at the MTC, the Manufacturing Technology Centre, just outside Coventry, the AMRC in Sheffield, or Make UK's own apprentices in Aston, I'm blown away by the sense of privilege that people have that have managed to discover what a fantastic career is in prospect if they get into manufacturing and engineering. While companies like Lander Automotive, whose MD, Peter Tack, I think is with us here today, creating new apprentices, 15 apprentices being recruited every 8 weeks to be embarked on a career that will take them around the world with excitement and discovery every year of that. And as more companies embrace new technologies, it won't be about people or technology, but about people and technology. I was struck at the Manufacturing Technology Centre looking at the latest application of robots. The big question is are these robots going to replace people? Quite the reverse. All of the skills there, and you know it in this room, are about making sure that we learn to work effectively with the automation that is made available. People working alongside robots or deciding what to do with data analysis. But as new technologies require new skills, we must make sure that these opportunities are available to those who may not be aware of them. And through our industrial strategy, our new national retraining scheme is designed to help people learn new skills as the economy changes, including as a result of automation. And we're also putting significant investment to help SMEs develop the leadership and management skills that, again, are often available more easily to the larger companies, but to reap the opportunities that we have in the world today, we want to make sure that the best skills are available to the leaders of some of our smaller businesses. With a management training program which could help 10,000 people a year over the next few years. And just as no one should be left behind by the new technologies that are sweeping this industry, no place should be left behind either. I hope that Made Smarter will support small businesses and small manufacturers right across the UK. And in pursuance of that goal, the first wave is in the Northwest, working with the towns and cities of the Northwest, Cheshire, Warrington, and Cumbria, Lancashire, Liverpool and Manchester, to make sure that small businesses there are the first to benefit and to really reinforce what is already a strong cluster of manufacturing excellence. We need to make sure that the opportunities of the fourth industrial revolution are available to every single firm in the economy. But in helping firms understand the data and where suitable to automate production, we can make a real impact. And there's been a huge response in the Northwest with 140 businesses signed up already to learn from the best in the country as to how they can spread industrial digitalization. As well as in automotive, we have a firm looking to use robotic equipment on the production line. We want the applications to be in, for example, food manufacturing, our most important manufacturing business by employment. We want this pilot to become a beacon for schemes in regions right across the country. So, ladies and gentlemen, in the coming days and weeks ahead, we are very conscious, and I have firmly in mind, that your future prosperity in a world of change and opportunity must be at the forefront of our attention in all of the policy decisions that we take. We need to have a test of a successful Brexit is that it should work for manufacturing industry at this time of such great opportunity, and through that, for the millions of people who depend on you. And just as we stand on the cusp of amazing new opportunities for manufacturers, we must maintain and create the future possibilities for everyone in this room. And we're conscious that every hour and every pound spent being devoted to Brexit preparations is necessary, I understand, but actually it is not the main focus of your work, which is to create the products and the processes and the customers that will sustain us for many years to come. So I look forward to continuing the very effective work that we've enjoyed with the EEF and now, I hope, with Make UK, that we can, in a short space of time, now agree a deal that brings the certainty that you have communicated so clearly that you want, and that we can make the UK as synonymous with the fourth industrial revolution as we are through our history books with the first. Thank you for letting me come today and gatecrash your event with my colleague. I'd be delighted to take a few questions, and then you'll forgive me if I've got to go over to the House of Commons to make a statement. But thank you for inviting me.
Thank you. I think we're going to take two questions for Greg, and when we ask questions, if you could state your name and your organisation, that would be very helpful for the record. But before we do that, you heard from me this morning about our relationship with government. Greg's reflected today on the weekly relationship we have in terms of inputting your thoughts into the big issues of the day, not only around Brexit, but on industrial strategy, skills, and the other important issues. And whilst we've got the two of you together, I'd like to thank you on behalf of this sector for all of your support and championing really what's important to us, Greg. Thank you very much for that. Thank you. Okay. Let's start with Andrew Churchill at the front here, shall we? June, thank you.
Thank you. Andrew Churchill, JJ Churchill Limited. Thank you for your words, Secretary of State. A very simple question. We leave in 38 days' time. Could you tell me what proportion of our current FTAs are ready?
Do we have an automatic?
I can't tell you the exact proportion, Andrew, but what I can tell you is, unfortunately, not all of the FTAs, and I might mention the the Japan and Korean ones that are important are expected to be concluded in that time. That is one of the reasons why I think it is so important that we should not leave without a deal. That would mean that those agreements did not roll over, but it reinforces the absolute requirement that we should leave with a deal and that we should do so quickly so that we don't have the jeopardy of those ships currently on the water not knowing how they'll be treated when they arrive.
Thank you very much. We have one over here. Thank you.
Hi, my name's Rowan Egan and I'm with the Northern Automotive Alliance. So we've seen quite a bit of disruption in the automotive sector at present with, Brexit and, of course, Dieselgate. And this has resulted in significant drop in production volumes, and we've also seen the losses of some jobs. There are some opportunities, of course, electrification, and you mentioned the Made Smarter scheme. But can you share a bit more detail just around what exactly is being done to protect the future of the automotive sector?
Absolutely. So there are huge opportunities in the automotive sector in particular. I was talking actually just this morning to an executive in the motor industry who has spent 45 years or so of a career in the sector. And he said that he's frustrated that he is coming close to retirement because the changes are more profound and exciting in that sector now over the next 5 and 10 years than during the whole of his 45-year career, whether it's the change in propulsion to electric powertrains or whether it's navigation through satellites and sensors and connected and autonomous vehicles. This is happening right across the world. And it so happens that we are a leader in the discovery of many of these technologies. And in this room, there will be many people I know that will follow Formula One, for example. And the one thing you know about Formula One is that drivers and constructors might have different national flags when they race, but almost all of the teams are based in Britain and in a cluster of global automotive excellence in all of these, whether it's materials, whether it's powertrains, whether it's navigational aids, they are here. And one of the things that frustrates me about the Honda decision is that they're accelerating the move into electric vehicles. And I think in a few years' time, it will be evident that the results of the investment that we've made with many people here, it's a joint investment with the industry, into being the leader in the next generation of battery technology, in having the best test beds for connected and autonomous vehicles, give us the chance to lead the automotive sector of the future. We're determined to do that. We are well placed. All of us are always going to need to get around in the years ahead, and there is every reason why Britain can be a leader in that. And through the industrial strategy, through the Faraday Challenge, for example, that is building the first battery manufacturing centre in the UK with investment from Williams and Unipart. I think John Neal is here. This is an early example of what is possible. So lots of opportunities in this time, which I acknowledge is turbulent for the sector.
Very good. Okay, for another question, Greg? Or
take one more then?
Take one more question. Yep. Let's go from over this side. Why don't we have one at the front here? Good, thank you.
Thank you. Mike Morgan, I'm the co-owner of Autocraft based in Grantham. What can we expect from the industrial challenge in the next 12 months? We've already had some great results, thank you, from in particular the Faraday Challenge. What can we prepare ourselves for, and what exciting things can you help us with?
Well, thanks. And I should have said a big thank you to everyone in this room who has contributed to the development of the industrial strategy. We identified 4 grand challenges, as we call them. One was the future of mobility that I talked about. The other was the move to clean growth. One of the others was looking at the the potential of the aging population with the changes that is taking place. But let me mention energy, for example, because energy is a good illustration of where a strategy is a plan for the long term, but it's also something that brings convergent sectors together. And one of the things that I can tell you we will see during the weeks ahead on clean energy is the application of some of these technologies that many of you have pioneered in the automotive sector into energy storage to make use of what is now a leading industry, and I'm sure we've got energy people in the room. We are the world's leading deployer of offshore wind, but to make greatest use of it, we need to be able to store it. And so what we have, there is a sector deal being negotiated with the offshore wind industry to bring it together with the work that's being done in the automotive sector to make energy storage something, again, in which Britain will be a leading force. So we'll have sector deals like that, and the sector deals, as you know, bring the industry, government and clusters around the country together. There will be more of those. The local industrial strategies, we will be launching the first of those in the West Midlands in the next few weeks. There has been for too long, in my view, in this country, an approach that didn't recognise the differences and the capabilities of different places, and to give the opportunity for institutions and the co-location of businesses to really help embed, just as I mentioned, the F1 cluster in Oxfordshire and Northamptonshire, to have that type of possibility in other sectors is what you'll see from that. So it's in full implementation, but it can only be done with you, and I'm grateful for your contribution so far in that.
Let's do one last question, shall we, Greg, if that's okay with you? So any more questions from the floor? Apart from David? David, why don't we ask you a question? If you could just wait for the mic for a second, that'd be good. Thank you, so we can hear.
Why don't you ask James Dyson if he'd like to build his electric cars in Swindon?
Good question.
With that mandate from the room, I will do just that. But it allows me to say, I've said a few things about Swindon. What you have there is a fantastic manufacturing facility in a town with not just a history, but an actuality of advanced manufacturing with a highly motivated workforce. Richard and I are bringing together a task force to make sure that the opportunities don't slip through our fingers. And top of that list is to advertise the brilliant opportunity that there is there in that site. And with his operations in Wiltshire, Sir James might want to take a look around.
Greg, thank you very much. You've been very kind with your time. I know you've got to zip off, and we're going to spend a few minutes with Richard on some more Q&As.
Thank you, folks. Thank you very much.
Thank you, Greg. Appreciate it. Thank you. Well, after the Secretary of State Q&A, we now have the Minister for Business, Richard Harrington. So again, any questions from the floor? Terry, you had a question. Do you want to start us off? Wherever. There's one here at the front, Jim. You're in the wrong end.
Stephen, thank you. And I think for Richard, my name is Terry Schooler. I now chair the Institute of Export and International Trade. I think in the event of a no-deal Brexit, the good Lord forbid, what is the fallback plan? What is the plan for support for British industry on the morning of the 30th of March?
Well, thank you, Terry. I feel a bit like Cinderella, really, but I've now got to the ball.
Sitting here.
That doesn't mean I think Greg's one of the ugly sisters, by the way. He's gone anyway, so I could say that. Well, I'd like to answer the question in typical politician's way in two ways. First of all, I do not believe there will be a, whatever it's called, no-deal Brexit. And the reason I don't believe that is because I think that the Prime Minister's deal will get through, but if it doesn't get through before then, Parliament will have taken over control. We will have a small extension to Article 50, and Parliament will then decide on alternatives. So I believe that will become the Plan B, of which I totally favour the Prime Minister's deal.
all. And I can assure him that my honourable friend, the Minister for Mental Health and for Suicide Prevention, is working night and day to make sure that we attract the people we need to deliver the services that our people deserve.
Mr. Speaker, may I ask a question in memory of my late friend Stephen Horgan, who died a few years ago from a very rare form of blood cancer with only a few months' notice. In his memory, I'm now a supporter of Bloodwise, an excellent charity that raise awareness about these rare cancers. And on their behalf, may I ask the Secretary of State, will the new workforce plan for the NHS include clinical psychologists, particularly those with cancer knowledge, in order to make the best absolute use of the very welcome resources that are going into this issue, and which I'm sure Stephen's family themselves would welcome?
Yes, well, my honourable friend puts it extremely well, because he reminds us of who we're here to serve when we are discussing questions of health and of cancer. He's absolutely right to raise this case, and I will absolutely confirm what he asks for. We will deliver, and we'll deliver in Stephen's memory and in the memory of those others who have died, and that is what gives us the strength to carry on and try to deliver and improve these services for everybody.
Mr. Speaker, the Secretary of State talked earlier about a 6-week stockpile of medicines. One thing that can't be stockpiled is radioisotopes for cancer diagnosis and treatment. I have asked multiple times in this place about arrangements. Can the Secretary of State detail the arrangements now for radioisotopes post-Brexit?
In the event of a problem at the border, at the Dover-Calais Straits, then we will be bringing in radioisotopes by air. We've already contracted an aircraft to make sure that this happens. So that part of the planning is very well advanced.
Speaker, on Thursday I had the great pleasure to open, along with Rugby's Mayor, the new Browns Over surgery, which has come about because of the hard work of the Patients Action Group there. Will the Secretary of State welcome the work of patients groups in delivering NHS services?
I'm absolutely delighted to welcome the work of the group who have raised so much money, and of course to my old friend who stands up for rugby and makes the case. And more broadly, we should welcome all those who want to make a contribution to our hospitals, to our hospices, and take a broad-minded and open approach to welcoming, whether volunteers volunteering hours, or people raising money to improve our great NHS.
Thank you. Order. Urgent question. Nick Thomas-Symonds.
Thank you, Mr. Speaker. To ask the Attorney-General to make a statement on options for legally binding changes to the Northern Ireland Protocol in the EU withdrawal agreement, which contains the backstop arrangement.
Solicitor General Robert Bachman.
Mr. Speaker, before I answer the honourable gentleman, I think my constituents would expect me briefly to express their dismay and deep concern about Honda's announcement this morning, which will deeply affect the community. I anticipate the statement of my right honourable friend, the Business Secretary.
Order. Don't tell me what the situation is. The honourable gentleman is a law officer and a member of the government. A sentence, but absolutely no more. He should have asked me in advance. You're either on the front bench or you're not when you're in government. It's not for the honourable gentleman to presume the right to speak about a matter about which he could speak if he did sit on the back bench, which he doesn't. The Solicitor General.
Well, I'm very sorry, Mr. Speaker, but I've said what I've said. The government recognises the legitimate desire of members on all sides to understand the legal effect of the proposed withdrawal agreement. On the 12th of February, the Prime Minister set out ways in which legally binding changes to the backstop could be achieved. The Prime Minister explained that the UK and the EU would hold further talks to find a way forward. These discussions are ongoing. It would not be appropriate to provide a running commentary.
Thomas-Symonds.
Thank you, Mr. Speaker, for granting this urgent question, and indeed to the Solicitor General for responding. But the reality is there are 38 days until we leave the EU, in all likelihood 8 days until the next round of voting, and we are nowhere nearer having any further clarity on this issue. And all the time, our economy, our jobs and our futures are affected by this uncertainty. On the 29th of January, the Prime Minister told this House, and I quote, What I am talking about is not a further exchange of letters, but a significant and legally binding change to the withdrawal agreement. Negotiating such a change will not be easy. It will involve reopening the withdrawal agreement. Can the Solicitor General confirm that it's still government policy to formally open the withdrawal agreement? If not, what positive, concrete proposals is the government suggesting? And can the Solicitor General confirm these proposals have actually been put forward as options by the government to the European Commission and the European Council? Yesterday, on Radio 4's Today programme, the Minister for the Cabinet Office said, and I quote, "The Attorney General, Geoffrey Cox, is closely involved with the negotiations too, and he will be making a speech on Tuesday to set out how, in his view, the legal test that he has set about ensuring that the so-called backstop cannot be used to trap the United Kingdom indefinitely could be met and overcome." Can the Solicitor General clarify exactly what the Attorney General's role in the negotiations is and when he will publish these legal tests? Is the government seeking, as is reported in the media, a joint interpretive instrument on the withdrawal agreement, some sort of annex to it, another exchange of letters, or changes to the political declaration? Mr. Speaker, we are about to make a momentous decision on the future of our country. The government needs to be clear with this House as to precisely what its strategy is. Running the clock down is reckless and irresponsible. Surely this nation deserves better than a government wandering in the wilderness, not even sure about what its next move is.
General. Mr. Speaker, what would be reckless and irresponsible would be for this government to provide a running commentary on sensitive negotiations. I would have thought it is as plain as a pikestaff to the honourable gentleman that that is not the way negotiations should be conducted. And let the government get on with this work at pace, which is what we're doing. Rather than criticising from the sidelines, Mr. Speaker, I think it now behoves the honourable gentleman and all those on his side to actually work for a constructive solution and end the uncertainty. It is in his hands as much as it is in the hands of the government.
Mr. Kenneth Clark. Mr. Speaker, I understand the dangers of a running commentary, but I have a little difficulty in understanding what the process is by which we've reached so far. So far as I can see, the serious negotiations are with the DUP and the European Research Group in my party to see what modifications to the withdrawal agreement we had negotiated they will accept. Then ministers go to Brussels to demand that the European Union accepts the changes and threatens them with leaving, a no-deal leaving if the changes are not made. Can my right honourable friend tell me whether that is, as he understands it, roughly the tactics being pursued? And also, why he thinks any European politician should accept a situation whereby the permanent open border in Ireland is subject to being terminated at any stage it wants by the British government or having an end date put on it, which seems to me a contradiction. And finally, does he think that the hardliners in the ERG would accept even that, even if my right honourable friend, the Attorney General, produces some ingenious form of words that seems to make it legally binding?
My right honourable friend tempts me as usual down many paths that I dare not go, simply because this is a negotiation between the United Kingdom and the European Union. We heard yesterday from my right honourable friend, the Secretary of State for exiting the EU, who has been to Brussels and who has held a productive meeting with Monsieur Barnier, and indeed my right honourable friend, the Attorney himself, has been playing an important part in these negotiations. Can I reassure him that the government remains determined to get on with the job at pace?
Joanna Cherry. This morning, France's Europe Minister, Nathalie Loiseau, said that there will be no renegotiation of the withdrawal agreement. And in saying that, she was simply echoing what has been said repeatedly by Donald Tusk, Jean-Claude Juncker, Angela Merkel, Emmanuel Macron and Leo Varadkar. And this was the position that was made crystal clear to the Exiting the EU Select Committee when we met with Martin Selmayr on 4th February. What he said was that the most that the European Union would be prepared to contemplate was an additional legal instrument or codicil to the agreement, which would incorporate the sort of assurances set out in the letter from Tusk and Juncker dated 14th January, but which would not contradict or change the existing text of the agreement. Now, can the Solicitor General confirm that that is still the position of the European Union and that there's no question of the withdrawal agreement being opened up and renegotiated in relation to anything, let alone the backstop? Will he confirm that it's quite clear that there will be no time limit or unilateral exit clause to the backstop? And if his position is that he doesn't want to give this House a running commentary, why is it that the Attorney-General is supposed today to be elsewhere giving a speech about what's proposed, not to this House, but to I don't know who? And is it true that that speech has been cancelled? And if so, why has it been cancelled?
Can I reassure the Right Honourable and Learned Lady, who expresses a deep interest in the diary of my Right Honourable friend, the Attorney-General, his plan is to make a speech about the issues, but can I assure you that it is not going to be some detailed exposition of a legal position which he will bring to this House if appropriate. He has already shown an admirable willingness, Mr. Speaker, to not only address this House but to comply with its orders as well, and I'm sure he will continue to work in that spirit. I'm very glad that the Honourable and Learned Lady referred to the letter of the 14th of January, because I think it's important to remind ourselves there that the Commission, in that letter, made it very clear that it was determined to give priority to the discussion of alternative arrangements. Now, that is very much part of the ongoing discussion. I think it would be, shall we say, somewhat difficult for me, Mr. Speaker, to commit the other party to the negotiation to a particular position. I've heard her comments with interest. I'm here to speak on behalf of Her Majesty's Government, and our position is clear.
Sir William Cash.
Thank you, Mr. Speaker. As you know, Mr. Speaker, I raised this matter urgently with you yesterday. Does my right honourable friend accept that it is essential that when the Attorney-General has had his discussions in the EU, that he tables, in compliance with his parliamentary obligations, any asserted legally binding treaty text in black and white in the House itself by Monday the 25th of February, so that my European Scrutiny Committee can fully assess and report to the House on its legal meaning and the substance, and not merely address some audience at a city law firm.
Well, my right honourable friend raises a very important point, and both the Attorney and I take the work of his committee, a committee of this House, with the utmost gravity. Can I assure him that any work that is done with regard to legal texts will, of course, be shared at the appropriate moment? I think he'll understand that I can't give him an absolute time commitment in terms of dates, but I've heard what he said and will certainly bear those comments very much in mind in the days ahead.
Thank you very much indeed. Mr. Speaker, if the technology existed that could keep the border between Northern Ireland and the Republic as it is today, then there would be no need for the backstop. The Minister knows that that technology does not exist. And no one can say when it might become available. And in those circumstances, can he please explain to the House how the government can credibly either ask for a time limit or a unilateral exit clause, particularly when he knows that the EU has made it very clear it has no intention of giving either?
Well, the Right Honourable Gentleman, the member of the Chairman of the Select Committee, I think elides two issues: the existence of technology and actually the sensitivities of the communities on both sides of the border. I don't think any of the discussions that have been ongoing relate to new technology in the sense that it needs to be relied on today. There's plenty of existing technology that could be used. The most important point, however, is the communities and their sensitivity. That is well understood by the government. I think that to hang his hat on that as a reason for the absence of any potential termination clause or unilateral mechanism is to simplify things just a bit too far.
Dr. Henry Mirison.
Does the Solicitor General agree with me that whatever agreement is arrived at with Brussels, we must get away from the idea that the potentially forever customs union is seen as base camp for our future trading relationship?
General.
Well, my honourable friend is absolutely right to remind us that the future relationship document contains a range of options. The negotiation on that will begin as soon as possible. Let's get the withdrawal agreement done so that we can have that debate urgently.
Ms. Redwood-Davey. Has the Solicitor General seen the study published yesterday by Irish Senator Mark Daly in conjunction with 2 UNESCO chairmen on the danger of return to violence in Northern Ireland in the event of a no-deal Brexit? Given Senator Daly says in his report, and I quote, "It highlights the responsibility of the UK government to stand by the backstop," what weight is being put on by Her Majesty's government in their discussions on the backstop for the cause of peace?
I'm grateful to the right honourable gentleman. I've not seen Senator Daly's report, but I will look at it urgently because, like him, I take the cause of peace with the utmost seriousness. And in fact, everything that the government has said reveals its dedication to not just the letter of the Belfast Agreement, but its spirit as well.
Mark Francois.
Thank you very much, Mr. Speaker. The Solicitor General has told the House very clearly that the government will not provide a running commentary on the negotiations. Unless, of course, you're Ollie Robbins, the government's chief negotiator, when you can get hammered in a bar in Brussels and give a very detailed running commentary to anybody who happens to be in earshot. That is extremely unprofessional behaviour for a senior civil servant. A minister who did that would be sacked. What disciplinary action has been taken against Mr. Robbins, or did he get away with it because he's teacher's pet?
The right honourable gentleman has referred to a newspaper report that I think would be ill-advised for me to comment on. Can I say this generally about our civil servants? Whatever their role or position or their views, they're in a singularly difficult position in that they cannot answer back.
Mr. Nigel Dodds.
Speaker, everybody knows that there's not going to be any hard border in Ireland, and everybody knows, given what Michel Barnier said, that even in the event of a no deal, that operational ways would be found to have no controls and checks. Exactly. So all of this is scaremongering and isn't going to happen. Anyone who knows anything about Irish politics knows that no Irish government will introduce a hard border on the island of Ireland. That's the reality of the situation. The fact of the matter is that the Prime Minister has, as the Solicitor General knows, given a commitment to reopen the withdrawal agreement and to seek legally binding changes to the treaty itself. Now, yesterday, Simon Coveney ruled out legally binding language even outside the withdrawal agreement. Does he not accept that some of the rhetoric coming from the Irish government and others is bringing about the very thing that they say they want to avoid, which is the possibility of a no deal?
The right honourable gentleman is absolutely right in his call for everybody to cool it and to calm down when it comes to important issues like the Irish border. I'm not going to make comments about members of friendly governments, but what I will say is that this is a time for calm heads rather than hot ones.
Well, on the subject of calmness, I think we should hear from a Lincolnshire knight. Sir Edward Lee.
Thank you. This is really a taster for what will be a very calm debate on Thursday, my German debate on this very subject, which I'm sure will be the highlight of the week. But without asking the Solicitor General to make running commentary, has he noted that many international lawyers said it would be entirely in accordance with international law if the EU doesn't want to reopen the withdrawal agreement, for us to issue, either unilaterally or in agreement, a conditional interpretive declaration proclaiming that there will be an end date to the backstop, something which I've been boring on for weeks now.
My right honourable friend is anything but boring, Mr. Speaker. He might be persistent, but boring, no. I commend him for the work that he has done in looking at this particular aspect of international treaty law and interpretation, and I urge him to pursue it.
Yeah, no, he's quite wrong. He's far too hard on himself. I've known the honourable gentleman for 25 years, and I've never been bored by him on any occasion. Never. Mr. Barry Sherman.
Mr. Speaker, I wonder if the Minister would mind me putting on record, and I hope he put on record, the distaste we felt of that personal attack from the backbenches, I think from a member of the ERG, on a civil servant trying to do his job. The job that they're trying to do is a very difficult one, and the people responsible for that difficulty is the government, not the civil servants trying to do a good job. But will you agree with me that what we need in this House is a running commentary? And I'm glad he's making the statement today, because the fact of the matter is, at a certain juncture in this dialogue we're supposed to be having to find the answers to this difficult problem, that side, the government side, stop talking to people. Will you resume the talk so we can get this sorted?
Well, the right honourable gentleman knows that I'm here. I'm always ready to talk, as is the government. That dialogue continues. The Leader of the Opposition has, of course, made an approach which we welcomed. That is an important sign of cross-party work that needs to continue. I've said what I've said about our civil servants. Politicians are here to be accountable and answer for our actions. They are there to carry them out, no further.
Vicky Ford.
Thank you very much. I have to say I find this urgent question from the opposition somewhat bizarre, as only last Thursday the opposition spokesperson on Brexit said he had no problems with the backstop at all. However, for the avoidance of doubt, can you confirm again, Solicitor General, can the Solicitor General confirm again that this government stands firmly behind all of its commitments on the Belfast Good Friday Agreement?
I will never tire of saying that to my honourable friend or to this House. We remain steadfast in our commitment to the Belfast Agreement. It is important to me now as it was when it was signed 20 years ago.
Thank
you, Mr. Speaker. Mr. Speaker, the Attorney General, the Solicitor General made a rather, if I may say so, snippy remark about my honourable friend, having made a comment from the sidelines, and then implied that the solutions to this situation were as much in his hands as in the Solicitor General's. He can't have it both ways. Has the Solicitor General invited my honourable friend to be part of that solution, yes or no?
Well, can I remind the Honourable Lady, who I have a high degree of respect for, of Section 13 of the European Withdrawal Act, which gives this House the role of ratifying the withdrawal agreement. It is Parliament that has to ratify it and pass a bill before that agreement is ratified. It's on all of us. The buck stops with all of us before we can ratify. So please, get on with it.
Andrew Bridgen.
Speaker, does the Solicitor General agree with the widely reported comments of Ollie Robbins, the Prime Minister's chief negotiator, who I believe spoke in Vino Veritas when he said that he saw the backstop as a bridge to a future partnership, clearly a future partnership revolving a customs union, which would prevent us having an independent free trade policy? And if the Solicitor General doesn't agree with him on behalf of the government, why is Mr Robbins still in his position?
Well, the honourable gentleman will have heard the answer I gave some moments ago. I'll simply say this to him, that the backstop is not intended to be a bridge to anywhere. It is only to be used in extremis if we cannot achieve a future relationship. It cannot be a bridge. The bridge has to be with the withdrawal agreement and then our future relationship.
Liz Savile-Roberts.
Solicitor General seeks to justify the problem that is Brexit by insisting that the backstop is the problem. And now I understand that he wants to sympathise with manufacturing communities in Swindon and Wales and elsewhere, and they're waking up to job losses, but it's difficult because he's in the government. Given the evidence, how can the government, abetted by the Labour front bench, continue to defend their myopia, their self-interest, their talent for procrastination? When will he admit their part in this problem?
Well, I can agree to her to this extent, that I think it is incumbent on politicians from all sides of the House, most importantly the opposition front bench, to work to achieve a solution rather than to achieve narrow party political ends. I entirely agree with her. I have seen precious little of the former and far too much of the latter, but God loves a sinner who repenteth, and I look forward to the opposition following that advice and helping us all do our duty and get the deal through.
Sir Bernard Jenkin.
Can I, first of all, thank my right honourable friend for making it clear that there are viable alternative arrangements which the government is discussing arising from the so-called Brady Amendment. But can he, President Tusk last week tweeted that no concrete proposals had been received from the UK government. Can you now confirm that these proposals have been presented as government policy to the European Union?
Well, I'm grateful to my right honourable friend. He knows that it would be invidious of me to provide that running commentary that I have been, I think, quite properly resisting. Can I assure him that the discussions are more than diplomatic niceties, that they are meaningful and substantial, and they will continue in greater depth in the days ahead?
Thanks. Gregory Campbell.
Speaker, can the Solicitor General indicate whether the government have made it clear to the European Union in negotiations that their insistence on the backstop is going to prove the most expensive financial and political wrongdoing in the past 60 years, because there cannot be a hard border because of the complexity of the border on the island of Ireland?
Yes, that's right.
Well, the honourable gentleman, with his deep knowledge of the border, speaks absolute truth when he talks about its complexity. Can I assure him that this government is dedicated to making sure that the backstop is fully understood, and the importance of making sure that this House can coalesce around a deal that will be acceptable. And I think that is now very much understood in the corridors of Brussels.
Mr. David Jones.
It is, of course, entirely reasonable that the Solicitor General should decline to conduct a running commentary on the progress of the negotiations, but can he at least confirm that in approaching those negotiations, the government has borne fully in mind the view of this House that the Northern Ireland backstop should be replaced with alternative arrangements, a state of affairs which I would suggest would not comprehend a mere interpretative instrument?
Well, indeed, the government listened very carefully when the House passed the so-called Brady Amendment, Mr. Speaker, and has pursued the strands of work that were encouraged by honourable members. That continues, and I am confident that it will bear fruit.
Ian C. Lucas.
Thank you, Mr. Speaker. Will the Solicitor General please confirm my view that the Prime Minister's withdrawal agreement creates a different set of trade rules applying on each side of the Irish Sea?
Well, without going through the detail of the protocol, the honourable gentleman knows that the particular construct of the protocol meant that for certain items of trade, then Northern Ireland was treated as a member of the single market. There would be an effective border if this country, if GB rather, Great Britain, changed its rules and there was a difference between the two. That's not our intention. I needn't recite the matter any further. He knows that that's one of the reasons why we've been looking carefully again at the backstop, bearing in mind the decisions made by this House. But it's time for him to come forward, be a statesman and vote for the deal.
Sir Desmond Swain.
Does this speech by the attorney include the assessment that the one thing worse than the backstop would be staying in the EU?
Well, in response to my right honourable friend, I've not read the speech yet, so I think it would be wholly premature of me to assume what my right honourable friend, with great style no doubt, will dilate upon.
Clive Bett.
Will the Solicitor General give an assurance that if there is any change to the legal advice which the government receives about the withdrawal agreement or any related documents, that that advice will be given to this House before we have the opportunity to vote on any resolution to which it might be relevant?
The right honourable gentleman asks a very proper point. Can I say this, that very careful consideration will be given to the publication of any documents that may emanate from my right honourable friend. We're very mindful of the position we reached in light of motions passed by this House. I think at the moment it would be wrong for me to prejudge anything that might or might not exist, but I've heard him very clearly.
Stephen Metcalfe.
Thank you, Mr. Speaker. I agree with my right honourable friend that it is not appropriate to provide a running commentary during these negotiations. But does he agree with me that during any negotiation it is not appropriate to remove the option of being able to walk away from that, as that is what focuses the minds?
Well, indeed, the government have been very clear about this, that when it comes to negotiations, one shouldn't willingly and wantonly abandon the cards that it has in its hand. And that is the way we will continue to negotiate, firmly but fairly, and as openly as possible, consistent with our duties to this House.
Peter Grant.
Thank
Mr. Speaker, we've seen all the usual excuses today, haven't we? Blame the civil service, blame Brussels, blame Ireland for what is an entirely British-made problem. As long ago as December 2017, the government, with the full support of the DUP, gave a binding commitment to provide a solution that would make their customs union red lines compatible with the Belfast agreements. Isn't it the case that the only reason the backstop will ever exist is because the government have failed to deliver on those commitments? And will the Solicitor General not finally admit that when it becomes clear that leaving the customs union and single market is incompatible with Belfast agreements, then the Belfast agreement has to stay and the government's red lines have got to go?
Hear, hear.
Mr. Speaker, I've not been seeking to blame anybody. I don't believe in blame games when it comes to constructive negotiation. I believe in trying to find solutions. And I think it's high time that the honourable gentleman and his party actually joined the solutions-based approach rather than constantly carping from the sidelines. I'm absolutely fed up of that approach. It's time that they grew up and joined the debate.
Hugh Merriman.
Thank you, Mr. Speaker. The Solicitor General is not only a great fighter for his workers in his constituency, but he's also a canny negotiator for government. So would he agree with me that rather than members of this place parroting how difficult it will be, position lines from EU27 government ministers, we need to hold our nerve, keep our best cards, and that way we will get a deal, and we will also ensure we deliver democracy at the same time?
I'm very grateful to my honourable friend for his remarks about the communities that both I and the member for North Swindon serve in the context of Honda. He's absolutely right to say that it is rather rum for people in this House and elsewhere to constantly believe the words of other negotiating parties and other governments as gospel and refuse to accept anything that Her Majesty's government might say as even in the remotest bit true.
The word rum was much favoured, as colleagues will know, by P.G. Woodhouse, and of whose works I suspect the Solicitor General is, amongst others, a devotee. Gareth Snell.
Thank you, Mr. Speaker. The Solicitor General says that it is in the fate of the Labour Party to help him secure a deal, but that simply isn't true. Could he tell me what concessions, if any, government are going to make towards the deal that the Labour Party has put down as a potential way through this? But he also said, but he will also know that I have given his government the benefit of the doubt on more than one occasion by not supporting things my party have asked me to and actively opposing things on other occasions. I didn't support the government on the Brady Amendment, but nor did I oppose it, because I did believe it was important that government had the space to do negotiations to get a deal through. The wording of that amendment quite clearly said replace the backstop. So without equivocation, can the Solicitor General tell me, when he brings that deal back, will the backstop have been replaced?
Well, I note with care the honourable gentleman's position, and I've observed what he is doing to represent his constituents. I do have to say to him, I think it would be somewhat preemptory of me to anticipate what might come back from the negotiation. Can I assure him that we're trying to get on with it at some speed so that his position can be as clear as possible, and he is able, with the rest of this House, to make that all-important decision on behalf of his constituents.
Kevin Foster.
Thank you, Mr. Speaker. The Solicitor General will recall, like I do, the House expressed a clear view on the 29th of January, and I'm pleased to note the Government is now negotiating to try and implement that and bring something back. But can he confirm that it's right not to give a running commentary on this, and that anyway the House will have the opportunity next week to debate and vote on this matter again?
I'm grateful to my honourable friend. He is, of course, correct on all counts.
Nick Smith.
Thank you, Mr. Speaker. This morning, the Health Secretary said that the NHS is spending £11 million preparing for no deal. Now, in January, this House voted for the Spellman-Dromey Amendment to take no deal off the table. So can the Solicitor General confirm why the government is ignoring the will of the Commons by trying to keep no deal on the table and spending this £11 million unnecessarily?
Well, I'm grateful to the honourable gentleman. The Spellman-Dromey Amendment actually committed a course of action that this House would not leave without a withdrawal agreement and future relationship. Those aren't quite the same things as the assertions that he makes. He knows that I am as anxious as he is to achieve a deal. He represents a constituency that I know well, that has more than its, shall we say, fair share of challenges. I want to help him and his constituents. The way to do that is to end the uncertainty and support the deal.
Mr. Bullabone.
Is it the policy of Her Majesty's Government to replace the backstop with alternative arrangements?
Well, my honourable friend knows the government's position. The Prime Minister set out a number of ways in which there could be a revision to the withdrawal agreement. Those matters are being pursued actively, and we will come back as soon as possible and hopefully satisfy him that he will be able to do the right thing and support a withdrawal agreement that will facilitate the Brexit that he has campaigned for so long to achieve.
Simon Clark.
Speaker, on the 29th of January, I voted for the Brady Amendment to replace the backstop with alternative arrangements, and I praise my right honourable friend for his personal role in helping to develop the Malthouse Compromise. With regard to the second meaningful vote, whenever it comes, can I urge him to emphasise to colleagues across government that the definition of insanity is to repeat the same experiment and expect a different result?
Well, my honourable friend puts it in a very attractive way, and I commend him for that. He knows, he like me, I think, is a realist, and he knows that he, representing his constituents as ably as he does, will want to resolve the uncertainty. I know he's very keen to do that, and I applaud him for the constructive approach that he's taking, and I very much commend that to him in the days ahead.
Nigel Huddleston.
Thank you, Mr. Speaker. While I recognise the challenging position of many opposition MPs, does the Solicitor General share my amazement at those opposition MPs who say they can't support the withdrawal agreement because it may include a temporary backstop keeping us temporarily in the customs union, but not paying into the coffers and without freedom of movement, and then simultaneously advocating a permanent customs union and stopping us from doing international trade deals?
Clark, having consulted his scholarly cranium, has just pointed out to me, is that it wasn't about government policy and therefore it doesn't warrant an answer. The honourable gentleman has made his point in his own way, but he was asking about opposition policy, which he knows he shouldn't do. Mr. Kevin Hollyrake.
Mr. Speaker, rather than having to agree with the European Union where we've met our obligations to avoid a hard border in Northern Ireland, would it not be fair and reasonable to both sides to refer the matter to a process of arbitration?
Well, my honourable friend does tempt me down an interesting path. He knows that, of course, the arbitration process is contained within the provisions of the agreement itself. I think that we appreciate that time is of the essence, and it's within that constraint that we have to operate, which is why we are very keen to come back as quickly as possible to this House.
Jeremy Lefroy.
Thank you very much, Mr. Speaker. I listened with great attention and respect last week to the former Taoiseach of Ireland, Bertie Ahern, as he gave evidence to the committee for withdrawing from the EU. And he made the point that leaving with no deal would be extremely damaging to people on both sides of the border, both the Republic of Ireland businesses and Northern Ireland businesses, particularly to indigenous businesses, not so much the international businesses. Does he agree with me that this is why it is incredibly important that this matter is resolved and that the withdrawal agreement is passed with support right across this House?
My honourable friend has long been a keen student of these issues. He is absolutely right to warn us about the dangers of a no deal, which is why he, I and many, many others have supported a deal. It's now time for all of us to do that, just that, and end the uncertainty.
Paul Masterton.
Thank you, Mr. Speaker. Isn't it the case that the time for running around Europe with ambitious schemes that aren't going to be accepted is over and simply increases the chances of a no-deal exit, and that the requests for any changes need to be detailed and precise? So can my honourable friend confirm that the government will be going in with a targeted microsurgery approach, not trying to blast the withdrawal agreement with a scattergun?
I can assure my honourable friend, who speaks with conviction and passion and serves his constituents admirably, that the government will be taking a forensic approach to this. This is a detailed negotiation. The time for platitudes is long gone, and we will be adopting his approach in the days ahead.
Thank you. Order. Oh, well, if it arises from the urgent question and in deference to the Father of the House, let's hear it. Point of order, Mr. Kenneth Clark.
Genuine point of order, I think, Mr. Speaker. In the course of the exchanges, two members of Parliament on this side of the House made reference to a civil servant, Sir Oliver Robbins, who they obviously regard as some sort of political enemy, although he's a non-political civil servant. They not only repeated newspaper rumours about what he'd supposed to have been overheard saying, but they did so in terms that suggested he'd been drinking too much when he was overheard, from which, so far as I am aware, there's never been the slightest indication, even in any of the newspaper reports, on which they were relying. Now, Mr. Speaker, people like that have no opportunity whatever of even knowing these allegations are going to be made or replying to them. There is an increasingly unpleasant personal tone creeping into the debate about Europe, mainly from the right-wing members of my party, and it will get quite out of hand if you don't issue a word of reproof and say that that's an abuse of the privileges of the House of Commons and is not conduct that should be repeated.
I'm grateful to the Father of the House. I have had discussion about the matter with the clerk. I won't argue the toss about wording. It's not, strictly speaking, an abuse of the procedures of the House, and it's not disorderly, but I think it is extremely undesirable, and it does represent a rank discourtesy, and indeed, as the Right Honourable and Learned Gentleman implied, a coarsening or vulgarisation of the terms of trade in political debate, which we should all strive to avoid. And let me say to the Father of the House that I didn't react quickly enough, as I should have done, to the Right Honourable Gentleman, the member for Rayleigh and Wickford, when he said what he did. He's absolutely entitled to his point of view and even to robust questioning of ministers, of course, but he shouldn't have said what he did about a serving civil servant. And perhaps I can just gently suggest, at the risk of embarrassing the Father of the House, that members across the House, whatever their political views, would do well to seek to emulate his own example. I've known him for 24 years, and throughout the time I've known the Right Honourable and Learned Gentleman, I've always observed one thing. He plays the ball. He doesn't play the man or the woman. He sticks to the issues, rather as the chair of the Brexit Select Committee does on the other side of the House. And that really is the model that other colleagues should follow. So I thank him for stepping in, and the point he's made is a valid one.
Well said, Mr. Speaker.
Thank you. Order. And statement, the Secretary of State for Business, Energy and Industrial Strategy. Secretary Dr. Greg Clark.
Thank you, Mr. Speaker. And with your permission, I would like to make a statement about Honda. This morning, Honda announced that future models of its Civic car, which are currently made in Swindon, will after 2021 be made in Japan. The Civic is the only vehicle that is made by Honda in Swindon, so as a result of that decision, the company's manufacturing plant will close in 2021. I'm not going to understate what a bitter blow this is to the 3,500 skilled and dedicated workers at Honda in Swindon and their families, to the many more people and businesses who supply the plant, and to the town of Swindon, which has been proud to be home for 34 years to one of the best car factories in the world. It's a blow to the whole British economy. Honda have given the reason for their decision as accelerating the move to electric propulsion and choosing to consolidate investment in their facilities in Japan. Following the entry into force of the EU-Japan Free Trade Agreement earlier this month, tariffs for cars exported from Japan to the EU will drop from 10% currently to 0 by the 1st of January 2026. Honda will then export from Japan rather than Britain to Europe and the rest of the world. The company has stated that Bracknell will be retained as its European headquarters and that it will continue to base its Formula One operation from Britain, and that its research and development centre into electrification and connected and autonomous technologies will continue at Swindon. Honda has announced an immediate consultation with the trades unions and the suppliers on this plan. I've spoken with the trade unions, with the local members of Parliament, the leader of Swindon Borough Council and the chair of the Local Enterprise Partnership. Shortly I will chair in Swindon the first meeting of a task force comprising these people and others to do everything we can to ensure that the much valued workforce of Honda in Swindon find new opportunities which can make use of their skills and experience. We'll work with the local community to ensure that Swindon's justified reputation as being a place of industrial excellence in manufacturing, technology and services is maintained and expanded. And in our automotive sector, we'll work in close partnership with an industry that is going through a period of technological change and adjustment across the world greater than at any time in its history. A period of change that is disruptive and, as is obvious today, painful for many, but in which Britain's industry can emerge as a global leader if we back innovation in new sources of power and navigation. One of the four grand challenges of our industrial strategy and the focus of our automotive sector deal. Mr. Speaker, I and many other colleagues in this House of all parties have worked hard over the last 3 years to make the case for investment in Britain to investors in this country and around the world, despite the uncertainty that Brexit has put into the assessments of investors in Japan and around the world. We've secured investments during this time from Nissan, Toyota, Geely, BMW, PSA, Aston Martin, Williams, and many smaller firms. We have an international reputation for being a place to do business with skilled, motivated staff, with access to innovation, especially in automotive, which is the best on the planet, and with a determination to make those strengths even greater during the years ahead. This is a devastating decision that's been made today, and one that requires us to do whatever and all that it takes to ensure that in years to come, Honda will once again, building on its continued presence here, recognise Britain as the best place in the world to build some of the best vehicles in the world.
Cologne Bailey.
Thank you, and I thank the Secretary for advance sight of his statement. Mr. Speaker, this morning's news is absolutely devastating for the 3,500 workers in Swindon, their families and the wider community. It's absolutely devastating for the businesses in Honda's supply chain and the tens of thousands employed within them. And it's a devastating blow to the automotive sector, the UK manufacturing in general, and indeed our entire economy. A worker employed at Honda in Swindon for 24 years summarised the situation last night when he said that the government is completely incompetent. Mr. Speaker, I couldn't agree more. Honda's decision is a damning indictment of this government's failure to support car manufacturing and ensure business confidence, both in terms of Brexit and in terms of their so-called industrial strategy. And before members of the opposite bench become too agitated, I understand that Honda's CEO this morning said that the decision was unrelated to Brexit. However, the company's statement specifically says they want to focus activity in regions where it expects to have high production volumes, especially of electric vehicles. So the question logically follows, why does Honda no longer believe that the UK will have high production volumes? And why do they no longer have confidence to invest here to make it so? They will be exporting, as the Secretary has stated, from Japan to the EU instead of from Britain. The reason why the likes of Honda and Nissan began producing in the UK in the first place was because it was a good place to locate their manufacturing. So something must have changed. Could it be the government's botched Brexit, causing chaos and uncertainty and undermining business confidence? The Secretary also alludes to the Japan-EU deal, which imposes zero tariffs at a time when we don't know what our tariffs are going to be. The likes of Airbus, Nissan, Ford and Jaguar Land Rover have all halted investment or slashed jobs as a direct result of the uncertainty. Nissan only 2 weeks ago reversed their decision to build the X-Trail here. JLR have slashed 4,500 jobs and Ford have cut 1,000 jobs. Over the weekend, we had the Airbus Senior Vice President saying that a no-deal Brexit would be catastrophic, adding that we will have to look at future investments. There's many other countries that dearly love aerospace. In fact, Honda itself warned last year that leaving the EU without a deal could cost the company tens of millions. So there can be no doubt this government's reckless threats of no deal and prolonged uncertainty is having an impact on business decisions in the here and now, even if that isn't the top line of a press release. So no deal must be taken off the table and a firm commitment to the customs union and a single market deal agreed. Now, Honda also say that global trends and the move to electric vehicles is a factor in their decision. So could it be that this government's failure to support the transition to electric vehicles through their industrial strategy has augmented their decision? They want to expand their electric vehicle production, something we all want, but we need that production to be here in the UK now, not used as a reason to close down plants in the wake of Brexit. The UK has a world-class automotive sector, and it could be a world leader in electric vehicles, at the cutting edge of electric vehicle technology and research. But this government has failed to invest to support this transition. Just one example. The Treasury pledged last year to support the switch to zero-emission vehicles with a £400 million fund for charging infrastructure, giving manufacturers the certainty to invest in production. Half the money was to come from the taxpayer, with the rest matched by the private sector. But 1 year on, Mr. Speaker, the money promised to be raised from the private sector has not been secured, and no money from the fund has been invested. Mr. Speaker, the automotive sector is the jewel in our manufacturing crown. It supports high-paid, high-skilled jobs. It contributes to our economy enormously, and it's been an exemplar of the kind of industry that we need here in the UK. But its future is in jeopardy, as has been shown so clearly through the decisions of recent weeks. So can the Secretary of State commit now to taking no deal off the table, agreeing a customs union deal and working with manufacturers and unions to support the transition in the market before it's too late? Can he offer Honda any incentives or reassurance that their investment here would be secure? He did offer Nissan a sweetheart deal after all. Or is he happy to let yet another industry and the communities who rely upon it fall by the wayside on the Conservatives' watch?
Thank you, Mr. Speaker. For over 30 years, Japanese companies investing in our automotive sector have been able to count on a bipartisan commitment to talking of the advantages of investing in Britain, of our skills, of our commitment to innovation, of the efficiency of our operations here. And members of this House know that on both sides of the House, I and my colleagues have worked intensively, including with trade unions, to make sure that we get investments that recognise that. And I hope that we can send to companies considering investments a clear determination across all sides of the House that we will continue to keep faith with that tradition of stability here. I share, of course, I think was evident in my remarks, her dismay at the decision and the consequences for the excellent workforce in Swindon and indeed its suppliers. And we will do everything that we can to make sure that they have good opportunities in the future. She asks about Brexit. The company said the decision was not about Brexit, and clearly we must accept that. She asks about the market share that they have. It is, in truth, they have a small market share in Europe compared to the markets that they said that they are expanding in, and these were the reasons that they have given. But I've always been very clear with this House that the motor industry, Japanese investors, and Honda in particular, have been very clear for many months that Brexit is an additional worry at a difficult time. And they have been instrumental in shaping a deal that has been negotiated. And if there's one message that all of us in this House can give that they want to hear, is that the deal should be ratified. The Ford Motor Company have said a no-deal Brexit would be a catastrophe. It is important we get the agreement ratified that's on the table at the moment. Aston Martin have said that the deal, it's obvious that it meets the needs of all the requests that we put forward as an industry and as Aston Martin. McLaren have said that the withdrawal agreement would provide urgently needed certainty and the implementation period would allow us to plan for the future. Toyota has said we welcome the announcement of the deal. It would provide business with the certainty that they need. And I could go on. The clear message from the automotive companies is that we should get on and ratify this deal. Now, she asks about the industrial strategy, and she will know that the commitment that we have made to the industrial strategy, through the industrial strategy, to the future of mobility, has been at the heart of that and has been widely recognised. The £250 million worth of investment that has gone into the Faraday Challenge to make Britain the best place in the world for new battery technology has resulted in the National Battery Manufacturing Centre being established in the West Midlands. We already have the biggest selling electric vehicle in Europe, and in fact 1 in 5 of electric vehicles in Europe are made in Britain. The fact that Honda's R&D facility will continue to be in the UK, and companies like Ford are coming to move their R&D to...
I'd love to see it. Yeah, no, he's very keen to say hello. We need to go. James, you need to actually... Nick Sorry about having to rearrange these 7th and 8th. Thank you so much for that introduction. It's a real pleasure to be here speaking again to the artists formerly known as the EEF, or Make UK, as you've now become. I always look forward to coming here because I come from a family of engineers, and I look forward to meeting you, as I do many of your colleagues all around the country. I take a very close interest in manufacturing industry. It's the beating heart of our economy. For those employed in the sector, manufacturing doesn't just offer a good job that pays well, it offers creative and satisfying work. But manufacturing needs the right environment to flourish, high-quality infrastructure, a skilled workforce, and open and stable trading relations. I'm going to talk about each of these in turn, because it's clear that something has gone badly wrong. Last week's GDP figures confirmed that our manufacturing sector is mired in recession. Output has fallen for 6 consecutive months, the worst run since the financial crisis of 2008-9. No doubt, the uncertainty generated by the government's shambolic handling of Brexit has had an impact, as has weaker global demand. But it's too convenient for the Chancellor, Philip Hammond, to brandish these as excuses for his woeful economic record. The truth is, the prolonged slump in manufacturing is part of a broader story. A weak economy limping through the most feeble and protracted recovery in British history. And the blame for this lies squarely with the government. 9 years of unnecessary austerity have caused untold damage to our economy and strangled investment, leaving us with crumbling infrastructure, a productivity crisis, and, frankly, no more than anemic growth figures. This is all the more painful because there is another way of doing things. A government prepared to invest in our economy and pursue an active industrial strategy could bring about a renaissance in manufacturing. And that is what the next Labour government will do. It starts with infrastructure. Our dilapidated transport, communications and energy infrastructure is desperately in need of an upgrade. Labour will unleash a massive programme of investment with a National Transformation Fund delivering £250 billion of direct capital expenditure on infrastructure and research and development. We will ensure this investment benefits every region and nation of our country, not just London and the South East. And we will establish a National Investment Bank to make available a further £250 billion over 10 years in the form of patient capital, lent to small and medium-sized enterprises in line with the priorities of our industrial strategy. They will be providing funding for green industries and the technologies of the future. The current government's failure to invest has left us poorly equipped to deal with the profound changes that are already upon us. Where is the industrial strategy to prepare our economy for life outside the EU? What's being done to harness the benefits of automation without threatening the livelihoods of millions? How can we mobilise industry to help avert the destruction of our natural world and climate? The government doesn't have answers to these questions. Let me give you an example of the change we need. To avoid climate catastrophe, we have to reduce our net emissions to zero by 2050 at the latest. This is not going to happen by itself. It requires large-scale public investment into renewable energy and home insulation, which in turn will create new opportunities for private enterprise. This is not a burden, it's an opportunity to kickstart a green jobs revolution. Labour's plans will create at least 400,000 skilled and unionised jobs and bring about a seven-fold increase in offshore wind, double onshore wind, and triple the amount of electricity generated by solar power. And these new manufacturing and engineering jobs will bring skills and opportunity to parts of the country that have been held back by decades of neglect. As our Shadow Business Secretary, Rebecca Long-Bailey, has said, this is about the jobs at the end of the road, from the Clyde to the Humber to the Mersey. Technology and manufacturing don't have to be a threat to our environment. Our responsibility is to develop the next generation of technology that will help us to preserve our natural world and protect our resources. Labour is committed to investing on a scale that will transform our economy. These policies won huge public support at the general election only 18 months ago. So I'm disappointed that a small number of MPs decided to take a different path. But this is an agenda which unites 500,000 Labour Party members inside and outside Parliament, along with millions of people across this country. And we've been upfront in saying that in return for that investment, we will ask the largest businesses that can afford it to pay a bit more towards the common good. Because the government's corporation tax cuts have not increased investment and growth. Indeed, the Conservatives had 9 years to fix the fundamentals of our economy, but have left it weak and unprepared for the future. And just as they failed to invest in infrastructure, so too have they failed to invest in skills. I travel around the country all the time. I visit many manufacturers and other employers. And I've been struck how often they tell me about the difficulty of recruiting skilled labour, how they're dependent often on a much older workforce as they don't have young people coming into manufacturing industry, and they want them. Of course, there are organisations and companies doing good work. Make UK's own training and apprenticeship programme are absolutely excellent. I visited the training centre in Aston twice, and I've been extremely impressed by the way young people are helped to get the best start to their working lives. But as a country, we're moving in the wrong direction. University fees, the scrapping of grants, and the cuts to training have made education less accessible just when we need a highly skilled workforce more than ever. So the great legacy of the next Labour government will be to reverse this trend with the creation of a national education service that makes education freely available to everyone, whatever their age, from cradle to grave, just like the National Health Service is there for all of us. I pay tribute to our Shadow Education Secretary, Angela Rayner, who's here today, for the work she's doing to drive this forward. My old friend Tony Benn used to say that education should be like an escalator going alongside you throughout life, that you can get on and off whenever you want. What a wonderful way of putting it. So today, I'm proud to announce the appointment of our Commission for Lifelong Learning to help make the principle of lifelong learning a reality. And what is unreal is the lack of water. It's all right. It is solved. Thank you. The Commission will bring together 14 experts from across education, top names in their fields, including Make UK's very own Chief Economist, Seamus Nevin. It's co-chaired by the former Education Secretary, Estelle Morris, and the General Secretary of the Communication Workers Union, Dave Ward. And I want to thank Gordon Marsden, who's also here today, our Shadow Minister for Higher Education, Further Education and Skills. Gordon's passion for lifelong learning has been crucial in bringing these people together, and part of Angela's team is absolutely dedicated to making sure this Commission works really well and comes up with the exciting ideas that we're going to put into practice in government. The Commission's task is to devise an inclusive system of adult education to be implemented by the next Labour government that will transform the lives of millions and reskill our economy. Lifelong learning will be available to everyone, no matter of what their background, employment status or previous education is. The Commission will make detailed proposals on how to integrate qualifications, introduce a credit system to make qualifications transferable, and make it as easy as possible for people to pick up or pause their studies at times that work for them during their lives. It will break down barriers between different types of education. The opportunity to retrain at any point will help close the gap between the skills people have and the skills our economy so desperately needs for the future. We know that new industries evolve and old industries collapse. Technological advance can create great anxiety for people. So for me, the National Education Service and its commitment to lifelong learning is a form of social security. Under a Labour government, workers will never again be left feeling discarded because there will be an industrial strategy creating good, well-paid jobs and training to help workers learn new skills for the future. It makes no sense for people to be only educated for the first quarter of their life and then work for the rest of their days with outdated or insufficient qualifications. It's a waste of talent and a waste of potential. Let's give people the skills to flourish. And I strongly believe there should be a really genuine parity between vocational education and academic education. We have to end the outdated grammar school mentality of looking down on someone who does a vocational course and looking up to someone who does an academic course. I see the skills of electrical work, of computer work, of design work learned through vocational courses as just as valuable as academic courses taken at university. We need all of those skills in our society. I remember from my own school days being told by my art teacher, who frankly didn't appreciate any of my abstract painting, he said, "Corbyn, you're no good at art, go and do woodwork." And I was sent to the woodwork shop and told that this was the last resort. Woodwork was looked down on in those days. In Germany, where they really value engineering, they say, "You're a clever kid, get down to the metal workshop." So education must be designed to get the best out of everybody and available to all, delivered through colleges, universities, unions, and directly via employers. If a Labour government is going to make this big investment in skills that will have benefits for business, then we do ask something in return, that as employers, you step up to invest in your workforce too. Last week, I visited the gear manufacturing company Beard & Fitch in Harlow. Fascinating visit. Spent a long time there talking to people doing highly skilled work. And at the end of it, I met Carol, a supervisor, who is partially sighted. She was doing the final checking and polishing on the gears, and she'd been provided with everything she needed, such as big screens, to help her do her work, and she's absolutely brilliant at it. I'm very proud of the work she does. That is a sensible employer who has made an investment in somebody who is very good at their job. And is paying off for Carol, but it's also paying off for the company. As I said earlier, that as well as skilled workforces and high-quality infrastructure, manufacturing needs a stable trading relationship to thrive, which brings us on to Brexit. Earlier this month, I wrote to the Prime Minister, setting out Labour's alternative plan based around a permanent customs union with a British say in future trade deals, a strong relationship with the single market, and a full guarantee on workers' rights, consumer standards, and environmental protections. Later this week, I'm travelling to Brussels to discuss these issues with Michel Barnier and his colleagues. It's a plan we're convinced could win the support of Parliament, be negotiated with the EU and help to bring the country together. It's been widely welcomed as a way of breaking the impasse. So I call on the government and MPs across Parliament to end the Brexit uncertainty and back Labour's credible alternative plan. It's regrettable that so far the Prime Minister has instead chosen to stick with an approach that has already been rejected, refusing to move from her divisive and damaging red lines. Business investment is falling and confidence is evaporating due to the uncertainty that's been created by the government's strategy. And let's have no pretence that if the Prime Minister could only get her deal through Parliament, then certainty would be restored. The political declaration she negotiated talks of, and I quote, a spectrum of different outcomes for administrative processes as well as checks and controls. A spectrum of different outcomes. What use is that when you're making very important and significant investment decisions? If the Prime Minister is unable to adopt a sensible deal because it would split the Tories, then, in my view, there needs to be a general election. Without it, we will keep all options on the table, including the option of a public vote on our future. The country cannot be taken over the cliff edge for the sake of the unity of the Conservative Party. The government is running down the clock in an attempt to blackmail MPs with the threat of crashing out without a deal. This is extraordinarily reckless. It puts our manufacturing sector, your industries, at risk. Labour has consistently advocated a comprehensive UK-EU customs union to deliver frictionless trade and protect supply chains that stretch across the continent. I outlined this last year in a speech I made in Coventry. Disrupting these supply chains would threaten good businesses and the skilled jobs that we cannot afford to lose. Just take the car industry, for example. The decision by Nissan to pull investment from its Sunderland plant was just the thin end of the wedge. Jaguar Land Rover is said to be stockpiling parts in preparation for a no-deal Brexit, but can only prepare for days, not weeks of disruption, because the company uses 25 million separate parts a day. Ford has reportedly warned the Prime Minister that it could cease production in the UK entirely, threatening 13,000 directly employed workers and their jobs and their communities, and has said that no deal would be, quote, catastrophic for the UK's auto industry. And although not directly linked to Brexit, today we learned that Honda is planning to close its plant in Swindon at a cost of 3,500 jobs. It's being debated now in Parliament. That is devastating news for those workers, for their families, and for the local economy that has been generated largely around that plant and other new industries that have moved in following the collapse of the railway industry. It's bad news too for all the small and medium-sized businesses that make up the supply chain for these companies. And while the government is boasting it has secured a trade deal with the Faroe Islands, it's doing nothing to protect skilled jobs and industry here in Britain. Of course, concerns about a no deal and the crash that would go with it go well beyond the car industry. Take food and drink, actually the UK's largest manufacturing sector. It needs frictionless trade for perishable goods, where time is obviously of the absolute essence. On steel, half the steel we produce is exported, most of it to the EU. A disastrous no-deal Brexit would mean trade restrictions on virtually all steel companies' export markets. And while the big household names get all the media attention, it's the small and the medium-sized manufacturers who will find it most burdensome to adjust to new customs regulations. Brexit has crystallised a choice about the kind of economy we want. On the one hand, the harsh economic environment fostered by the Conservatives' low investment, low productivity, low growth, and a damaging trade deal with Donald Trump and the USA. On the other, Labour's investment-led approach, underpinned by a close relationship with our European neighbours in a rebalanced economy that no longer privileges those who lend and speculate over those who actually make things. These are very anxious times for manufacturers. But the future doesn't have to be one of decline. With a government that believes in and supports industry, manufacturing will be the engine of innovation in the green economy of the future. Infrastructure, skills, certainly that's what manufacturing needs. And that's what only Labour will deliver. Thank you very much for inviting me to your conference today.
So I think we have some time for questions. So the same as we did before, if you'd like to put your hand up and then state your name and affiliation, that'd be great. Before we do that, though, Jeremy, I'd like to thank you on behalf of the manufacturing sector and Make UK, formerly EEF, as we stand here, for our relationship. You've listened well to our concerns. It's great to see you being supported by Angela and Gordon, because skills is the #1 issue for this sector. And I think we've enjoyed and we look forward to continuing that relationship going forward. So that's great.
I thank
so
you.
Thank you very much.
I thank you for the toolbox you gave me. It's in my office. It's frequently used to make repairs.
Very, very good. Perfect. Okay. Let's start over here. I think John at the front here. We'll do one.
Mr Corbyn, you are here discussing business and the economy and Brexit. Yesterday, 7 MPs, as you said, resigned from the party, saying you are anti-business, wrong on Brexit. They also say that you tolerate anti-Semitism. What do you say to those MPs who are now saying they're considering following them out of the party, and the larger number who say that those complaints are justified?
Do you want to settle together?
Okay, let's take another one as well. Over there. There's one over there. Just take that one. We get a good balance here.
Good afternoon. John Kubra, Timberwolf UK. Mr Corbyn, I know you said it was an option, but when are you planning to invoke your conference policy and call for a second referendum?
Second referendum? 2? Want another one? One more?
Yep.
Should we do one more? One more. That one there. And that's a lady there in the centre, to make it easy for you, June.
Andrea Half, AT Engineering Solutions, based in Manchester. British engineering and manufacturing has been one of the UK's success stories of the last 100 years, employing 2.7 million people around the UK. What will Labour do to ensure that the Parliament reaches a deal before the 29th of March, so that we don't see the job losses, reduction in investment and higher prices to consumers?
Okay. Thank you. I'll do those 3 questions. The first one, thank you very much, from the BBC. I regret that 7 MPs decided they would no longer remain part of the Labour Party. I thank them for their work. I hope they recognise they were elected to Parliament on a manifesto that was based around investment in the future, was based around a more equal and fairer society, was based around social justice. And it is that programme, I believe, that we will be able to put to the electorate in the future that does have enormous support. They were elected to carry out those policies. They've decided to go somewhere else, and I regret that, because I want our party to be strong. I want our party to be united around the policies that we've put forward. On the second referendum, thank you for your question. In the Parliament a couple of weeks ago, I put down an amendment to the Prime Minister's motion from the Labour front bench, which included quite specifically the option at the end of the process of a popular vote on any deal that's reached with the European Union. I put it down in line with the policy put forward by our conference. This government is running down the clock and threatening a no-deal exit from the European Union, which I think would be very dangerous and very damaging to our economy and jobs all across the country. And we've made that very clear. That is why we did get a backbench motion through Parliament, which said no deal should be taken off the table. And I see that as an absolute necessity, that we take no deal off the table and we negotiate intelligently with the European Union as to the way forward, which is why I'm taking a delegation to Brussels on Thursday in order to put that forward. Because the worry that people have over investment, over jobs, over supply chains and over education and so many other areas is absolutely serious at the present time. This government has had now 2.5 years to negotiate and apparently has done no trade deals with anybody else and keeps on threatening no deal. We will do everything we can to prevent a no-deal Brexit. We will do everything we can to protect jobs and industries across this country and to reach out to those who want to work with us, which is why I put forward the amendment I did, and we'll be doing the same again next week, depending on what the Prime Minister brings back. And as I said, which is why I'm taking a delegation to Brussels on Thursday.
Very good. Just take another small group of questions. One over here, I think, which would be good.
Lewis Goodall, Sky News. Mr Corbyn, you've said what your message is to the MPs who have left your party, but what specifically is your message to those, that many of them, who are saying privately that unless the party changes, unless the way you operate changes, that they will follow suit and leave the party? What is your message to them, and what are you going to do and do differently in the future to keep them in?
Very good. I think we have one at the back there who's June, one at the back there that's been up for a while, which would be good. Thank you. June's keeping fit, running around with that. That's fantastic. Bit of health and well-being.
Nick Byrne, Robert Byrne and Company. I'm second generation in a family manufacturing business employing 30 people. We make a great contribution to the community. I think when I looked at it, we pay more out in tax than we pay out in dividends and take-home pay, and we're proud of doing so. But my concern is my daughters have now come into the business. They are the third generation. Will they be able to take over the business under a Labour government? Or will the concern about wealth inequalities mean that the business will need to be broken up?
Very good. And maybe one more question from this side. Let's do that over in the corner, that lady over there. Sorry, June, I'm doing the most extremes for you so you can run around the hall. There you go. Lovely. Thank you.
Sorry, you'll get a bit. Heather Stewart from The Guardian. Mr Corbyn, do you agree with your deputy, Tom Watson, that the front bench of the Labour Party needs to broaden out to better reflect the range of views in the wider Parliamentary Labour Party?
OK, thanks for the questions. First of all, the question from Sky News. We've developed our policies in the party over the past few years by working with our 500,000 members, biggest membership the Labour Party's ever had. And they are radical policies, I acknowledge. They're also very popular policies on housing, on education, on environment, on economy and industrial development. And we do our best to put all those policies forward. They are discussed frequently with parliamentary colleagues, through select committees, through interest groups within the party, and we're making huge progress. Angela and Gordon are here on the platform with me today. They've developed the National Education Service from an original idea put forward in the party and in conference, and they're bringing it to a reality and consulting very, very widely in achieving that. And so anyone who thinks they're not being consulted is not taking up, in my view, the opportunities that are available there and open and ready for them at all times to do that. And I'm always prepared to discuss policies with people in the party, and I do all the time. A colleague who asked a question about your company, well, it sounds like a very successful company, and coming from a family of engineers, I'm really pleased you've got a third generation moving into engineering. Great. I don't see any problem with that whatsoever. That's the kind of company we would want to work with. And indeed, the point I made in the speech about the need for capital support for small and medium-sized enterprises is, I believe, very important. I talk often to the Federation of Small Businesses about this. You're probably familiar with this, and I'm sure many in this room are as well, that you get to a certain size as a manufacturing enterprise, you need to borrow money for capital investment, for new machine tools, for new computer systems, for all kinds of things to develop. And they are very, very expensive. You can't get a loan to do it, you can't expand, so you end up selling up to somebody else or selling up to asset strippers who take over the land and use it for something else. We need to nurture and develop the innovative skills that are there all over the country. And indeed, it's often the small companies and almost single-handed entrepreneurs that are often the most innovative in developing new ideas. And they're the kind of people we'd want to work with these regional transformation funds that would have a local bias in how they do things. And we're already working with a lot of people all over the country through our regional economic forums and indeed town and city size economic forums on how those economies would develop. On the point raised by The Guardian, I am proud to lead the Labour Party. I'm proud of what the Labour Party has achieved. The National Health Service, the Equalities Act, the Human Rights Act, what it's achieved in so many areas of our society. And I recognise that leading the party means you've got to take people with you, and I'm determined to do that. Determined to do that so that we can, when an election comes, present those policies and that determination to the public as a whole. Our MPs, representing communities, many of whom are representing very poor communities, are the very people to carry those policies into operation. Because we cannot go on living in a country where inequality gets worse, where the numbers of people rough sleeping gets worse, and the number of people dependent on food banks gets worse. I want to live in a country that is more at ease with itself, and that does require investment. It does require a social programme to bring about those kind of changes. But above all, it also requires investment in an economy to deliver the resources to do all of that. And that's why I'm so pleased to talk to you here today, but so pleased also to visit many of your member companies all over the country and see the innovative work they're doing and the training work that they're doing. I want us to have a qualified, trained workforce. I want young people to have hope for the future, not pessimism of unemployment, of closures and redundancies. We can do it, but we have to change our ways of doing things. And we have to have a deal with the European Union that guarantees trade, guarantees investment, guarantees our rights. A no-deal Brexit would, I believe, be a very dangerous cliff edge, and I don't want to go over that cliff edge. Thank you very much.
Thank you, Jeremy, and thank you very much for your time. And we couldn't finish on a more exact note than no deal is not an option. Thank you very much.
Thank you.
Thank you very much indeed. And thank you, Gordon. Lovely to see you. And of course, thank you very much. Absolutely, well done. Great skills, #1 issue for us.
In the industrial strategy, we are determined to make sure that we are at that leading edge and can be an example to the rest of the world.
Yeah. Helen Goodman.
Thank you, Mr. Speaker. This morning, a person who owns a firm in the supply chain wrote to me. He expressed his extreme dismay about the lack of a UK-Japan trade deal. Yeah. He suggested that B's ministers talk to the 56 Japan-based firms in the northeast, and he sought a more active industrial strategy. Now, I know about the Secretary of State's Faraday initiative, but were we to have some really big infrastructure investment for electric vehicles, we might grow the domestic market, which would enable us to sell more here and leverage more exports on the basis of that.
Well, what I would say to the Honourable Lady, as my honourable friend said earlier, we are across Europe the second country in the EU in terms of the take-up of electric vehicles. And I don't think she will find anyone in the industry that doubts the commitment that my colleagues and I make to our industrial strategy of advancing that leadership. It is something that is noted not just in this country but around the world. As I said earlier, it is frustrating that the timing of this decision by Honda has not allowed it to avail itself of some of the fruits of that strategy.
John Stevenson.
Thank you, Mr. Speaker. Manufacturing represents around 20% of the Carlisle economy, twice the national figure. Many of those businesses export to Europe and to the rest of the world, but probably most importantly of all, they provide jobs, security and livelihood for thousands of people who live in my constituency. Would the Minister agree with me that we must do nothing to endanger that success? And would he further agree that he must ensure that we continue to have access to our biggest export market, as well as ensuring a domestic environment that is stable and certain?
I agree with every part of what my honourable friend said. At a time of change and challenge for the industry, that is just the time to provide that certainty and provide the commitment and indeed the enthusiasm about the future that will retain and attract investment from this country and around the world.
Jonathan Edwards.
Those arguing that this announcement is no way Brexit related are insulting the intelligence of the workers in Swindon and those in the manufacturing companies along the supply chain. And Mr. Speaker, two of those companies are based in my constituency, employing hundreds of workers. What discussions will the British Government be having with the Welsh Government, therefore, to coordinate response in terms of this announcement today?
I'm grateful to the Honourable Gentleman for his question. I think it is important to point to and to acknowledge the reasons for the decision that have been given by the company, but I've been clear that publicly the automotive sector has strongly advocated the need for supply chains to continue to be effective and uninterrupted. I work very closely with Ken Skates, my counterpart in the Welsh Government, and we will make sure that we work together to ensure that the supply chain in Wales is part of initiatives that we take.
James Cartledge.
It's a sense of deja vu for me because a few days after the meaningful vote was lost, Philips announced the closure of the Philips Avent plant in my constituency, my largest plant, and they said explicitly it wasn't to do with Brexit, moving the production to the Netherlands. The key question is surely this. We know it's bad news, whatever the cause. We've now got to get new inward investment and make ourselves competitive and attractive. Are we going to be doing that better if we trade in the future on WTO terms, or if we have a deal with the EU with tariff-free access into the largest market?
My friend puts it extremely well. In a world of competitive investment, we need to have all of the assets and the strengths at our disposal and deploy them. Internationally mobile investments are competed for by many other countries, and we have to get everything right. And it seems to me to have trading relationships that are at the bare minimum of what take place internationally is a handicap rather than an advantage.
Steve McCabe.
Mr. Speaker, an analysis of the last Labour government's car scrappage scheme revealed that it generated almost 400,000 new sales over a 12-month period at relatively modest cost. Given the twin challenges of poor air quality and a downturn in the automotive sector, why doesn't the government consider a repeat of that strategy?
Well, I know the honourable gentleman is very familiar and experienced in this area, and I understand the point that he makes. I would say that the reasons behind this decision and some others have not been so much about demand in this case, but about an acceleration of a change in technology and how that investment can be consolidated. So I'm not sure that would be the answer to the reasons that Honda have cited, but I do take into account the representation you made.
James Heapy.
Thank you very much, Mr. Speaker. The car industry is having to quickly reset as consumers turn their back on diesel and increasingly internal combustion engine cars more generally. Does the Secretary of State share my view that as we compete for those new EV production lines, one way of making the UK more attractive is to show strong domestic demand by accelerating our planned transition from ICE to electric vehicles?
Well, I do think that there is an expectation that if you want to be renowned as a source of innovation and manufacturing, then people look to the domestic market to see that products are consumed here. I think that is important. But I'm always careful to respect the fact that for some years to come, conventional vehicles will be manufactured here and would be a perfectly reasonable choice for people to make. And I think we need an orderly transition rather than an abrupt shift. That is the best for investment and confidence.
Dr. David Drew.
Thank you, Mr. Speaker. The employment base and the supply chain of Honda goes well beyond Swindon into the Stroud Valleys, which remains a major manufacturing sector. We've also had the double blow with the announcement of SKF that it intends to shut its factory in Stonehouse, with the loss of our last aerospace ball bearing manufacturer, which has a major impact on Rolls. Is it about time that the government looked at which bits of our manufacturing base we must retain in this country and come back and talk to members about how the government could do that?
What I would say to the honourable gentleman is he ought to come and talk to me about the automotive sector deal, which has brought in investment into research and development from across the industry. He talks about aerospace. There is a sector deal with the aerospace sector that again is about positioning Britain at the leading edge of new aerospace technology. These are commitments that are being made by industry as well as by government, and I'm very happy to see him, to talk him through what we are doing with the industry.
Richard Drax.
Speaker, my sympathy extends to all those who are going to lose their jobs. Can I remind the Secretary of State that we are leaving the EU, and we must be able to strike our own trade deals around the world if we are to flourish as a country, and I believe we would. So that any deal we sign with the EU that stops us or prevents us from doing that is not acceptable.
My honourable friend makes an important point. It has been clearly part of our mandate to negotiate in a way that allows us to strike free trade agreements. That is provided for in the agreement that has been put forward, and that is there, that is on the table. But what I think would be the wrong thing to do in furtherance of that is to lose our ability to trade without tariffs and without frictions with, as we might say, our existing customers.
Chris Elmore.
Thank you, Mr. Speaker. The announcements today from Honda obviously are devastating for the communities of Swindon. Just up the road in Bridgend, which neighbours my Ogmore constituency, Ford have announced voluntary redundancies. The Jaguar Land Rover contract is ending 3 months early, and there's only one Dragon engine left, which will only employ 500 people beyond 2021. So 1,700 people down to 500 will mean far more redundancies in the long term. Ford have also supposedly warned the Prime Minister that a no-deal Brexit would be a catastrophe and they would look to pull out all their production from the UK. So what more can the Minister do to, one, support the Bridgend workers, particularly the Bridgend Ford workers, and secondly, I wish him luck in trying to convince the Prime Minister that, to take a no-deal off the table, because it would be catastrophic for the car manufacturing industry in this country, including in Bridgend Ford.
Well, he mentions Bridgend, and I speak to Ford and Steve Armstrong, its VP for Europe very regularly, and he is absolutely right that they look to us to resolve this matter. Steve Armstrong says that if we leave without a deal, it would be pretty disastrous and would force us to think about what our future investment strategy for the UK would be. But what he also said is that the deal that has been negotiated would address these concerns, and I hope with his interest in the workers in Bridgend, he will come to resolve this matter by voting for this deal.
Kevin Hollinrake.
Mr. Speaker, well, this is very sad news for the workers at Swindon and for the jobs and businesses in the supply chain. But does my right friend agree this is much more to do with the EU-Japan trade deal than it is about Brexit? The reality is with free trade deals, they do create winners and losers in the short term. In the longer term, there are benefits for all with free trade.
Well, again, I think it's for the company to account for the reasons for the decision. But he's absolutely right in pointing to the fact that any new free trade agreement adjusts the pattern of trade that took place hitherto, and that is evident. It seems to me to underline the case for us to have a free trade agreement with Japan, and unless and until we do so, not to lose the ability to be part of the EU deal.
Ian C. Lucas.
Thank you, Mr. Speaker. The Secretary of State makes this case very well in response to this devastating news, and my real condolences go to Swindon, which I visited as the automotive minister. But isn't the central problem that hasn't it been displayed by the exchanges of the Secretary of State with some of the members opposite, namely that the deal that the Prime Minister is currently putting forward is an interim deal which actually defers this big question of whether we have frictionless access or whether there's this freedom to make trade agreements. And it's getting towards high noon here, and I've got a lot of respect for the Secretary of State. The position is that there is a natural majority in this House to do the sensible thing. And we need to have people like him being statesmanlike and taking the right decision on behalf of the country. And that is to reach a permanent deal as far as our arrangements with the EU are concerned, and to sort this situation out. And I plead with him as a former minister in this sector, for which I have a great deal of affection, to do that.
I'm grateful to the Honourable Gentleman for his kind words, and he embodies the spirit of continuity in understanding and support for the sector that I said right at the beginning of my statement, and that is very important for investors. What I would say in response to the future partnership agreement, it was in fairness the EU that maintained that those discussions could only take place after we've left the European Union, and that is part of their negotiating mandate. That's why it hasn't been possible to agree the final state. But it is the case, and I have worked hard to convey the requirements of manufacturing industry, that within those negotiations, the opportunity to have frictionless trading arrangements should be there and are noted, and it's one of the reasons why firms and sectors support the deal.
Mr. Marcus Jones.
This is a very sad day for the people whose livelihoods depend on the Swindon plant. This is a global industry undergoing a massive change, with the challenge that car sales volumes are falling quite significantly in many markets. Already hearing what my right honourable friend has said about Brexit and going forward in that sense, can he say what more can be done to help British manufacturing companies and manufacturing companies from other countries that are based here to get through this transitional period and the turbulence that is undoubtedly there, so that these companies can come through that period stronger and world leading in many of the new technologies?
What I say to my honourable friend is that they want the uncertainty to be brought to an end. That is their prime requirement. It is in the gift of this House to meet that requirement, and I think it is not something that we can and should leave a moment longer, we have the opportunity during the days ahead to conclude this. That is the best thing that this House could do for this and other sectors of the economy.
Mr. Philip Hollowbone.
May I applaud the response of the two local honourable members for Swindon, but also the Business Secretary for his swift plans to go to Swindon and establish this task force. But can I criticise him for not being clear enough that this is not a Brexit-related issue? Had we voted to stay in the European Union in June 2016, the chances are the Business Secretary would be here today at that dispatch box making a statement about the closure of the Honda plant. And we know this because Honda are closing their car factory in Turkey, which is a member of the Customs Union. And we know this because the chief European officer of Honda has said on the radio today, and I quote, "This is not a Brexit-related issue for us." So can the Business Secretary make it absolutely clear that we'll offer every support to the Honda workers, but this closure announcement today is nothing to do with Brexit?
Well, I'm grateful to my honourable friend for giving me the chance to say on the record that, of course, we totally respect the reasons that they have given. And this is a sector, I think, in fairness, he will agree that I've made clear is undergoing a big change, not least in technology. But I have to report to him and to the House the countless conversations that I have with virtually every firm in the automotive sector, large and small, who say that the uncertainty is something that is a negative factor in their investment decision making, and that in terms of our future relationship, they want that to be without frictions, without tariffs, and without rules of origin checks. That is sufficiently consistent that I think in a statement about the automotive sector, it is fair to bring that to the attention of the House.
Mark Pawsey.
Thank you, Mr. Speaker. A year ago, the Bay Select Committee visited the Honda plant at Swindon, and we saw Civics coming off the line, many destined for the European market, and we saw the benefits of the very substantial overseas investment that's taken place in our auto industry, some of which has been to the benefit of my constituency through the London Electric Vehicle Company, and the investment which reached in its peak year of 2013 £588 million. Are there any decisions that the Secretary of State would suggest this House might take in the next few days which would encourage future investment to get back to those kind of levels?
I would indeed. The context of technological change is something that is common to the motor industry around the world. But as I hope have been clear, we have the opportunity to be a beneficiary of that change. And because we can't be complacent at how competitive the sector is around the world, we must do everything we can to give confidence to investors. And that certainly involves, over the next few days, agreeing a deal that then can unleash, I think, the optimism that comes from investment up and down the country that I know in many instances, is not taking place while people contemplate what our future trading relationship will be.
Jeremy Lefroy.
Thank you very much, Mr. Speaker. My thoughts are very much with the workers whose excellent work I saw on a visit to the Swindon plant with the IPT last year, and indeed with those at Bridgend and elsewhere. My first job after graduation was as a foreman in Ford in Bridgend, and that is why we must not have no deal. Mr. Speaker, Honda's relationship with the UK car industry goes well before the plant at Swindon. Indeed, the tie-up with British Leyland and with Rover Group, while it was still nationalised. And I think I would urge my right honourable friend to remember that history and to engage with Honda to see in what other innovative ways we can engage with Honda for the benefit of the workers at Swindon and elsewhere, just as they did with Michael Edwards and British Leyland in those days when they brought forward the new models for Rover.
Well, my honourable friend makes an excellent point, drawing on experience that I wasn't aware of, but clearly was important for him. He is right that the relationship that this country has had with Honda has been a mutually successful one, lasting many years, and we should respect the contribution that it has made to the British economy during that time. The fact that they will continue to have their European headquarters here, will continue to have their Formula One team based in Milton Keynes, just outside, and that they will continue to do research and development there, I hope, as I said in my statement, might give us the opportunity that in the months ahead, when they're contemplating new investments, they will think first of a place that has served them and the workforce well during a very long period of time.
Thank you. Order. Statement the Financial Secretary to the Treasury and Paymaster General, Minister Mel Stride.
Thank you, Mr. Speaker. With your permission, I would like to make a statement on making tax digital for business. Mr. Speaker, it has never been more important for businesses to be able to seize the opportunities that digital technology offers. Making tax digital helps them to do just that, and I am pleased to update the House today on HMRC's progress in delivering this important modernisation of the UK tax system. Businesses who are registered for VAT and whose taxable turnover exceeds the VAT registration threshold of £85,000 will be required to use digital tools to keep their business records and to file their VAT returns for periods from the 1st of April. It is important, Mr. Speaker, to be clear that MTD is not changing what businesses do for VAT. The frequency of reporting and tax rules remain unchanged. MTD is rather about making it easier for businesses to get their tax right by transforming how businesses keep their records and send their information to HMRC. Under the changes, those who do not already keep their records digitally will be required to start doing so, but the process of then sending returns to HMRC will become more straightforward, with their VAT returns generated and sent direct from the software they are using to keep their records. In my last update to the House in July 2017, I announced that I was slowing the pace of the rollout of MTD to give businesses, particularly small businesses, more time to prepare. I set out then, Mr. Speaker, that the start date for MTD would be April 2019, limited to VAT at that time, and that the smallest VAT-registered businesses would not initially be required to use it. The extra time that these changes provided has been well spent. The pilot for the MTD VAT service has been running successfully since April 2018 and was opened up to the public in October. And I can announce today that there are now over 16,500 businesses signed up to the service, and I would encourage all those businesses who will be mandated to use MTD from April to sign up now and get used to the new service. Businesses such as the oldest family business in Britain, R.J. Bulson and Son, a butcher's based in Bridport, Dorset, established in 1515, just 6 years into the reign of Henry VIII, are already making the switch from keeping paper records and, prior to that, Mr. Speaker, no doubt records on parchment. The benefits to those who are moving to MTD are clear. It gives businesses more control over their finances, allowing them to spend their time focusing on innovation, growth and the creation of jobs. Indeed, the Enterprise Research Centre in 2018 found that for micro-businesses, web-based accounting software delivered productivity increases of 11.8%. In a world, Mr. Speaker, where businesses are already banking, paying bills and shopping online, it is important that the tax system keeps pace. But MTD isn't just about providing a modern digital service for these businesses, it's also about helping them get their tax right. We know that keeping records on paper and submitting VAT returns to HMRC manually results in errors. In a recent YouGov poll, 61% of businesses said they had previously lost receipts, and errors can also occur in the manual transposition of data or manual calculations. £9.2 billion of the UK tax gap is attributable to errors just like these. MTD will be a step change in addressing this, closing the tax gap by around £1.2 billion to 2023-24. The service builds on the way many UK businesses are already operating, as they have already seen the benefits that digitising will bring. And starting a business and taking control of its future will now be easier than ever. Mr. Speaker, some have questioned HMRC's decision not to produce its own software for businesses, but I make no apology for overseeing the development of a diverse software supplier marketplace which caters to a variety of different needs, making sure that businesses have the tools they need to succeed. Software developers have responded positively by producing software at a range of price points, including free products and offering different levels of functionality. This includes bridging software for those who want to continue to use spreadsheets for record keeping, as well as fully integrated accounting software that provides additional functionality to help users better understand and plan for their business. Mr. Speaker, there are already over 160 software products listed on HMRC's Software Choices page as part of the MTD VAT pilot, and I am aware of many others currently in development. Our approach to the provision of software means that businesses will be able to choose a product that suits both their budget and their needs. This includes some products that have been developed specifically to support different types of sector, such as specialist products for farmers. But, Mr. Speaker, it's not just HMRC and the software industry who are getting ready. HMRC's latest research, which I can now share with the House, shows that in December 2018, 81% of the mandated population were aware of MTD, and 83% of those had started to make the necessary preparations. And HMRC will have written directly to every business who is mandated to join MTD by the end of this month to signpost them to the help and support that they need to prepare. Now that the January self-assessment peak is over and HMRC is expanding its communications activity, we are confident that awareness and take-up will increase still further. HMRC wants to ensure that MTD lands well and that customers feel supported throughout their transition. The first stagger of businesses that file quarterly will not need to submit their first VAT return through the new service until August of this year. We will continue to listen to our customers to ensure the right support is available to businesses as they become familiar with the new requirements of MTD. And I want to be clear, Mr. Speaker, that during the first year of mandation, penalties will not be issued for late filing, only for late payment. There will, of course, be a process to claim an exemption from MTD on the basis of digital exclusion due to factors such as disability, access to broadband, or indeed on religious grounds. Any business that is already exempt from online filing for VAT will remain so under MTD without having to reapply. I know some have questioned the timings of these changes, in particular, Mr. Speaker, the proximity to the date the UK is leaving the European Union. But let me reassure the House that MTD is designed to enable businesses to meet their UK tax obligations as simply as possible, regardless of the outcome of EU exit discussions, and to complement our business tax obligations. We will continue to work closely with the software industry and business over the coming weeks to ensure that exactly this happens. Mr. Speaker, HMRC have made good progress in preparing for MTD. The pilots have progressed well, and the full functionality of MTD has been tested with a wide range of different businesses, including some below the VAT threshold, who have chosen to take part voluntarily. HMRC are ready, the software market is ready, and hundreds more businesses are getting ready every day by joining the pilot. MTD will help unlock the potential of UK businesses, putting them on a stronger footing to compete internationally, maximising productivity and simplifying business processes. And I commend this statement to the House.
Peter Dowd.
Thank you, Mr. Speaker. I'd like to thank the Financial Secretary for the advance copy and his reference to Henry VIII. The government are obsessed with Henry VIII, I've got to say, and all the powers that they are using in that regard. As recognised, Mr. Speaker, by the Federation of Small Businesses, we have consistently called on the government to rethink their making tax digital policy. Not least, the manifesto commits us, our Labour manifesto commits us to scrapping quarterly reporting for companies under the VAT threshold. Therefore, the opposition's concern in this regard are well versed. We've raised them during numerous debates in relation to numerous pieces of legislation, announcements, delays and indeed U-turns. And unfortunately, we are here again today addressing the government's absolute failure in its handling of the digital transition, a failure that has serious consequences for businesses up and down the country. Because, to be clear, we fully support digitalised tax reporting, which we can all agree has the potential to drastically reduce the amount of time individuals and businesses owners will have to spend filling out long and complicated tax returns, and the productivity gains that they bring that the Financial Secretary referred to. If handled correctly, it could change the way people report taxation positively for decades to come. However, Mr. Speaker, it has to be done properly. And yet, the stakeholders to whom we have spoken in the business sector and the tax community continue to raise deep concerns about their ability to be ready for digital reporting of VAT. And they've expressed these concerns to the Treasury Select Committee as well. Owners of small and medium-sized businesses are already worried about the stark changes that they are faced with making in 2019 to prepare for Brexit. They're concerned about the possibility of a no-deal scenario and the overnight effect that would have on costs and supply chains. There is also the potential introduction of tariffs and, of course, the impact on staff who are EU citizens. And the government have continuously failed to provide the certainty needed, so it's little wonder that business confidence is pretty low. What is more, few people inside or outside the government believe that HMRC is actually ready. To the best of my knowledge, HMRC has the same problems as many of the business that will be required to begin digital reporting in 2019. Those concerns are echoed by tax professionals who emphasise that the current timetable is unrealistic and unworkable for HMRC and the business community. And that's why the opposition proposed delaying digital reporting for VAT and income tax to the end of the Parliament in 2022, assuming it actually goes that long. Such a delay to report digital reporting will give HMRC and small and medium-sized businesses the time they need to prepare adequately and to properly implement new software in their businesses. Indeed, the government, despite the announcements today, current timetable risks bringing with it chaos and confusion unless the concerns of the business community are fully addressed. As such, I would appreciate if the Minister could provide clarity today as following. Are there any further costs anticipated as a result of today's announcement? Is the delay on implementing Making Tax Digital in any way connected to the so-called estate transformation or downsizing of HMRC, which has seen 170 regional offices merged into 13 regional centres? Isn't there a need for in-house provision of Making Tax Digital software, given the bespoke nature of HMRC's UK-specific needs and the needs to coordinate with other departments? Under what legal authority or process are HMRC outsourced provision of Making Tax Digital software? Mr. Speaker, 0.5% of eligible businesses have signed up. That's 1 in 200 companies. At this rate, is the Minister satisfied, confident that all those businesses will be signed up by the end of Parliament? The Financial Secretary says he wants to listen to business, but I'm afraid he isn't listening hard enough. And the rosy picture he paints isn't quite as rosy as he thinks, and you only have to ask businesses.
Financial Secretary and Paymaster General.
Thank you. Mr. Speaker, and I thank the honourable gentleman, the Shadow Chief Secretary to the Treasury, for his response to my statement. And can I welcome the fact that he, as I do, recognises the value in the approach to digital processing of tax returns, and he made indeed a specific and welcome reference to the productivity advantages of that. He refers to what I think he suggested were serious failings in our approach, and that we were not taking the right approach to these matters, and I couldn't disagree more. Mr. Speaker, indeed, I have been at pains to set out in my statement the very proportionate and measured way in which we have approached these matters. I referred to the fact that I took a decision when I first became Financial Secretary to the Treasury to delay the rollout of MTD, such that it only related to those VAT-registered businesses by 2019, and carved out the very smallest of those VAT-registered businesses and individuals from these measures, and indeed gave reassurances to the House and to the business community that when it came to income tax and corporation tax, nothing will be brought in any earlier than 2020, and that we would see how the rollout of the VAT MTD occurred before we took any further decisions in that respect. But the honourable gentleman raised several very specific questions, which I will address in turn, Mr. Speaker. The honourable gentleman asked, will there be any additional costs as a result of today's announcements to those businesses that are in scope of MTD, and the answer to that is most certainly not. He may be familiar with the estimates that have already been produced that suggest that on average a business in the United Kingdom that is in scope of these measures will face additional costs of some 60 pence per day, and that doesn't take into account the efficiency gains that can be expected, or indeed the fact that in many cases those costs will be able to be written off against taxation. He made reference to the estate transformation work that's continuing at the moment, and whether there was any link between this and making tax digital. Well, I think there is, in the sense that we have a clear drive to make sure that HMRC is a lean and efficient organisation, is itself in the 21st century, is not scattered across the country in numerous offices, some of them employing fewer than 10 employees within them, but actually in state-of-the-art hubs where digital and IT approaches can be maximised. The honourable gentleman also asked about whether we had considered, or I think he might have been urging us, to develop in-house software for MTD, and I know that it is a passion of the party opposite to centralise and have monolithic organisations that do all the organising at the centre. But that's not the way of this side of the House, Mr. Speaker. We believe that the market generally knows best, and that is why I'm delighted to have been able to announce that we have no less than 160 different competing products, and this number is growing by the month. He also asked whether I was confident, or the government was confident, that we would be signing up the right number of companies in time. And I'd make a few important points here. One is that there is no cliff edge, Mr. Speaker, on the 1st of April. That is the date at which companies and individuals will be required to keep digital records. But of course, for most companies, the first time that they will actually have to submit a VAT return under MTD for the first tranche will be around the 6th of August, and for subsequent tranches it will be in the months following that date. So there is plenty of time for companies to sign up and get involved. And the second thing is, I already elaborated, we will be taking a proportionate and light touch approach to penalties, working with companies and working with businesses to make sure that MTD rollout is a success.
And Nicky Morgan.
Thank you very much indeed, Mr. Speaker. I think we can all agree that obviously digitisation of tax is to be welcome, and companies paying the correct amounts and the tax gap being reduced. But I want to pick up where the Financial Secretary left off, which is what happens for smaller companies if this goes wrong, or if there are errors they make in their filings. The shadow front bench is correct in the sense that many businesses are very unconvinced by this rollout, and many business organisations. The Financial Secretary said in his statement that penalties will not be issued for late filing in the first year, only for late payment. But of course there are many businesses for whom actually payment is all very well to give HMRC the money, but getting it out of HMRC and getting HMRC to deal with queries can be very, very difficult. So I think overall a system of generous forbearance, if the Financial Secretary wants to continue with this system, would be very welcome. Does he agree?
Mr. Speaker, can I thank my right honourable friend for her questions, and also for the work that I know that she and her committee have focused on this important matter, and reassure her indeed that we have no intention of being heavy-handed in any way in terms of those businesses that might not quite be ready through perhaps no fault of their own, or not being used to the new requirements. But I think there's a very important point here, Mr. Speaker, which is that some 98% of businesses, and that includes small and medium-sized enterprises to which my right honourable friend refers, are already filing their VAT on a digital basis at the moment. But I can reassure her that I will make sure, as the Minister responsible, that we take a proportionate and light touch approach to the penalty regime in this matter.
Kirsty Blackman.
Very much, Mr. Speaker. There's a lot going on in HMRC just now with making tax digital, with all of the incredible number of additional staff that are being put in to deal with Brexit, and with the downsizing and the changing of HMRC offices. It's actually interesting to see the Minister say that he's not in favour of centralisation in relation to providing software, but he is in favour of centralisation in relation to closing all of the offices so that there are only super offices and not local ones. In terms of the information that's been provided from HMRC to taxpayers, they've not yet provided the most basic of information that taxpayers will require in order to take part in making tax digital. They have some have received a letter telling them of the start date, an overly complicated and fairly cursory letter, but they've not received information about the specific queries that they have about how to sign up to making tax digital and how it will work for them. So it would be useful for the Minister to provide more information around what HMRC are doing on that. In relation to the numbers, he mentioned the 81% figure. I think it's a pretty damning indictment that only 81% of businesses who were expected to be signed up by April are aware of it. The HMRC and the government should be doing a better job at making sure that these businesses are aware of it, because 19% of them are not aware, and actually there's a significant number of businesses that are hearing about this potentially for the first time today. In relation to the software providers, because there's no kind of one approved software provider or no one that is recommended by HMRC, I'm actually concerned that 160 is quite a baffling array of software choices that businesses will have to make, with no idea of which of these software choices will work, which of these software choices will work well, and which of these software choices will suit their business. I don't think it's helpful to have that many. In terms of the penalties on businesses, can the Minister confirm, I understand that when businesses sign up to making tax digital, their previous records are transferred from the old system onto the new system and are lost from the old system. Can the Minister confirm that those businesses that hold out later than April, but before their filing date, will not be penalised for holding out in order to make sure that they can see that the system is working properly and make appropriate software choices before they make that switch and potentially lose all of their old records? And just in relation to the Brexit staff and the changes that HMRC has been making to focus on Brexit, can the Minister confirm how much resource has been put into making tax digital and communicating this to taxpayers compared to how much resource has been put into Brexit and preparing for Brexit? Because if significantly more has been put into Brexit just now, is it really the right time to be trying to make changes around making tax digital when in fact there's potentially not enough HMRC resource to go around, never mind enough resource within businesses to try and deal with both these things coming down the line at once?
Well, Mr. Speaker, can I thank the Honourable Lady for her various questions, and just to deal with them in turn. Firstly, the matter of awareness to which she refers, the 81%. We would expect that figure to rise through time quite strongly, not least because of our communications programme. We will be writing by the end of this month to the 1.2 million businesses and individuals in scope of this measure. We, of course, have our VAT helpline where there are queries, and there's a huge amount of information available also on .gov.uk. The Honourable Lady made, I think, the very pertinent and perfectly reasonable point about how businesses and individuals will navigate their way around the various software suppliers that there are on the 160 different products. That is something where, firstly, all that information is available on .gov.uk, but secondly, we will be shortly releasing further information which will actually allow those businesses to put in their requirements and then reduce that number of products to a subset that is particularly relevant to their needs. And also the Honourable Lady, Mr. Speaker, asked a question about a comparison between the resources put into MTD and making our preparations for Brexit, which of course I think probably begs several other questions as to what aspects of our preparation for Brexit she wishes to make for that particular comparison. And if she would like to speak to me afterwards, I'll be very happy to discuss that with her in further detail.
Sir John Redwood.
Is there a short and comprehensible guide for any small business in my constituency that is worried about this but has been concentrating on serving their customers, because it isn't necessarily their first priority to get alongside all this? They now know they've got to do it. They need something short and simple so that they don't have to waste too much time just fiddling around with how they comply with the tax authorities.
The short answer, Mr. Speaker, is yes. It can be found on .gov.uk, and indeed we have also produced a partnership pack for intermediaries which sets out in very clear language exactly what is involved and what will be expected of those businesses and individuals.
Mr. Chairman.
Speaker, I don't know if the Minister is familiar with young children's literature, but Roger Hargreaves is a very popular choice, and he's the Mr. Man inventor. And, you know, I'm not accusing the Minister of being Mr. Tickle or Mr. Silly, but a bit this morning, Mr. Smug. The fact of the matter is, small and medium enterprises in this country, in my constituency, have been knocked sideways by the changes in the training levy and how they get their people skilled and trained. They haven't digested that yet. Now we have another onslaught in digitalisation. And is he aware that many of my constituents are going to be forced into the hands of professional people, so-called professional people who are accountants, will charge them a great deal of money to do this process for them?
Well, Mr. Speaker, I'm indeed familiar with the work of Roger Hargreaves, and I'm not sure whether he has a Mr. Cautious or a Mr. Sensible, but I think they would be more appropriate than Mr. Tickle or Mr. Silly, I have to say. But in answer to his question, in terms of navigating around the various options here, we are providing very clear guidance that is very easy to follow. 98% of those businesses and individuals impacted are already digitally filing their VAT return, and of those software products available, there is, for example, bridging software, which allows companies to continue to make use of spreadsheets, use the bridging software, some of which is free, in order to make their submission to HMRC.
Craig Tracy.
Can I welcome this statement? And one of the barriers to encouraging, to creating a coherent strategy to encourage more female entrepreneurs is a lack of gender disaggregated data to enable us not to understand not just how many there are, but also what sectors they're in. Would my right honourable friend agree that this platform provides a potential way to resolve this?
Mr. Speaker, can I firstly thank my honourable friend for all the good work that he does through the APPG in terms of promoting women in the world of work, and of course this government is presided over a government in which we have almost a record number of women active in the workplace. I know that his APPG is shortly to produce a report on the point that he has raised. I will look at that very carefully and see if there is something that might be done, mindful, however, of the important point that many other members are making, that we don't want to overcomplicate or clutter up forms seeking additional information. But I will very carefully look at the recommendations that he makes.
Christine Jardine.
Thank you very much, Mr. Speaker. On the one hand, the Minister says he wants to simplify and digitise the tax system, but on the other hand, exporters have been threatened with masses of red tape when the government is refusing to rule out a no-deal Brexit. So why are we rushing this through at this point where companies are already facing such flux and uncertainty because of government policy?
Well, Mr. Speaker, I think probably Brexit and our preparations for that are slightly outside the context or the scope of this particular statement. But I can reassure the Honourable Lady that every step that has been taken in terms of preparing for this, indeed having delayed the rollout of MTD to make sure we can prepare, so that we make sure that all those companies and individuals, the 1.2 million of them, are in the best possible position to go forward with something which actually will be a help to their own productivity in the future.
John Howell.
Thank you, Mr. Speaker. One of the problem areas that comes out of my own constituency is in the farming industry, which seems to be having enormous problems with this. He mentioned this in his statement, but what specifically is he doing to help the farming industry?
Well, I thank my honourable friend for that question. He's right. In my statement, I made reference to the fact that there will be some very specific, or is some specific, software available for those in the farming sector. There is also advice which is very relevant to farming on .gov.uk. But if there are any further specific points that he would like to raise with me in the context of his farmers, then of course I'd be very happy to discuss those.
Ian C. Lucas.
Mr. Speaker, the HMRC command economy in Wales requires all HMRC workers to work in Cardiff city centre. Can I invite the Financial Secretary to get out more and to go to places like Wrexham, where 380 skilled workers in HMRC are being forced either to go to Cardiff city centre or to work in England? We have a vibrant digital sector. We have businesses who are very anxious to support the local economy. And why is it that the government is so intent on focusing centralisation on communities. And shouldn't towns in this country have any stake in the digital sector?
Minister. Well, Mr. Speaker, I think the honourable gentleman's question relates almost exclusively to the HMRC transformation programme as opposed to MTD, but perhaps with your indulgence, Mr. Speaker, I could reply to the specific points you make. What matters is that we have an HMRC that is ready and right for the 21st century, that is sophisticated enough in terms of its digital offering, that it has the skills resident in the centres that we have to run a 21st century tax system. He refers to me getting out a bit more. I'm going to have great pleasure, Mr. Speaker, in visiting Bristol within the next fortnight to be part there of the opening ceremony of the very important office that we'll be bringing on stream in that part of the world.
Sir David Evanet.
Thank you, Mr. Speaker. Can I welcome my right honourable friend's statement today, and especially his determination to make it easier for individuals and businesses to get their tax right with MTD. I'm also pleased that he was sympathetic to small businesses, particularly initially, but can he confirm that the government remains absolutely determined to tackle tax avoidance, tax evasion and non-compliance?
Well, I thank my right honourable friend and gallant friend indeed for the question that he has posed. He has my reassurance that we will most definitely continue to focus on avoidance, evasion and non-compliance. We have brought in and protected a total of £200 billion since 2010, and these measures, indeed, by 2023-24, Mr. Speaker, will protect and bring in a further £1.2 billion. And let's remember, Mr. Speaker, we bring in this tax for a purpose, which is to support our vital public services, including the record amount that we will be spending on our National Health Service.
Jim Shannon.
Thank you, Mr. Speaker. I welcome very much the efforts by the HMRC to making tax digital through the pilot schemes, and the take-up is quite significant. However, there is a shortfall, as the Minister has referred to in his statement, of approximately 25%. Some businesses are not au fait with technology and find the process laborious. So does the Minister agree that there is a need for a concerted campaign to handhold the remaining customers, in particular the farming sector, through the MTD? Would the Minister commit to doing just that?
Minister.
Well, Mr. Speaker, the honourable gentleman raises an extremely important point about our communications programme, and as I've already set out, we will be writing to every one of those 1.2 million businesses and individuals who are in scope of MTD by the end of this month, and that comes on the back of a huge amount of engagement that there has already been. We are holding webinars. There are 2 webinars on MTD, in fact, happening, I believe, this afternoon. Certainly one. I think there may be a second as well. For those who are genuinely absolutely digitally excluded, then we have a pilot to make sure that we're able to accommodate those. And those 5,000 businesses and individuals who are currently digitally excluded for digital filing of VAT will automatically be excluded from having to enter into MTD.
Matt Warman.
Mr. Speaker, the Minister knows that I'm one of those who would urge him to make tax digital faster because the costs the benefits so clearly outweigh the disadvantages. So can I say to him that we should no more seek to limit the number of software providers in this country than we should seek to limit the number of accountants? So can he assure me that HMRC is doing everything it can to encourage more of them so we can provide unique and bespoke software for the many different sectors that power our economy?
So thank my honourable friend for that important point. We are encouraging businesses to engage the software community. They've been part of our engagement more generally with stakeholders over a number of months on that basis. There are new software products coming to the market all the time, and as I've said before, Mr. Speaker, we have no less than 160 different products already available.
Opposition.
Ben Lake.
Mr. Speaker, it's good to see that the government recognises that accessing adequate broadband remains a challenge to many businesses, especially those in more rural areas. Could I ask the Minister to elaborate further on the exemption that will be introduced to reflect this, and how it might apply to areas such as Ceredigion, where 9% of lines receive speeds slower than 2 megabits per second?
Well, Mr. Speaker, certainly the standard speed of 2 megabits per second, or 2 meg, is perfectly adequate in order to run the kind of software that we are looking at here. I have touched on the issue of digital exclusion. So for businesses who really cannot find appropriate broadband speeds, or indeed are extremely isolated, or indeed are already exempt as one of the 5,000 businesses and individuals who are not required to submit digital VAT returns currently. We will make sure that those companies and individuals are still excluded, and we will look at every single case very carefully and on its merits.
Forward.
Thank you, Mr. Speaker. My constituent is like many self-employed service providers. He collects VAT from his clients, does his VAT return himself and inputs the figures directly into the HMRC website. Now he's going to need to use a software system to upload that data, and I'm delighted to hear that there's 160 different providers, some of which are free. But when you go on the HMRC website, it's not clear which of those are free, and my constituent's been trying to find a free one suitable for a small business. So could the Minister possibly go back to the HMRC and get a little bit more clarity on your own website on which offers are free and which are best for small self-employed entrepreneurs?
Thank the Honourable lady for her question. I will certainly look into the specific matter she has raised.
Nick Smith.
Thank you, Mr. Speaker. And following on from that last question, a KPMG survey of this month reports that 64% of businesses say making tax digital is a good idea, but they need more support. Unsurprisingly, the British Chamber of Commerce have called for a delay until 2020. Don't they make a good point?
Well, I think the important point that has been consistently made to me is that we need a measured and proportionate approach to the rollout of MTD, which is why, as I've said earlier, Mr. Speaker, I took an early decision to delay the rollout of MTD, to restrict it just to VAT, and to restrict it within that to only the larger VAT-registered VAT-registered businesses. We are investing a huge amount now in the rollout and the information that's going out around that, including writing to 1.2 million companies and businesses by the end of this month, the webinars, the VAT helpline, all the information that is on .gov.uk to make sure that that runs smoothly.
John Stevenson.
Thank you, Mr. Speaker. Firstly, can I declare an interest, as I am a member of a business that submits such tax returns? And can I also say that the digital system that we are in fact using has many advantages, is actually very beneficial and does create efficiency within the business? And can I also acknowledge and completely agree with the Government that it wants to streamline the process, which is undoubtedly advantageous? And can I also agree with the Minister about his comments about no penalties? However, what I would say to the Minister, I am aware of some businesses that are oblivious to this requirement, and are also some businesses that are going to struggle. Can I therefore gently suggest to him that HMRC concentrate on the larger businesses and gradually move down to the smaller businesses over time, and give them, the smaller businesses, the maximum amount of time to get themselves organised, and if need be, would he agree that the implementation period should be extended slightly, but only for smaller businesses?
Minister.
Well, my honourable friend is absolutely right to make the observation that the very smallest companies are almost by definition likely to find this change the most onerous. And I will take on board the points that he has made, and I can certainly reassure him that in all cases, but most particularly in the case of very small companies, HMRC will take a light touch approach to penalties, provided that individuals and businesses are not willfully trying to avoid or change the amount of VAT that they have due. Then we will take a very light touch and proportionate approach to those businesses.
Kevin Hollin-Rake.
Thank you, Mr. Speaker. And I'd like to draw the House's attention to my register of members' interests, my continued business interests. My right honourable friend has taken a very considerate approach in the past, both in terms of the threshold of eligibility and the pace of the rollout. Can he confirm he'll continue that considerate approach in the next phase of the rollout, but also that our default position should be to reduce rather than increase the bureaucratic burden on small businesses?
The nation will be pleased to know that the honourable gentleman is a distinguished estate agent. Minister.
Thank you. Well, that's certainly no oxymoron, Mr. Speaker, I'm sure. He is indeed a distinguished estate agent, and I thank him for his question, and he has my absolute reassurance on the point that he has raised about not bearing down on businesses with additional bureaucracy. We're there to help them and support them, but at the same time to make sure that they are more efficient and effective in their tax affairs.
Julian Sturdy.
Thank you, Mr. Speaker. I'm reassured by the Minister's response over the businesses that won't be able to access suitable broadband provision. But can I ask him what conversations he's had with the Department for Media, Culture and Sport over access to better digital broadband going forward, so that the 5,000 businesses he's mentioned that won't be able to access MTD going forward will be able to access it in the future?
Well, as with all departments, Mr. Speaker, the Treasury and all departments across Whitehall are having regular contact with DCMS around the issues of broadband rollout, given the centrality of its importance to many of the aspects of what the Treasury does, but in this instance specifically to MTD, and we will continue to have those conversations.
Thank you. Order. Point of order, Mr. Barry Sherman.
Mr. Speaker, I would ask your guidance. Some of us in this House, many of us in this House, regard parliamentary privilege as the greatest privilege, that we can say things in this House that people cannot take action against. But there is a very small minority, and I stress this, a very small minority of members who seem to more regularly use that privilege to attack either colleagues in the House and people outside. And today, on the statement on the backstop on the Northern Ireland, two members particularly went for a senior civil servant, Ollie Robbins, and said things about him, his reputation and his character that were quite indefensible. And I know both sides of the House believe that that kind of remark about senior civil servants who cannot answer back or have any recourse. Is there any way you, Mr. Speaker, could look into the way in which a very small minority of people are using parliamentary privilege in a way that it wasn't designed for?
Well, I'm very grateful to the honourable gentleman for his point of order. I would make a number of points in response to him. First, members should exercise their parliamentary privilege with due care and a sense of responsibility. Secondly, immoderate language, not merely in relation to subject matter, but more particularly in relation to people, is frankly to be deprecated, and I think that we should observe the precepts of Erskine May in the conduct of parliamentary debate. I don't recall off the top of my head whether the honourable gentleman was present in his seat when I treated earlier of this matter in response to a very timely point of order from the Right Honourable and Learned Gentleman, the member for Rushcliffe, also, of course, the Father of the House. The Father of the House similarly took exception to some of what was said. I did not myself at the time intercede, for there was not a direct breach of parliamentary protocol. There was nothing specifically disorderly about what was said, but I did think that there was an issue at the very least of taste involved, and I think I did refer to the coarsening and vulgarisation of debate, and we should take care to avoid that, more particularly in relation to what the honourable gentleman said about civil servants. Although each member must, of course, take responsibility for what he or she says in this place, we must remember that those individuals are not in a position to respond. They cannot speak for themselves with a public voice other than very specifically on behalf of their ministerial bosses. And I think many people will feel it is not appropriate to launch personal ad hominem attacks on public servants. What we say to each other is a bit different, but in relation to such career officials, great care and responsibility should be exercised. And I am sorry that there have been departures from that principle in recent times. I hope they will not be repeated. Thank you. Order. We come now to the 10-minute rule motion, and it's a pleasure to see and to call Bill Wiggin.
Thank you, Mr. Speaker. I beg to move that leave be given for me to bring in a bill to make it an offence to consume dog meat
and to transport, possess or donate dog meat for the purpose of consumption and for connected purposes. Tragically, 30 million dogs are eaten every year around the world. More than 10 million of these are killed in China alone. In the Republic of Korea, dog meat is the fourth highest consumed meat after pork, beef and chicken. Over 450 tonnes of dog meat were imported to Japan between 1997 and 2017. The dog slaughter industry is worth between 220 and 273 million US dollars. Eating dog meat has long-standing cultural significance in many East Asian countries. Many consumers believe it to have medicinal value and bring good fortune. Yet none of these alleged health benefits have any scientific basis. Instead, eating dog meat fuels an unspeakably cruel trade involving animal torture. It may seem extraordinary, but consuming dog meat is currently not illegal in the UK. Luckily, there is no evidence that dogs are eaten in the UK, yet due to the vile way in which dogs are treated in China, I would like our country to join in setting an example to the world. This is because China argue that until we make it illegal, why should they? 2 months ago, a ban on the humane consumption of dog meat was passed in the United States, following Germany, Austria, South Australia, Taiwan and Hong Kong. This bill is an opportunity for the UK government to join these countries by bringing in a ban. It is particularly important to do this as the conditions under which dogs are farmed, transported and slaughtered are deliberately cruel. It is believed that inflicting suffering raises the animal's adrenaline levels, tenderising the meat and adding medical properties. Therefore, this bill is not just about consuming dogs, but about the extra suffering and cruelty involved. The animal protection organisation, the Humane Society International, has reported the appalling conditions these dogs are subjected to. Usually forced into tiny cages, many dogs suffer broken limbs as they're transported vast distances, often without food or water. Pure sanitation, parasite infestations and disease outbreaks spread quickly in crowded conditions. For example, a study by the National Institute of Hygiene and Epidemiology of Vietnam in 2007 found that 2 out of 10 sick dogs in Hanoi slaughterhouses were rabid. Some dogs are force-fed with a tube down the throat in order to boost their weight before slaughter. Nearly half the dogs die before reaching their final destination. Injured, dehydrated and exhausted, the dogs which are alive then face unspeakably cruel deaths. Routine methods of slaughter include bludgeoning, hanging, boiling, skinning and blowtorching alive. The dogs are then consumed. The city of Yulin in China hosts an annual dog meat festival that is infamous for its inhumane slaughtering methods. These are practiced at over 100 slaughter sites throughout the city, including crowded markets in the streets and outside schools. The dogs, some of which are puppies, are tortured and killed in front of each other. During the 10-day festival, 2,000 to 5,000 dogs are killed per day. Over 230 tonnes of dog meat are consumed each year at this festival alone. And I hope the House would agree that the sheer scale, as well as the unnecessary cruelty, are truly shocking. In the UK, we spend £10 million a year on our 8.9 million pet dogs. They provide companionship, love and a part of the family for many people. Dogs are used by the police, armed forces, in therapy and, of course, as guide dogs. Our laws usually reflect the respect that dogs deserve. This bill fits with our long and proud tradition of support and insistence on the highest standards of animal welfare. As a nation of dog lovers and champions of animal protection, the UK must enact a ban on trading and consuming dog meat. If the animal cruelty was not bad enough, the human suffering cannot go unnoticed. In China, an estimated 70% of dogs slaughtered for consumption are stolen pets. Anybody whose pet has gone missing knows the worry and fear for the future of that loved pet, anguish and concern over what has happened, or simply, where is my dog? At least in the UK, we know that our missing dogs won't be eaten. In China, dog-snatching gangs are hired by butchers to supply cheap animals. Increasingly bold, these gangs are often armed with machetes and tasers. The dog meat trade normalises violence and fuels both animal and human abuse. For the sake of the tortured animals, victims of crime and exploited workers, it's vital that the UK takes steps to end this cruel industry. In 2015, the World Dog Alliance organised a petition to urge the South Korean government to act. They received over 100,000 signatures from UK citizens, and in response, the South Korean government closed the nation's biggest dog meat market ahead of the 2018 Winter Olympics. Fortunately, many countries have recognised the value of contributing to this global effort, the United States being the latest to introduce a ban. It was passed 2 months ago, even though, like here, dog meat consumption is not a problem in America. Last week, a group of US congressmen and former Senator Jeff Denham wrote directly to our Prime Minister urging the government to introduce a ban, emphasising the need for international condemnation of dog meat consumption. I am proud to have campaigned for tougher sentences for animal cruelty, and that the mistreatment of animals in the UK and across the globe has always been an important concern for our government. My honourable friend, the member for Clacton, has added an amendment to the Agriculture Bill which will enable the House to support the ban on consuming pets. The honourable member for Strangford will also debate this topic in Westminster Hall on Thursday. It's helpful that this is an issue that has support from MPs from across the House, and it's certainly one that my constituents and the wider population care deeply about. I'm sure that anyone who takes animal welfare seriously would join my colleagues and I in condemning the vile torture and slaughter of dogs. Making it an offence to consume dog meat and to transport, possess or donate dog meat for the purpose of consumption would highlight our country's commitment to outlawing the practice globally and cement the UK as a champion of animal welfare. I beg to move.
Thank you. Order. The question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
Giles Watling, Andrew Rosendale, Cheryl Gillen, David Amis, Scott Mann, Ian Little-Granger, Daniel Kivchinsky, Henry Bellingham, Damien Moore, Royston Smith, Tracy Crouch, Jim Shannon and myself.
Bill Wiggin.
The bill.
Dog meat consumption offences bill.
Second reading what day?
March.
22nd of March 2019. Thank you. Order. We come now to motion number 2 appertaining to exiting the European Union. To move the motion, I call the Industry Minister, Mr. Richard Harrington.
Mr. Speaker, thank you. And I'm normally with statutory instruments, we obviously say how honoured we are to serve in front of the chair, whoever he or she may be. This is the first time I've done one here in the chamber. So I don't know if I should say it's an honour to do it in front of you, Mr. Speaker, but if you could take it as read, you're very entitled to do so. I shall... Yes, chuntering from a sedentary position from the opposition whips, they do themselves no credit, Mr. Speaker, particularly. However... Indeed so. Indeed so. However, Mr. Speaker, I beg to move that the House consider the European Structural and Investment Fund's Common Provisions and Common Provisions Rules, brackets Amendment, brackets EU Exit Regulations 2019, which were laid before the House on the 28th of January of this year. In a no deal, this instrument will repeal the European regulations concerning the European structural funds while ensuring that they can continue operating domestically. It will also repeal the regulations for the Cohesion Fund, for which we're not eligible. Structural funds, including the European Regional Development Fund and its cross-border
European Territorial Cooperation Component and the European Social Fund. Structured funds, Mr. Speaker, structural funds are shared management funds. They support regional investment across the UK and are funded via the EU budget with co-funding provided by project participants. Typical projects include the recently launched Advanced Engineering Research Centre in Sheffield, which supports economic development and upskilling in the local economy. Typical cross-border projects under the European Territorial Cooperation component of structural funds include, for example, the Intelligent Community Energy Project on smart energy. 3 UK universities and local small businesses are working in collaboration with French research centres and SMEs to find local solutions to support local carbon energy systems. In a no-deal, Mr. Speaker, the United Kingdom is expected to lose access to European funding. To ensure this regional funding continues in a no-deal, the Government announced in 2016 that it would guarantee funding for structural fund projects signed before we leave the EU, and this was extended in July of last year to cover new projects signed after exit until the end of 2020. This guarantee covers UK beneficiaries and exceptionally all beneficiaries of the Peace Programme in Ireland and Northern Ireland, and Interreg VA in Ireland, Northern Ireland and Scotland. That's 3 countries in the Interreg VA. This is due to the Government's continued commitment to support peace and reconciliation in Ireland. Mr. Speaker, this instrument facilitates the domestic delivery of structural funds in a no-deal. It repeals the European regulations for these funds because they've become inoperable in retained European law. Therefore, they wouldn't work. It's because the European regulations create a shared management programme between the EU and a member state. Keeping them would create obligations that the managing authorities of the funds could no longer meet after a no-deal exit. The instrument also ensures that for European Regional Development Fund and European Social Fund projects started before exit, current fund delivery rules are upheld through existing fund agreements. That's through existing funding agreements, without keeping redundant EU regulations. The powers to continue paying the project beneficiaries in the UK already exist under our domestic law. So the instrument doesn't make provisions for projects started after exit. Managing authorities for the funds will nonetheless continue to sign new projects because they've got existing domestic powers and using existing delivery systems with appropriate simplifications. So the main aim is to provide stability for beneficiaries, and the project rules will continue to be enforced through the same funding agreements. Honourable members should also note that this instrument ensures that structural funds delivery remains a devolved matter. Absolute pleasure.
I'm very grateful. I'll refrain from asking his opinion on a no-deal, but in terms of structural funds, which are there primarily, in my view, to try and rebalance our economy from regional investment right across the UK, whether we're in the European Union or after it, and whatever state we're in after it, does he agree it's hugely important we spend a greater proportion of our investment in infrastructure and other economic development in the regions rather than in the capital?
Thank you, Mr. Speaker. I totally agree with everything that my honourable friend said, other than he didn't actually ask what my views were on no deal. But I think he knows those, and I hope most people in the House do.
Could you just tell us what the dispute resolution procedure is?
Well, if my right honourable friend would bear with me, I consider that later on in my remarks. I thought he was going to ask me the same question. Anyway, this instrument includes a transitional provision that enables the guarantee to be paid out to bodies involved in the European Territorial Cooperation Programme. The power to fund beneficiaries of cross-border programmes currently comes from European law and therefore needs to be continued in domestic law through this instrument to protect beneficiaries in a no-deal. This will enable the United Kingdom to continue to participate in cross-border European territorial cooperation programmes involving Northern Ireland, Ireland and Scotland. These programmes are known as PEACE. That is PEACE not in the normal way, but in PEACE, P-E-A-C-E, and Interreg VA, because they do support peace and reconciliation on the island of Ireland. The EU has made special provisions to enable the United Kingdom to continue in both peace and Interreg VA in a no-deal if the United Kingdom continues to pay for its share of these programmes. The transitional powers in this instrument enable the United Kingdom to make such payments to the EU to enable our continued participation in a no-deal, which is consistent with our general commitments to peace and Interreg VA. In this arrangement, the European regulations do not need to be retained. The United Kingdom will sign an agreement with the EU to ensure that programme beneficiaries continue to follow relevant rules. The transitional provision to pay the guarantee to European territorial cooperation beneficiaries also ensures beneficiaries of cross-border programmes other than peace and the Interreg VA can be paid sums from the guarantee. Specifically, this provision gives HM Government and the devolved administrations the appropriate powers to ensure that UK partners of such cross-border projects can receive the guarantee through domestic arrangements to safeguard for all possible no-deal scenarios. Among such scenarios, the House should note that in a no-deal, without further changes to the European Commission's regulations, UK organisations will currently be unable to continue in the majority of our European territorial cooperation programmes other than peace and Interreg VA, as they wouldn't have third country access to the programmes. The instrument is designed to enable UK partners to access funding in such a scenario. The European Union has published a no-deal regulation that would allow the UK to continue participating in UK programmes in a no-deal until December 2019, but it would agree to us agreeing to contribute to the 2019 budget as if a member state. The proposal is subsidiary and without prejudice to the EU's specific proposal on peace and Interreg VA. The Government is currently analysing the Commission's proposal, but honourable members should rest assured that this instrument will allow the guarantee for ETC to be distributed in any scenario. Well, without this statutory instrument, Speaker, delivery departments would not have the powers to pay out the guarantee to beneficiaries of the European territorial cooperation programmes. Without legislation, we would not be able to pay for its share of the peace and Interreg VA programmes involving Northern Ireland, which means that we couldn't take part in these two important programmes, and beneficiaries that are currently beneficiaries of those programmes would be at financial risk. I mentioned briefly the separate legal provision being made by the EU for the UK for us to continue in the peace and Interreg VA programmes. That's intended to enable continued access to the programmes in the event of no deal, but it doesn't resolve the problem of payment powers. That's why we need the EU regulation and the statutory instrument to safeguard these programmes and to ensure the continuation of their benefits. Not having the instrument enforced by exit. Oh, I do beg
Before he moves on from the money, can you explain how the money would be calculated, and do we have to make a contribution to the admin costs or just the actual cost of the programme?
Thank you. Mr. Speaker, if I may use this opportunity to answer your first question, not your first question, Mr. Speaker, my right honourable friend's first question about the dispute resolution. Any disputes in relation to how funding is spent are dealt with through the audit and default functions and the provisions which are set out in the existing funding agreements. And as for the second question, I will have to give that matter some thought, because I have to confess, Mr. Speaker, I don't know the answer. And I will, if I don't think of the answer in the next half an hour or so, I will certainly write to my right honourable friend with the answer for it. But my memory is quite good. Usually things come back, in the due course of time, Mr. Speaker, as I know it does with you. I mentioned the separate legal provision being made by the EU for us to continue and participate in the peace and Interreg VA programmes. That provision is intended to enable continued access to the programmes in the event of no deal, but does not resolve the problem of payment powers. That's why we need both the EU regulation and this statutory instrument to safeguard these programmes and to ensure the continuation of their benefits. Not having this instrument enforced by exit would also prevent the Government and our devolved administrations from paying out the guarantee to UK partners of other territorial cooperation programmes, risking their financial viability. Yes, indeed, of course I will.
extremely grateful to him for giving way. I don't think anyone on this side of the House objects to what the Minister is saying, and in fact I'm sure he and I would agree over the catastrophe that could be a no deal. But would he care to expand on what would happen with the Shared Prosperity Fund beyond any transition period, beyond any deal? Because at the moment we seem to not know, and it would be very helpful, because the Minister is a very honourable man, if he could give some reassurances to devolved administrations about how that Prosperity Fund would be managed and what funds would be available to regenerate communities in my constituency of Ogmore.
Minister.
Mr. Speaker, as the honourable gentleman, who is also a very honourable man for the record, would expect me to say, this is not actually within the scope of this particular statutory instrument. Now, I know, Mr. Speaker, that you don't have to rule in this case on the scope of it, but it's quite a long answer to his question, and one which I'm happy perhaps to discuss with him outside of this chamber, if that's acceptable to him. I think I got away with that one, Mr. Speaker, but I'm not sure. For now, Mr. Speaker, for now, yes. The House should note this instrument is really designed for a no-deal scenario, because in a deal, the intention is to include a provision in the Withdrawal Agreements Bill to defer commencement of these regulations until the end of the implementation period. For this reason alone, Mr. Speaker, I would urge all honourable members and right honourable members to actually vote for the EU Withdrawal Agreement Bill. This means that these regulations would come into point at that point rather than on the date of exit. In conclusion, in a no-deal, this instrument repeals redundant European law whilst ensuring that regional investment projects previously supported by the EU are protected by the funding guarantee, including those supporting peace in Northern Ireland. And for those reasons, Mr. Speaker, I commend this regulation to the House. Mr. Deputy Speaker.
Marvellous. Thank you, Minister. The question is that motion number 2, as on the order paper. Shadow Minister Chiomwara.
Thank you, Mr. Deputy Speaker, and I would like to thank the Minister for setting out the technical details of this statutory instrument so clearly. But here we are with yet another statutory instrument making provision for the regulatory framework after Brexit in the event that we crash out without a deal. The parliamentary recess has been cancelled due to the sheer volume of SIs to be dealt with before the 29th of March, and of the 442 laid since June, 269 have yet to be completed, and of the 20 business SIs passed this year, only 2 had available impact assessments. So, as many of my shadow ministerial colleagues have made clear, the volume and flow of European Union exit secondary legislation is deeply concerning for accountability and proper scrutiny. The government has assured the opposition that no policy decisions are being taken. However, establishing a regulatory framework inevitably involves, for example, matters of judgment and raises questions about resourcing and capacity. So in this light, the opposition would like to put on record our deepest concerns about the process regarding these regulations. But I would also like to start by saying, Mr. Deputy Speaker, that we will not oppose this statutory instrument, given the importance of European structural and investment funds to the United Kingdom. We recognise the necessity of ensuring that the requisite regulations are in place to allow the UK to manage this funding. But we have serious concerns, Mr. Deputy Speaker, about the scope of this SI and the complete failure of this government to take effective action to reduce regional inequality in the UK. This government has presided over the UK becoming the most regionally unequal country in the European Union. We are the second most regionally unequal country in the OECD. Only Mexico is ahead of us. We are home to the richest region in Northern Europe, London, but we also have 6 of the 10 poorest regions. In London, disposable income per household is almost 60% higher than in Wales and many regions in England. Transport spending per head is 15 times higher in London than in Yorkshire. The government has not only failed to tackle regional inequality, it has increased it. Its local government finance settlement shows a party so beholden to ideology that they will willingly deepen the crisis in our councils, councils that have been gutted by a series of government policies. Not my words, but those of the UN's Special Rapporteur on Extreme Poverty and Human Rights. Now, European structural and investment funding plays a significant role in addressing just such economic and developmental disparities between regions. And it's all the more important because of the impact of the last 10 years of Tory government. I'll happily give way.
You referred to a point I think comes from the IPPR research that the spending in Yorkshire is 15 times lower than in London. I think that's what she said, but on transport. But those figures are actually inaccurate. The contribution from central government is kind of pretty much on a par on a per capita basis. The difference being when you add in local authority spending on transport infrastructure and private sector investment, it is still about 3 to 1 and still there's too great a differential. But it's important we look at the figures in the round and factually rather than some of the kind of headline figures that we sometimes hear. Sorry, Mr Deputy Speaker. Very important point.
I'd like to thank the Honourable Gentleman for his intervention, and it is absolutely important that we look at the background, if you like, to the statistics that we use. But I can say to the Honourable Gentleman very clearly that, for example, the statistics used by Transport for the North and other reputable bodies show consistently higher per head spending in London than in our regions, including his and my own. So the ESI funding supports, in the Honourable Gentleman's region and in my own and across the country, supports our people, our businesses and our innovation. They are simply too important to leave questions about transition unanswered. Over the current 2014 to 2020 funding cycle, European structural investment funds are worth more than €19 billion to the UK, and that's €10 billion in direct investment. Wales alone, as one of the poorest regions in the UK, is receiving €2.4 billion in the current period. The impact of this funding is huge. The impact of losing it would be more so. In the last 10 years, it is estimated that the European Union investment has created more than 115,000 jobs and 25,000 businesses. In my constituency, ERDF funding supports the construction of the core, part of the Newcastle Helix, and the growth of over 800 local businesses through Supply Chain North East. Throughout the UK, European Union funding has driven growth in the low-carbon economy, particularly through investment in research and innovation. It has ensured that it is local economies that have benefited. And it's not just income that the European Union funds provide, Mr Deputy Speaker. The security guaranteed by the 7-year funding cycle of structural funds allows for economic planning in partnership across local authorities, the private and third sectors, over a longer period than our domestic funding. This security is crucial in attracting the necessary match funding from donor partners. So, Mr Deputy Speaker, this SI deals purely with projects that start before the Brexit exit day on the 29th of March and ensures that they will be able to be administered according to pre-agreed frameworks. But we need more clarity. So can the Minister tell me, does this refer to projects that have been approved before the 29th of March, or just projects that have actually started, and how is started to be defined? What have projects started after exit? How are these to be administered? Now, we have been promised that funding for all projects up to 2020 is guaranteed and that projects will continue to be signed under the same terms until 2020. What we have not been told is anything about how these projects are to be run, how decisions are to be made and how funding is to be allocated. According to this instrument, these frameworks are still to be drawn up. It states mainly that delivery framework for future projects will be based on the pre-exit framework and the same investment priorities as have been applied for existing structural fund projects. So may I ask the Minister, who will make these decisions? This is up until 2020. And how does the government intend to replace the European Union structural funding in the long term? The issue that my honourable friend raised. So the government has committed to a successor fund, the Shared Prosperity Fund, but then they also committed to a consultation on this fund by the end of 2018. In case the Minister has not noticed, it is now 2019. We are just 38 days away from the 29th of March, yet we have yet to hear a single detail about how this fund is supposed to work. So will the Minister say how the government plans to replicate the security of the 7-year EU funding period and how they intend to administer the Shared Prosperity Fund? And the Minister said that this was not within the scope of this SI, but I think it is necessary to give confidence in the ongoing funding and the decisions that the Minister is taking, that we understand that we have some strategic vision as to what will happen after Brexit. So, ESFI funding has traditionally been focused through regional and sub-regional bodies, aligned to regional priority programmes. This has provided our local areas with a strong level of direct influence and control over resources and the ability to align them with other local and regional investment, an ability which is all too often missing from central government funding. But unfortunately, because the coalition government chose to abolish regional development agencies, the current ESIF programme lost much of this local knowledge. Instead, we have a national approach with regional allocations, with leadership and administration of funds moving from regional development agencies to central government department. So despite the committed work of local enterprise partnerships and their partners working in the regions, the loss of regional control over funds has meant they are targeted less effectively and been subject to significant delay in approvals and delivery, as well as being less responsive to local needs and aspirations. So could the Minister say how he intends to make the right decisions for regions, given the lack of regional development authorities? We need clarity, we need details, and not just empty promises, because real jobs, businesses and communities are at risk. And the continued failure of this government to address regional inequality is the hallmark of a Tory party that places narrow party interest above the good of the country. Mr Deputy Speaker, the absence of any plans that deal with projects started after exit day and the deafening silence around the Shared Prosperity Fund leaves our regional economies in jeopardy. While we not oppose the statutory instrument, we want to know that this government does more to safeguard, how this government will do more to safeguard the future of our communities. Labour has committed to matching European Union funding for regional development for at least the next decade. Why won't the Minister follow suit? A Labour government would invest £250 billion in a national transformation fund to meet the infrastructural needs of every part of our country and create a network of regional development banks to ensure growth in the areas which most need it. We need a viable plan for sustainable and equitable regional development, one that reflects the needs of the region, one that empowers local people and grows local economies, one that can guarantee funding for all our communities. It is one that only a Labour government is evidently able to provide. Thank you.
Mr Deputy Speaker, it's a pleasure speaking this afternoon's debate, and I warmly welcome this SI, which, as we've heard from the Minister, preserves the effect of structural funds through to the end of the 14 to 20 period, whether we have a deal or no deal, in true Noel Edmonds style. And I very much hope there will be a deal. And I underscore again today my commitment to the Brady Amendment that we voted on the 29th of January and the Malthouse Compromise, which is attached to that. But if the EU isn't disposed to be reasonable, then as a matter of law we will leave the EU with no deal, at which point it's important and right that we make sure that our law continues to operate and that important funding streams continue to be devoted to addressing the aims for which they've been set up. And of course, the EU structural funds are a very important source of funding. I have always slightly objected to the whole concept of EU largesse, which is implicit in the concept of structural funds, because of course the UK is a net contributor to the European Union. This is in effect our money being washed back through the EU institutions into our country. And of course, as we know, in a number of European nations, the EU structural funds have indeed been the substance of very, very considerable abuse over the years, which is one of the reasons which drove frustration with the EU in the first place. But nonetheless, in our country, where the money is generally well spent, there's nothing to fear. And more than that, once we've left the European Union, it will be our ability to actually ensure that this money goes to our priorities. And of course, that's where the Shared Prosperity Fund is so important. This is something which the Prime Minister spoke about a week before the 2017 general election in my constituency in Gisborough, and she outlined in that speech her very clear commitment to making sure that the substance, the amount of money that was devolved as part of the regional development funding from the EU would be matched by the UK once we've left. And that's something which we warmly welcome, because the North East is a region which has been a net beneficiary of this funding. And my goodness, there's a lot that we can be doing with it. We know that the Shared Prosperity Fund will be used to help drive the local industrial strategies which the government quite rightly wants to establish. I think this is something which is actually working very well. I'm glad that it's not emerged as a sort of continuation of the 70s policy of picking winners. Instead, it's been about empowering local devolution to make a real difference in supporting industry. And in the Tees Valley, we've got a really exciting proposition under our Mayor, Ben Houch, and he's got a real clear plan for projects like the South Tees Development Corporation on the former Redcar Steelworks, and making sure that we have serious, sustained, long-term funding in place for projects like that is absolutely essential if we're to continue to close the gap between London and the regions. And that's something which I think all of us in this House support and want to see, and which I'm confident that, thanks to not least this SI, we will continue to be able to achieve. Whether that be on transport, whether it be on jobs, whether it be on education and skills, there's a tremendous amount of work that can be done. I don't think there's anything to be afraid of from our leaving the framework of the EU and its structural funding. Instead, I think this is a classic example of how taking back control is something which can work for the benefit of the UK, and indeed for those parts of the UK which voted most heavily to leave in the 2016 referendum. It's worth noting that Teesside voted by 2/3, in some cases more, to leave. And so there was real confidence among the population there that we should indeed take control of this funding. So I'm optimistic. I'm grateful that the government's doing this. I'm grateful that there is a clear plan in place to ensure that there won't be a discontinuity on exit day, however we end up leaving the European Union. I'm grateful to the Minister, because I know that he and I take a somewhat different view on some aspects of this debate, but he has nonetheless approached it with great professionalism. He continues to deliver good, sensible legislation to make sure that, under all circumstances, our country should have nothing to fear.
Thank you, Mr. Speaker. And like the Honourable Member for Newcastle upon Tyne Central, we won't be opposing this SI this afternoon, but we do share many of our deep concerns, particularly around the UK Shared Prosperity Fund, exactly what it is, where it is and what will it mean. But of course, this SI would not be necessary at all, and this debate wouldn't be necessary if the government would just simply take the threat of a no-deal Brexit off the table. The government could, if they so choose, remove the threat of no deal today. But they have, very cynically in my opinion, decided that the threat of a no-deal Brexit is too politically useful to have as a tool in order to bludgeon MPs into supporting a deal that we have already rejected as the clock runs down to March the 29th. But if the government insists in preparing for the possibility of a catastrophic no-deal scenario, then yes, this SI does allow for the transfer of regulations in order that continuity is retained and the continued rollout of the European Agricultural Fund for Rural Development and the European Maritime Fisheries Fund will be allowed to continue. And this SI will continue to allow payments until the closure of the current 2014-2020 programming period. And I think it's worth pointing out, Mr Speaker, the huge importance of these funds to communities right across Scotland, but particularly to those remote and peripheral communities like my Argyll and Bute constituency. The EU Structural Fund in Scotland are worth up to €941 million across the EU budget period for use in economic development. Over £500 million a year comes to Scotland from the Common Agricultural Policy in the form of direct payments to farm businesses and for rural development funding. Following Brexit, short-term guarantees have been provided by the UK Government to replace most CAP funding until 2022, but no firm commitments at all have been given about replacing CAP in the long term. The Common Fisheries Policy... I will give way.
I think it's really important to note that under the terms of the Agriculture Bill, we'll be making sure that environmental incentives are aligned with good practice in terms of agricultural management, which is something I think which all parties in this House would want to see, and that would be a welcome change from the way the CAP just rewarded the largest farmers.
I thank Lord and I think he makes an important point. It's a point I'll come on to in a moment as to why we're having this SI discussed here before the Agriculture Bill has actually gone into report stage. And it's something that I'll come back to. But I think you're right. I mean, I wouldn't necessarily defend the way that the CAP is administered in every pound and where it's allocated to. But I think it's important that we recognise the amount of money and the amount of support that CAP does give to UK agriculture, but particularly those LFAS areas in my own West of Scotland constituency.
Well, he give way.
I will give way.
I thank my colleague for giving way. He's making a great speech. In terms particularly of the lack of certainty beyond 2022, is it not the case that those in farming communities are planning a long way out with what they intend to do with their ground, what they intend to do in the future, and actually certainty beyond 2022 would be helpful in them doing that long-term planning as part of their role of stewardship as well as the role of trying to make money?
I thank my friend for that, and she is absolutely right. It's absolutely vital that our farmers have the ability to plan into the future. And what we had at the moment, or what we have and enjoy at the moment, is that ability to long-term plan. And the fear is now that that long-term plan is being taken from them. I think also that the Common Fisheries Policy is co-financed in Scotland through the European Maritime Fisheries Fund. And Scotland has allocated 44% of the total UK figure. With £42 million, that's over 80% of the Scottish allocation already committed to projects at the moment. Competitive funds are awarded directly by the European Commission to organisations to include significant research, innovation and educational exchange programmes. And since 2014, €533 million of Horizon 2020 funding, €65 million of Erasmus Plus funding and €58 million of territorial cooperation funding has been secured by Scottish organisations. And even since just 2016, the European Investment Bank Group has signed loans worth £2 billion for projects in Scotland. So you can see, Mr Deputy Speaker, that these EU-funded programmes represent a vital source of funding to communities right across Scotland. But as I said earlier, they are of particular importance to the peripheral communities who are in greater need of support. And that's why, when the question was asked in 2016, do we wish to remain part of the European Union, every single part of Scotland, without exception, urban and rural, said yes to staying in the EU, because our communities knew, and we still know, the benefits of being a member of the European Union and the significant difference that has made to their lives, both economically, socially and culturally.
He's making some great points there, and is he aware that urban areas such as Glasgow have benefited hugely as well? And since 2010, regional selective assistance grants to businesses in Glasgow have provided over £83 million of investment and created 7,292 jobs.
I thank my friend for that contribution. And It is absolutely remarkable, and no one should be in any doubt just how significant it was, that of the 32 Scottish local authority areas, for every single one of those areas, urban and rural, with the vast differences that exist between them, to have said with one voice that we as a nation wish to remain within the European Union. It cannot be ignored, it should not be ignored, and the significance of it, I don't think, can be underplayed. Mr Deputy Speaker, the loss of the funds that I've listed earlier could be absolutely devastating for our farming and fishing communities, and as yet there are no guarantees for the continuity of these funds beyond 2020. Here we are, a month from Brexit Day, and there is still no certainty for our farming and our fishing communities as they plan for the future.
Will he give me on that point?
I will, yeah.
He's making a great point in relation to funding. Does he share my concern that these communities are going to be hit doubly, because also there's going to be the changes to immigration, which may mean that they won't have the access to labour, given that we are suffering from depopulation in some of our areas that we've worked really hard to counter? Does he feel that this is a double whammy that rural communities can't afford?
My honourable lady, she may well have been looking over my shoulder because I was just about to come on to that very point. My constituency of Argyll and Bute is suffering from massive depopulation. We are losing population at a rate which we cannot sustain. We need to get people to come and live and work, invest and raise a family in Argyll and Bute. And much of our plan was predicated on EU nationals coming to Argyll and Bute to fulfil that function. So not only are we being denied access to funding, but we are being denied access to people. And unless we can find a way of squaring that circle, which I do not think is possible, then I fear for the future. And that's why independence and an independent Scottish Government being represented as an equal partner within the European Union is without doubt the only way that Scotland is going to prosper. And it was reported just today that the DEFRA Secretary told the National Farmers Union that there was, and the quote I've been given is, no absolute guarantee that UK farmers could export to the EU under a no-deal scenario. This is the chaos in which we have descended. And as we said earlier on, of course, the UK Government has promised to replace EU funds with a much-vaunted UK Shared Prosperity Fund, but despite all the repeated promises, there has still been no detail or definition given as to how that new structure will operate. So I would ask the Minister, when will we find out the detail of this Shared Prosperity Fund, and when will we know exactly what that will mean for people across the UK, but people in my Argyll and Bute constituency? Also, could the Minister tell me, post-2020, when the cycle of these current EU funds comes to an end, how will this proposed new system operate? What consent and control will the devolved administrations have over this future funding model? What consultation has been carried out to ensure that this new system will have the consent of and remains consistent with the devolution settlement? Could you also explain why, as I said to the member opposite, why is this statutory instrument coming to the floor of the House before the Agriculture Bill or the Fisheries Bill have even reached the report stage within this place? And why, when the President of the European Commission has promised to financially support Irish farmers in the event of a no-deal Brexit, hasn't the UK Government offered similar support to Scottish farmers? And finally, doesn't he agree that so much of this worry, so much of this angst, so much of the trauma that we are being put through and we are putting other people through could all be prevented if the Government would simply take no deal off the table?
Here.
Here we are, Matt Warburton, please.
Deputy Speaker, I will not detain the House very long, but I do want to speak in support of this SI, which of course secures funding which is vital to some projects in my constituency. Overall, £41 million comes to Lincolnshire, and about £500,000 of that is helping to secure a project that protects a large amount of farmland from flooding. So I think this is an important measure from a government that is taking sensible steps. But the broader and not lengthy point that I would seek to make is that while money did come back to Lincolnshire, overall the fact that Britain was a net contributor to the EU does mean that when we set up the funds that the Minister spoke of post our exit from the European Union, it will give us the opportunity to do two things. And the first of those is to redress some of the regional imbalances that my colleague from Middlesbrough South and East Cleveland spoke of, and which affect regions such as Lincolnshire particularly extremely. But it will also, I hope, give us a much more serious opportunity to win the argument around funding and around what the government is doing to seek to redress those regional imbalances. It is an argument that the EU totally failed to win or even seek to engage in, and it is in many ways why in a constituency such as mine, even when money came back to Lincolnshire from the EU, we didn't see any great love for the European Union, and that was of course reflected, as it was in Middlesbrough South and East Cleveland, in the result that we saw during the referendum. So I would hope that the government, in establishing these new funds, will seize the opportunity not only to redress those balances, which is very real work, but also to seek to really get the advantage from being seen to do what all good government should be doing, which is to move some of the opportunities around the country, in my case away from the southeast and into Lincolnshire. It's good, sensible work, it's good, sensible economics that will allow us to improve productivity and will allow us to grow our thriving agricultural economy. But it needs also to be sold to the public because, as I say, the European Union encouraged a huge amount of antipathy for the European project. We have enough trouble with people holding politicians in this place for contempt. We need to sell the work that we do in order to redistribute that money. That will go far broader than investing in sensible infrastructure projects such as the drainage project that I referred to, and will actually, I believe, provide us with an opportunity to go into a realm of allowing people to see that what we do in this place is fundamentally good work. It addresses things that our constituents want to see done, and it is ultimately not just about economics, it's about good democracy as well, and that is why I will be supporting this SI today.
Minister Howlett. Well, thank you, Mr. Deputy Speaker, and welcome to the Chair. Well, this is the first, as I explained to the Speaker, the first SI I've done actually in the Chamber, and I hadn't realised that it was going to be a general debate on the European Union. And I think most members' views are quite clear on the subject, and many of us share the same views, and some of us disagree. But I think for the purpose of this statutory instrument, if that's acceptable to the Chair, I'll try and answer some of the questions that people answered on the specifics. My right honourable friend from Wokingham asked how these funds would be calculated. These were the funds he was talking about, that where our country would have to pay to the EU in order to get them back, for the peace and Interreg VA. And I can confirm to him that the UK would pay for its full share of the Peace and Interreg VA programme, including, and that's what he wanted to know, administrative costs. And if he would like to take up further detail on that with me directly, I'd be very pleased to try and answer more detailed questions. The Honourable Lady for Newcastle-on-Tyne Central, the Shadow Minister, asked me quite a lot of questions, which I shall do my best to answer. And I thank her for supporting the gist of the statutory instrument. And a lot of the questions came about her views on regional inequality generally, slightly wider than the scope of this. And I must say I absolutely agree with her, having been brought up in the north of England myself, and having been brought up in a country where government was very centralised. And I remember going to visit, I think, in her actual constituency when I was doing my A-levels. It was actually probably a long time before she was born, Mr. Deputy Speaker. Well, one has to do one's best to get the opposition softened up a bit, but it's actually true. It is true in her case. But I went up to visit as a school student the local NEDC, which was an offshoot of the government, National Economic Development Corporation, where very well-meaning civil servants tried to give government money to basically investing in companies in that region. And we were shown also the devastation that the end of mining and other things have caused. It should be very familiar to her, and also to me, coming from Yorkshire myself. And I think successive governments, Labour and Conservatives, have tried their best to deal with that. In some cases, by pretending that government shouldn't have an industrial development policy in that respect, which I have no truck with at all, and a more centralised approach by the Labour government following that with the best intentions, and then different attempts to devolve, either through legislation in the case of Scottish and Welsh authorities, or regional policy, which I very much support, to try and have local delivery mechanisms. The local mayorships is a very good example of that, mayoral authorities. Irrespective of what political party they are, I think the structure is a very good one to try and address this imbalance. The LEPs themselves, the Northern Powerhouse Initiative. Now, the opposition may well argue, in fact do argue regularly, that this is fine, but it needs a lot more money to go into the machine in the first place. And that is always arguable. Oppositions always say they're going to spend more money. Governments of whatever complexion look there and say we've got to find the money from somewhere. These are well-rehearsed arguments. But I would like to place on record, Mr Deputy Speaker, I fundamentally agree with the point that devolution and more money to regions is absolutely important. And I think that point was very well made, and very well made for my honourable friend who's not in his place at the moment. The Shared Prosperity Fund in the future will invest in the foundation of productivity as set out in our industrial strategy to support people to benefit from economic prosperity. And I fully accept the fact that the opposition and many other members on, not just in this statutory instrument, but generally, have commented on wanting to know what it will look like. The WMS that was done in July stated it was, at least, it stated very clearly that it was designed to tackle inequalities between communities, especially in those parts of the country whose economies are furthest behind. And the honourable gentleman for Argyll and Bute argued that case very well. And I'll come on to some of his more specific points in a minute if I may, but the point was very well made. So the funds there to invest in the foundations of productivity, which we put in our industrial strategy document, ideas, people, infrastructure, place in the business environment, and it will be an integrated, simplified fund but operating throughout the UK and not with centralised decision. So what's the government going to do now? Well, I accept the opposition's points that, well, what is going to happen now? Always difficult if you're in government because you have to consult with everyone and form an actual policy, otherwise one gets criticised. Not yourself, Mr. Speaker, Mr. Deputy Speaker, you wouldn't be criticised at all, but the government does in fact get criticised and legal challenges, etc., for not consulting properly, and there will be a proper consultation shortly to recognise the importance that there's a lot of interested parties with different opportunities. And this will inform our decisions on the composition of the shared prosperity funds, which will be taken at the spending review later this year. To set the record straight, this prosperity fund will respect the devolved settlements, and we've made it very clear that we will continue to work in partnership with the devolved administrations to ensure the fund works for all places across the Union. And there has been calls for clarity, but we're working on it. The government's held engagement events with stakeholders from a variety of sectors across the country, including the devolved authorities, because we have to discuss lessons learnt from the past and learnt from them, and potential investment priorities. And I believe that next year, when the spending review consultation takes place, we'll be able to move a lot more quickly on this. The government has guaranteed funding for all. So the government has guaranteed funding for all structural fund projects signed before exit in the event of a no deal, and the guarantee can also be used to fund projects started after the exit. This will protect beneficiaries under this settlement, and regional investment will continue as planned. My honourable friend from Middlesbrough South and East Cleveland, as he has said on a number of occasions with his usual dignity and tact, we do disagree on certain matters. But one thing I absolutely agree on is the way that he is working so diligently to push the interests of his constituents, and the point that he made about the importance of regional plans. He mentioned the Mayor, Ben Hoochin, and the others. I really think this is a model for the future. And whatever one's views on other subjects, well, again, I apologise to talk about your views with Deputy Speaker. Whatever some members' views, I think everyone would agree that the Middlesbrough South and East Cleveland could not have a better Member of Parliament representing their interests. And he reiterated to his constituency the importance of the Shared Prosperity Fund. The honourable gentleman from Argyll and Bute, the SNP spokesman, again spoke generally about his views on Brexit generally, rather than rehearsing those arguments, I'd like to just talk specifically, if I may, on why we're taking, as a government, a different approach in this SI to the agricultural and fishery funds, a point that he mentioned. The European Agricultural Fund for Rural Development and the European Maritime and Fisheries Fund share some regulations in common with structural funds, but this SI only makes provisions for the structural funds, because there's a separate one for the agricultural and fishery funds, which will retain and amend the EU regulation insofar as they apply to those funds. So they're being treated differently, that's why, in fact, they're different, unlike the European Regional Development Fund and the European Social Funds. And so that's why we had to do it. And he asked the question why this is before the agricultural bill, and because this SI is designed to address structural funds, the DEFRA SI will deal with the agricultural funds which it's not related to. And finally, Mr Deputy Speaker, I'd like to commend the speech from my honourable friend from Boston and Skegness, thanking him for his support. But the excellent point, Mr Deputy Speaker, often not made in this House, that the distribution of funds should come with love as well as money. And I'm sure he could be in charge of love in his constituency, which I'm sure he actually is doing very well at the moment. Well, Mr Deputy Speaker, I have tried my best to answer the questions made, and I commend this SI to the House.
The question is motion number 2 as on the order paper. As many of that opinion say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. I now call the Minister to move motion number 3 on terms and conditions of employment.
Thank you, Mr Deputy Speaker. I beg to move that the National Minimum Wage Amendments Regulation 2019 be considered by the House. The Government wants fair employment for all. Through our industrial strategy, we committed to boosting productivity, increasing earning power across the country. The way in which people work is changing thanks to new technology and new employment models. We need to ensure that the labour markets continue to work for everyone. In December, we published the Good Work Plan, which sets out the biggest package of workplace reforms in over 20 years. This includes our vision for the future of the labour market and our ambitious plan for implementing the Taylor Review recommendations. The important package will ensure workers have access to the rights and protections they deserve. It will also create a level playing field for employers, ensuring that responsible employers are not undercut by a small minority who seek to circumvent the law. The national minimum wage and the national living wage are crucial to these commitments. They help to protect the lowest paid in our society. We can be proud of our labour market. Our employment rate of 75.8% is the highest since comparable records began in 1971. Unemployment is down to 4%. Since 2010, the national minimum wage has increased faster than average wages and inflation, meaning more money for the lowest paid workers, while employment continues to increase. This success means we can continue to increase the rates above inflation. We will continue to work towards our target of the national living wage reaching 60% of median earnings by 2020, subject to sustained economic growth. I will give way.
I thank the Minister for giving way, and she's doing a brilliant job, not only as the Small Business Minister, but also the Minister for the Labour Markets. I was lucky enough to be the Minister when we brought forward the biggest increase in the national minimum wage for 10 years. Does she agree with me that the greatest beneficiaries of this are women in the workplace, who tend to be the lowest earners, and that our actions in increasing the minimum wage to the scale that we have has gone a long way to help reduce the gender pay gap?
I'd like to thank my honourable friend, my predecessor, for making the comments in regards to what the government has undertaken to have done over recent years to increase the wages for the lowest paid workers. And I too would like to agree with him that actually what we have done in regards to increasing the rate of pay for the lowest paid workers has indeed supported women in the workplace and being able to help the reduction in our gender pay gap, and also with the other particular programmes that we have coming forward in regards to our consultation on the ethnicity mandatory pay reporting, which we will be saying more about soon. These regulations will increase the rate of national minimum wage and national living wage from the 1st of April. We estimate that this will lead to a pay rise for over 2.1 million workers. I would like to place on record my gratitude for the work of the Independent Low Pay Commission, which recommends the rates. It brings together the views of businesses, workers, and, informed by research and analysis, reaches a consensus on what the rate for the national minimum wage and the national living wage should be. I am delighted to say that we have accepted all of their recommendations for the increases to the different rates from the 1st of April this year. These regulations will increase the national living wage for those aged 25 by 38 pence to £8.21. This is an above inflation increase of 4.9% and means a pay rise for a full-time worker of over £690 a year. I will give way.
Low Pay Commission. Can I too commend the work of Brian Sanderson from the Low Pay Commission and his team? Given that Brian manages to bring together unions, labour market experts and businesses and get them to agree, does she think that maybe we should get him involved in our European Brexit negotiations?
Minister.
I thank my honourable friend for pointing out the good work of the Low Pay Commission and how they bring people together in order to come up with the balanced proposals that we have here before us today, which the government is accepting. It does mean that a full-time worker on the rate will be over £2,750 better off next year compared to the year the national living wage was introduced. The regulations also increase the rates for younger workers and apprentices. Those aged between 21 and 24 will be entitled to a minimum hourly rate of £7.70, a 32 pence increase. Workers aged between 18 and 20 will receive an extra 25 pence an hour, taking their rate to £6.15. 16 to 17-year-olds will earn at least £4.35 an hour, a 15 pence increase. Apprentices aged under 19 or those in the first year of their apprenticeship will receive the largest percentage increase of 5.4%, meaning an hourly rate of £3.90. The regulations are... I will give way on it.
That point, does she appreciate that that's not even enough to buy a Freddo?
Minister.
I would like to point out to the honourable lady that we are talking about the apprenticeship rate. The regulations will also change the amount that employers can charge workers for accommodation without it affecting their pay for national minimum wage purposes. From April, this will increase to £7 per day. Changing the law is the first step. We need to make sure that all workers know they are entitled to the national minimum wage and that all employers know they must pay it. The government runs an annual campaign to increase awareness of the national minimum wage and the national living wage. Last year, we spent £1.48 million reaching workers and employers through posters and billboards, as well as digital and online channels. We know most businesses are good employers and pay at least the national minimum wage, but where non-compliance exists, government will step in and make sure money is recovered on behalf of workers. Since 2015, we have doubled our investment to enforcement of the regulations to over 26 million per year. There are over 420 HMRC staff involved in the enforcement of national minimum wage, and they follow up every worker complaint they receive. HMRC also conduct proactive, risk-based enforcement in sectors or areas where there is a higher risk of workers not being paid the legal minimum wage, including those identified by the Director of Labour Market Enforcement. In this work, they cooperate closely with other labour market enforcement bodies to share information and conduct joint operations where that makes sense for businesses and workers. I will give way.
I thank the Minister for giving way. Where businesses have repeatedly been found to have breached national minimum wage regulations, will the Minister ensure that HMRC proactively investigate other cases of staff employed on similar terms and similar contracts, rather than requiring each employee to separately demonstrate that they have been underpaid?
Well, I thank my honourable friend for raising a point in regards to HMRC enforcement of the national minimum wage, and I would like to point out to him that we take it very seriously. People who breach the law and do not pay the minimum wage there are many different actions that we can take as a government. We will prosecute if companies are found to not be paying the national minimum wage, but also one of our priority remains making sure that workers who have been underpaid do actually receive the arrears owed to them, and we're able to do that, making them pay the arrears but also a penalty on top. But we are committed, and that is why we've doubled the amount that goes towards enforcement of the national minimum wage. We will continue. I'll give way.
I thank the Minister for giving way. So just on enforcement, can the Minister tell us how many people are currently employed in HMRC's National Minimum Wage Compliance Unit, and how does that compare to, for example, those employed in the Department of Work and Pensions chasing social security fraud?
The honourable gentleman asked a question around how many people are working in HMRC on the national minimum wage, and as I've just said, there's 420 that work on the national minimum wage enforcement. Unfortunately, I don't represent the DWP here, so I'm unable to make comparisons at the box today. But as I've said, there's 420 staff involved with the enforcement of the national minimum wage, and as I've already reiterated, we have doubled the amount we are spending on enforcement, as we are determined that companies and businesses will be paying workers what they are entitled to, and we will continue to enforce where we can. I will give way.
Thank you, Mr Deputy Speaker. Can the Minister just tell us how many companies have been penalised for breaking the rules on national minimum wage? How many prosecutions have been brought to bear in the last year?
Minister.
Since the national minimum wage has been brought in, 14 have been prosecuted. There are still some other companies that are currently undergoing investigations. But what we must remember in regards to enforcement, as I've already outlined, is the priority is to make sure that people who have been underpaid get the arrears they are entitled to. And that is also matched with a penalty of up to 200%. And so our focus is making sure the individuals get the money that's owed to them. But there are also prosecutions which we can undertake, and there's also other action that we can do. So our priority is to always make sure that workers get the money that they are entitled to. I will give way again.
In her answer, she said that there have been 14 prosecutions since the national minimum wage was introduced. That wasn't the question I'd asked. I'd asked how many there had been in the last year. I wonder if the Minister could clarify, please.
I will happily try and get some information but in the last year, if you want to clarify which part of the year that you're referring to, whether it is 2019 or 2018 however, I don't have the breakdown for year on year. I've told you that I've done it again. I've told you told the amounts that have been prosecuted since it was introduced. We will continue to support businesses to comply through issuing guidance and the work of ACAS in providing advice. Alongside these regulations, new legislation will come into force from April dealing with payslips. Under this, all employers must provide payslips to all workers. If workers' pay vary according to time worked, their payslip must show the number of hours worked. This will increase pay transparency and help workers to understand and check their pay. These proposed increases to the national living wage will keep it on target to reach 60% of median earnings by 2020. This government has an aspiration to end low pay. In his 2018 budget, my right honourable friend, the Chancellor of Exchequer, said we will give the Low Pay Commission a new remit beyond next year. This will be set out in the budget 2019. In developing this remit, we will engage with both employers and workers to balance the needs of both. Mr Deputy Speaker, these regulations make sure that the lowest paid workers are fairly rewarded for their valuable contribution to the economy. The regulations contribute to our commitment to promote a labour market that increases people's earning power and boosts businesses. And they will give over 2.1 million people a pay rise this year. Therefore, Mr Deputy Speaker, I commend these regulations to the House.
The question is that motion number 3 as on the order paper. Shadow Minister Sean Mora.
Thank you, Mr Deputy Speaker. In the Labour Party's long history of standing up for working people, the introduction of the national minimum wage in 1998 was a particularly proud moment. And let us never forget that it was members on the benches opposite who unanimously opposed that introduction of the minimum wage. I want to start by saying, Mr Deputy Speaker, that we will not oppose this increase in the minimum wage for working people. Any increase in pay for those on the lowest pay is to be welcomed. However, this small rise is entirely insufficient and emblematic of a government who will only do the very barest minimum for working people, and often not even that. Mr Deputy Speaker, there is a crisis in our country. Millions are struggling to make ends meet. Work is no longer a guarantor of a decent standard of living. Indeed, work and poverty are no longer contradictory under this government. The failed policy of austerity has had a terrible impact on our communities. Years of austerity have bred wage stagnation, which in turn has meant that 4 million workers across the country are living in poverty. Real wages are still almost £15 a week lower than they were 10 years ago, and they will not recover to those levels until the mid-2020s. But at the same time, Mr. Deputy Speaker, the rich are getting richer. Our country gets even more unequal. Top executives are now paid 133 times more than the average worker. And that means that the salary of the average FTSE chief executive is the same as that of 386 workers on the minimum wage combined together. I'll give way.
For giving way, and she makes a very good speech. But will she agree with me that as a result of the taxation policies of this government, the richest are paying more tax than ever before, and we have actually lifted the lowest pay by changing the tax rates? We've lifted the lowest paid in our society out of paying tax altogether.
Well, I will thank the honourable gentleman for that intervention, but it does show a lack of understanding of the economic realities in our country. The richest are not paying their fair share. The poorest are paying more in tax, and particularly in that most unequal and unprogressive of taxes, value-added tax, VAT, which the coalition government immediately raised when it came into power. So the poorest in our country are being taxed more, and the richest are not sharing their burden. I will give way a second time.
Raises the issue of value-added tax, VAT. Is it her party's policy to lower VAT should they ever come into power?
Well, as one of my colleagues helpfully says, we have set out, and our 2017 manifesto set out our policies for a fully funded taxation and spend policy. What the honourable gentleman needs to recognise is that a fairer taxation policy will not only enable us to fund our public services better, but it would also ensure that we have an economy which is growing and where the growth is shared by all those who contribute to it, unlike at the moment. Last month we learned that household debt is at its highest rate ever. Many people are reliant on borrowing not for luxuries but for essentials like putting food on the table for their children. Food bank use has skyrocketed.
Can I thank the honourable member for giving way? She's making a very powerful case, and like our 2017 manifesto, it was fully costed, full of figures. The only figures in the manifesto opposite were the page numbers. In my constituency, we have 3,000 families containing 5,000 children, according to the Step Change charity, in toxic debt, owing about £14.5 million. This is because of 8 years of austerity. Does she not agree?
I thank my honourable friend for his contribution, and he makes an excellent point that, in fact, the burden, if you like, the burden of debt has been shifted. We still have our public debt, but it has also been shifted onto the poorest families. And if we look at our national figures for debt, then we have great concern as to our future economic stability. And in addition, as a consequence rather of that, food bank use has rocketed, with wages no longer covering basic living costs. And Mr Deputy Speaker, in my own constituency, our Newcastle's West End Food Bank is the largest in the country. Not an achievement of which we are proud, but we are proud of the generous Geordies who take on the role that this government has abandoned in feeding the most vulnerable amongst us. 5.2 million are trapped in low pay, and small single-figure percentage increases in the legal minimum will not put an end to this misery. Shockingly, 1 in 4 employees earning the minimum wage for 5 years have been unable to move out of that low pay. So low pay is becoming a trap for that period, and that is the highest figure since records began. And the workers least likely to escape the low pay trap are those in the North East and women. They are being trapped by the lack of action from this government. So will the Minister admit that under the Tories, Low pay means work is not a protection from poverty. Now, I want to be clear, Mr Deputy Speaker, that despite its name, the government's minimum living wage is not a real living wage. The small increase that this SI represents will not make it a real living wage. More than 5 million people are paid less than a living wage, a huge increase from 3.4 million people in 2009. I'll give way to the...
I thank the Shadow Minister for giving way. She refers to small increase in minimum wage. The 38 pence increase in the national minimum wage that's been introduced, could she just inform the House how many of the 10 years after the introduction of the national minimum wage did the then Labour government have a bigger increase than the 38 pence that workers will see under these increases?
Well, I think when we introduced the national minimum wage, that was a transformative change for the pay of so many low-paid people. And our commitment to a £10 an hour real living wage is... Our commitment to a £10 an hour real living wage is one which will also be transformative for working people. So the Living Wage Foundation research reveals, which the Honourable Member may be interested in, reveals that 1 in 5 workers, more than 5 million people, are paid less than a living wage, a huge increase from the 3.4 million people in 2009. And in Newcastle, 30% of workers who live there and 20% of those who work there are paid less than the real living wage. In the North East, around 238,000 jobs are not living wage jobs. And so I'm particularly proud that in January, Newcastle City Council, despite having its budget halved by reckless Tory austerity in the past decade, Newcastle City Council renewed its commitment to pay all staff the real living wage. This government, after a decade of imposing austerity, will still not give workers a real living wage. So would the Minister tell me why the government will not follow the example of Newcastle City Council and raise the minimum wage to a real living wage? And the Minister has said that she does not represent the Department for Work and Pensions, but she does represent the Department for Business, who are not paying the London living wage to all their staff. Would the Minister confirm the number of staff, the number of employees who are not receiving the London living wage, and will she explain how we are to have confidence in her ability to enforce even the national minimum wage when her own staff are striking because of a lack of a decent wage from the government of the day?
Thank you, Shadow Minister, for giving way. She makes a very important point that the UK government departments are not complying with the London living wage and that people are taking industrial action. So does she agree with me that that needs to be sorted out today and it should be sorted out now?
I thank the honourable gentleman, and he is absolutely right. A government which cannot even guarantee its own employees a decent wage is not a government that should be able to speak in this debate. And I hope the Minister will clarify the points that I have asked and confirm a plan to ensure a real London living wage is paid to its own employees who are totally within its ability to do so. So this increase in the minimum wage will be of some help to the lowest paid, but it will not be transformative. It will not tackle these extreme and growing levels of inequality, and it will certainly not end the growing levels of in-work poverty faced by millions. Because even if it were a sufficient safety net, the minimum wage would not catch all workers. With the growing gig economy forcing more and more workers into sham self-employment, it is more important than ever that every worker is paid a decent living wage. But the minimum wage does not cover self-employment, and TUC figures show that almost half of self-employed people earn less than the minimum wage. This means 2 million self-employed workers are now stuck on poverty pay. Does the Minister think this is acceptable, and what is she doing to address poverty pay amongst the self-employed? Now, another glaring inconsistency, Mr Deputy Speaker, is the huge discrepancy in the minimum wage for those under 21 and again for those aged 18 to 20. Can the Minister set out why this is the case? Why does the government believe that workers aged 18 to 20 should be paid a far lower rate than those aged 21 for exactly the same work? Why is the adult rate for those under 25 less than for those over 25? What is it about a 24-year-old doing exactly the same work as a 26-year-old that leads the Minister to believe that the former deserves less? The minimum wage does not protect workers against other forms of underpayment. I'll give way.
Extremely grateful for giving way on this point. Does she agree that the anger felt by young people on this particular policy is palpable? And what the message it sends from this government is that by being younger, you're not worth as much as someone who's older than you. What kind of message does that send to young people?
I thank the Honourable Lady for her intervention, and she puts an excellent point very well. What is the message that is being sent to those under the age of 25 about their contribution to our economy? Exactly the people whose confidence and contribution we need to promote, especially during these difficult times. Now, in its latest report, the Low Pay Commission found that over 200,000 workers were underpaid a cumulative total of £15.6 million last year. Measured underpayment for those aged 25 and over increased from 2017 to 23% of all those covered by the national living wage. So does the Minister agree that this is simply not good enough? Labour would stand up for workers against unscrupulous employers by properly resourcing HMRC, a critically important point when it comes to enforcement, and, in addition, strengthening enforcement of labour laws. We will crack down on employers who breach labour market rights and regulations through increased fines and sanctions. Because Labour is committed to making work pay. And that is why we will ensure a real living wage of at least £10 per hour for all workers aged 18 and over. We believe that there is no justification for differential rates based on age. Increasing wages, particularly of the lowest paid, would not only immediately help those workers and their families, it would also increase demand in our economy and reduce the subsidising of low pay by the state. So given this government's chaotic handling of Brexit and the perilous state of our economy as a consequence, does the Minister agree that such economic benefits, the boost that a significant raise in the living wage would do, that those economic benefits are desperately needed? It's important that the state sets a minimum rate of pay, Mr Deputy Speaker, based on the Commission's recommendations, but state minimums are just one part of the solution to low pay. Trade unions are the collective voice of workers, through which they are best placed to bargain over what they are paid within a negotiating framework, including the employers. So does the Minister agree that it would be far better if workers had a direct voice in the setting of their pay through, for example, national sectorial collective bargaining? Mr Deputy Speaker, I believe workers in this country deserve far better than this government is offering. They deserve far better than this government. That's why Labour will set up a new department to roll out sectorial collective bargaining, protect the interests of workers and strengthen trade unions, introducing new rights and freedoms so that every worker gets the support, security and pay at work they deserve. This government is clearly incapable of doing that, but I hope the Minister will at least be able to answer my questions. Thank you.
Gillian Keegan.
Thank you, Mr Deputy Speaker. Well, I, for one, am pleased to see the national living and national minimum wage continue to increase and support the lowest paid. And it's frequently the case that those on the minimum wage have the hardest jobs and jobs which many of us, well, they're vital to our daily lives. Carers are just one example, and many of us who've had a relative cared for know just how demanding this work is, but how invaluable, indeed priceless it is as well. And we need to make sure that carers and many on the minimum wage are properly rewarded for their work, as everybody rightfully should be. So the government has made some promising steps in this regard, with net wages for somebody on the minimum wage increasing by 39% since 2010. It's estimated that 2,600 people in Chichester are either on the national living or national minimum wage, and all are set to benefit by the above inflation increases to their hourly rate. And that represents about 6% of the local workforce. And Chichester Chamber of Commerce and Industry has welcomed the government's acceptance of the Low Pay Commission's recommendations. And the CCI have said that Chichester businesses want to recruit the very best employees, and this needs to come with a decent wage. I completely agree, and I'm also encouraged that the CCI does not foresee any adverse effects on local businesses because of the proposed increases. I'm not saying that raising the minimum wage alone is the silver bullet, but because of these proposed increases, a full-time minimum wage worker will see their earnings increase by over £2,750 annually next year, which is a number of Freddo bars, I think. And this is good news on top of other government measures, like increases to the personal tax allowance. And I also wanted to celebrate the 20p increase to the hourly rate for an apprentice. It represents by far the biggest proposed increase, a 5.4% rise compared to current rates. And this will be a welcome boost to the pockets of the 540 people who started an apprenticeship in Chichester this year. But let's not forget that many people, this is a minimum wage, and many people pay above the minimum wage to apprentices. I myself was an apprentice, aged 16, more than 30 years ago, and I think the Labour policy at the time actually wasn't to pay the same minimum wage to me at 16 as you would at 50, but it seems that that could be the policy they're about to introduce according to the front bench. And actually, many people pay above the minimum wage to apprentices, but also apprentices are getting valuable new skills which are sponsored and paid for by their employers. But as a newly appointed apprenticeship ambassador, and with National Apprenticeship Week coming up, this increase will be one of the benefits of taking this route into the workplace, as well as learning the skills that you need. And I, for one, will be welcoming that. And with employment at an all-time historic low under this government, this has resulted in only 1.2% of people in Chichester actually being unemployed. And so the job centre's aim to get everybody a job, get them a better job, and then move them into a career is a realistic ambition, and the minimum wage will help along that journey. So I welcome the proposed increases, and I'm pleased that we are on our way to making the national living wage reach 60% of median income by 2020. Hard-working people deserve an income that is reflective of their importance to our economy and the services we rely on daily. We all want to make sure that work pays, and I think these inflation-beating increases are a good step in making that a realistic prospect. Thank you.
Chris Stevens.
Well, thank you, Mr Deputy Speaker. It's my first statutory instrument in the Chamber, I should say. It's a pleasure to see you in the chair, and it is a pleasure to follow the honourable member for Chichester. Now, when you're in this chamber, Mr Deputy Speaker, as I am, I'm sure there's always a moment when you ask yourself if the party of the establishment actually have a clue about what happens in real life. And I think that moment was revealed today when my honourable friend for Glasgow Central pointed out to the Minister that one of the increases of the minimum wage rate was the price of a Freddo bar. And we saw some members of the government didn't know what a Fredo bar actually was. We had the Prime Minister's PPS shouting in a secretary position that he thought, and I did tell him I was going to mention him, that he thought the price of a Fredo bar was 10 pence. What chance does the country have, Mr Deputy Speaker, if someone advised the Prime Minister doesn't know the exact price of a Fredo bar? And I think I'll give way in a second. But perhaps, Mr Deputy Speaker, perhaps the library might want to do some research that if the minimum wage rate had increased at the same rate as the price of a Fredo bar had increased, I wonder what the minimum wage rates that would be presented today would be. I'm suggesting, Mr Deputy Speaker, that it would be higher than what the government is presenting today, and the honourable member for Dudley South has asked to intervene, so I'll give way.
I thank the honourable member for giving way, and clearly you do not get a fine figure like this without knowing precisely the figure, the price of a whole range of chocolate bars, and I'm sure he'll be aware, as I am with young children, that Fredo bars as recently as last month were indeed 10 pence at Tesco.
So there we are. So it seems unlikely. Perhaps we'll ask for photographic evidence from the honourable member of the price of Fredo bar, and we'll maybe make that sort of competition for members of Parliament this weekend. Mr Deputy Speaker, statutory minimum wage rates are important because in some sectors of the economy, the statutory minimum rate is actually becomes the maximum wage rate, and it's important that the statutory minimum wage rates are enforced properly. Now, the Minister notified me in an answer to a question that the National Minimum Wage Compliance Unit hires 420 staff to enforce national minimum wage compliance across these islands. That's opposed to 4,754 full-time equivalent posts who chase social security fraud. And yet, Mr Deputy Speaker, we know that over 200,000 workers are not paid their proper statutory wage. An absolute scandalous figure, in my view, Mr Deputy Speaker, and one that I think needs to be addressed. So I hope the Minister can tell us what plans going forward the National Minimum Wage Compliance Unit have to hire additional staff to correct this situation and to ensure that the national minimum wage rates going forward are enforced properly, so that we don't have a situation where over 200,000 workers are being paid incorrectly. The Minister mentioned the Good Work Plan. Certainly, with a view of these benches, that they don't go far enough, and in fact the Minister should perhaps just pick up the workers' definitions and rights bill in my name and go forward with that. That would give far better protection for workers. It would sort out the status of a worker. It would eliminate zero-hour contracts. It would provide protection for wages where a company ceases trading or where an owner of a company absconds. And it would also deal with the increasing situation in the workplace where workers turn up at work and told that they're subjected to short-notice shift changes. And in some cases that is, we don't need you today, and in other cases that is, you're going to be working far more hours than we told you to when you turned up to work. So perhaps the Minister could tell us when she expects the statutory instruments in relation to the Good Work Plan to come before this House, and whether they would be debated, as these ones are, in the Chamber. Now, Mr Deputy Speaker, whilst we welcome any increase, it's certainly our view that these measures don't go far enough, and indeed the real issue of age discrimination is not being dealt with, and really the age discrimination in relation to these minimum wage rates really does have to end, and that young people are being denied a real living wage, not the pretended living wage, are being denied a living wage of £9 an hour, or as is the case in London, £10.55. And I would agree with the Shadow Minister that UK government departments should be paying the London living wage, and the fact that they're not, I think, is a disgrace. Now, if we look at the percentage increases going forward, for over 25s, the percentage increase is 4.9%. 21 to 24-year-olds, it's a smaller increase, it's 4.3%. 18 to 20-year-olds, 4.2%. 16 to 17-year-olds, 3.6%. And the apprentice rate is going up 21 pence an hour, and that would be scant consolation to those women born in the 1950s who the government keeps telling us that they should pick up apprenticeships as opposed to fighting for their pensions, that they should take up apprenticeships, that they would get an apprenticeship rate of £3.90 an hour. So can the Minister tell us when this age discrimination is going to end? And does she not accept that 21 to 24-year-olds often have the same responsibilities and payment demands and bills as those who are over 25 years of age or over 25? And can the government actually tell us, in relation to their pretended living wage, why was the age of 25 picked? We've never had a proper explanation as to why that applies to those aged 25 or over. It seems to me that that is a particularly ludicrous position, because I remember the arguments that we used to use when I was on the Unison Scottish Young Members Committee not that long ago, Mr Deputy Speaker, when we were arguing, I think, a rather sensible position. If you have two individuals who work at a fast food restaurant and they're both flipping hamburgers, and one is 17 and one is 37, they're both active participants in the labour market, and yet the difference in pay from the regulations going forward would be as much as £3.84 an hour. It would actually be, if it was an 8-hour shift, the difference would be £30 a shift. And that could be as much as £150 a week. It really is time for this age discrimination to end, Mr Deputy Speaker, and I look forward to the Minister telling us when that will be the case.
Thank you very much, Mr Deputy Speaker. Now, I know that many across this House will share my concerns that Brexit and the removal of hard-won EU legislation will mean a race to the bottom for workers' rights in the UK. So in that respect, it is at least a little bit encouraging to see a commitment to continuing to increase minimum wages. However, as I've said time and time again in this place, it does not go nearly far enough. The UK Government's pretended living wage is not enough to live on. The real living wage, as calculated by the Living Wage Foundation, is set at £9 per hour or £10.55 in London.
Yeah.
Mr Deputy Speaker, the pretended living wage falls short of this. And for those of us who wish to see a highly educated, highly skilled, high-wage economy, it continues to be extremely disappointing that the UK Government chooses not to increase minimum wage levels to a level that people can actually live on. High wages are linked to increased productivity, which is an issue the UK has struggled with for many, many years, to increase staff retention and to higher standards of workers. A substantial increase in wages is not a choice between acting in the interests of businesses and the interests of employees. Mr Deputy Speaker, it's entirely possible to cover both. The attitude I'm hearing from the opposite benches is that the national living wage falls short of a real living wage, but we should celebrate it anyway because it represents a pay rise for working people. But, Mr Deputy Speaker, this represents a real lack of aspiration from the UK Government, a government which claims it wants to help people work their way out of poverty, but by whose actions they fail time and time again. If this UK Government really wanted people to work their way out of poverty, they would be investing in our labour markets, increasing the powers of trade unions and improving the rights of those in insecure work. The UK Government is presiding over one of the lowest rates of real wage growth amongst the advanced nations in the G20. Andy Haldane at the Bank of England has described the last 10 years as a lost decade for workers, and the measures today will do very little to address this problem. Mr Deputy Speaker, as things stand, the Chancellor is giving with one hand and taking away with the other. For those at the lower end of the income scale, the proposed increase in the minimum wage doesn't even offset the impact of the benefits freeze. I and my honourable friends in these benches have consistently called for an end to the benefits freeze, which is a pay cut by stealth for some of the lowest earning people in this country. And we welcome the Labour Party's commitment to scrap it, even if it didn't feature in their 2017 manifesto. Mr Deputy Speaker, I would like to address the age pay gap, the income inequality that the national minimum wage creates over age groups. The base impact assessment on this policy explicitly states that the purpose of a lower minimum wage for under 25 is to maximise the wages of low-paid workers without damaging their employment prospects. Further, within the impact assessment, it says the Government asks the Low Pay Commission to recommend separate national minimum wage rates by age band 16 to 17, 18 to 20-year-olds and 21 to 24-year-olds. There is no real evidence behind this to justify why this is necessary. And it's absolutely insulting to young people in my constituency and across these islands to say that employers would not want them if they had to be paid a fair wage. And quite apart from this, it entices employers to make hiring decisions based on age, encouraging unscrupulous employers to break the law. And make no mistake, Mr Deputy Speaker, this is state-sponsored age discrimination. If we look at the specific impact assessments here, the public sector equality duty sets out that the government has to eliminate unlawful discrimination, harassment and victimisation and other conduct prohibited by the Act. The protected characteristics consist of 9 groups: age, race, gender, disability, religion or belief, sexual orientation, gender reassignment, pregnancy, maternity, marriage and civil partnership. If I was to say that any one of those other protected characteristics, Mr Deputy Speaker, gender, for example, that women could be paid lower than men, that would be against the law. But somehow, mysteriously, this impact assessment does not extend to age. And I would really like to see somebody, some smart lawyer, take a legal challenge against the government here, because this is clear discrimination by government in the terms of this statutory instrument on the basis of age alone. There is no justifiable reason for this policy. And to compound matters further, the proposal we're discussing today will increase the pay gap between the age groups. The uprating of the bill will mean that 24-year-olds can earn £90 less a month than 25-year-olds for the exact same job, amounting to a difference of more than £1,000 a year, and the gap will increase even further within the under-25 age groups, making it even harder for young people to get by. And since this was brought in 2016, Mr Deputy Speaker, 18 to 20-year-olds have seen the age pay gap go between themselves and somebody on the higher rate go from £1.90 to £2.06. 16 and 17-year-olds have seen it rise from £3.33 to £3.86, that gap between the highest wage and all that they are legally entitled to be paid. And for apprentices, the gap has gone from £3.90 to £4.31. There is no justification in the impact assessment for this state-sponsored age discrimination. And if I was to suggest, perhaps, that MPs in this House, an MP born in 1973, perhaps like my honourable friend, an MP born in 1978, like the Minister across the way, and myself born in 1982, if I was to suggest that MPs were to be paid different pay rates depending on their age, I can't imagine any MP in this House signing up to that. So why should young people face this discrimination in law proposed here today by the government? And I mentioned exploitation. Yes, of course.
I'm listening very carefully to the point. Having started my own working life age 16 as an apprentice, I wouldn't expect to get the same level as a minimum wage at 16 as I would perhaps starting in a new job or in something else when I was 20, 30, 40. I mean, surely there is some recognition that experience does come with some age, even if it's not always in the workplace. And to expect the same at all of those, I think people perhaps when they're older might like to see a differential for their experience.
Well, you see, she misses her own point though, because it doesn't say the national experience wage amendment on here. Yes. It says by age. It's discriminating by age and by age alone, not by experience. So if she as a 16-year-old walked into a job on the same day as somebody who was 25, they're not legally entitled to the same wage. They have no more experience in that job, regardless of what experience they might have in life. And there might be 20 or 16-year-olds who are far more savvy than a 25-year-old on the first day in a job, or a 45-year-old, or a 65-year-old. That is not what we're measuring here. Which one?
I thank the honourable lady for giving way. Surely she recognises the conclusions that Low Pay Commission actually came to, and they said, in light of this evidence, we concluded when thinking about the pay floor for this age group that it could not currently be set at the same level as the national living wage without risks to employment.
This is exactly the same kind of employment that the Conservatives made when this was being brought in the first place, that it would risk people's employment. That has not been the case. And it says within the impact assessment, if he wants to look at it, that the government asks the Low Pay Commission to set it at these levels. The government has instructed the Low Pay Commission to do this. So that's quite different. That is quite different. And I don't buy his arguments at all. And this amounts to a difference of thousands of pounds in the take-home pay between a 16-year-old, an 18-year-old, a 21-year-old and a 25-year-old. And it is completely unjustifiable. Because this is not about experience, as I've said. It doesn't say that in the regulations. It specifies age and age alone. And I'd like to turn to a quote from the Young Women's Trust, who've done an excellent report that I would commend to the Minister, called Paid Less, Worth Less. And Sinead, who's 24, said, a 25-year-old starting out in their first job and just entering the workplace would have the same experience as a 16-year-old who's also just starting out. If companies want to pay based on experience, then that should be reflected in what they choose to pay people, but that's different in paying us on our age. She's absolutely correct. And at 25 or younger, many people have families of their own to support and their own responsibilities. And in the research by the Young Women's Trust, Tia mentions specifically her circumstances, and she says, I'm a care leaver and I've lived independently since I was 17, so that makes my costs exactly the same as maybe like a 30-year-old who's living in a private rented flat. You have bills to pay like any other adult. Everyone gets hungry. Everyone has to pay for gas, electrics, toiletries, clothes and food. It all adds up the same, so I don't see why there should be a pay difference. Madam Deputy Speaker, I don't see why there should be a pay difference either. It's completely unjustifiable. Young people have to pay the same amount as somebody over 25 for rent, for getting the bus to work, for childcare, for going to the cinema, for whether they want to buy a Freddo bar or not, as we've discussed. All those prices are exactly the same. They're not entitled to discounts on their rent because of their age. And indeed, they get less in benefits from this government as well because of their age. So they're doubly missing out here. Young people deserve the right to be paid a fair market value for their skills and not be subject to state-sponsored age discrimination. And Madam Deputy Speaker, I mentioned unscrupulous employers here. And when I was at school, it was well known amongst my peers that employers would pay young people that I was at school with up until the point that the employer had to pay them more, and then they would lose their jobs. And this is particularly true for people who are on zero-hours contracts and precarious employment who can be let go at a moment's notice. Because as soon as an employer thinks, I'm going to have to pay that person more, they can show them the door. And there's very little by way of protection here, particularly when you look at young people who do not know what their rights are or cannot afford legal representation to challenge them. And I had a constituent a few years ago now who worked in a bar when the rates went up, and she was pretty sure, because she was the oldest person employed in that bar, that that was the very reason she was let go, but she could not prove it. And that is the door that this government leaves open to unscrupulous employers to do this time and time again to workers, low-paid workers, often female workers in part-time jobs, to do those kinds of things, because they are able to do so by the law. They can get up to that point of doing it in law, and this government is aiding and abetting those unscrupulous employers in doing so. Madam Deputy Speaker, Scotland is the best performing part of the UK in terms of paying the real living wage. There are 1,363 real living wage employers in Scotland, and I'm proud to say that the latest ones are among in my constituency, the Scottish Fair Trade Foundation, Silver Cloud, and the spectacle manufacturer Eola, who has a shop in Finniston, are amongst those. And I'm proud to see that growing, and I'm proud to see real responsible employers seeing the benefits of paying the real living wage to their employees. They see it improves retention, they see it improves morale, and they see the value in doing so. But these powers around minimum wage at the moment are not devolved. They stay with this government. This government is not interested, quite frankly, in making the change for young people in this country. So I ask the Minister, if she's not interested in doing this, will she devolve the powers to the Scottish Government and let us get on with the job?
Minister. Thank you, Madam Deputy Speaker, and I would like to thank all colleagues and members for their contributions this afternoon. And I am very pleased to hear that the opposition will not be objecting to the statutory instrument that we have before us here today. However, Madam Deputy Speaker, I do want to raise my disappointment at some of the comments that have been levied across the House in regards to these bench and their commitment to workers and their commitment to the youth. And it seems to be a continuing theme. I heard some of these criticisms levied last week at me in another debate. And I want to point out that this government has been clear, the Prime Minister's been clear, and actually I won't take any lectures from the other side of the House about supporting low-paid workers or whether we really understand the real world on this side of the bench. As I've stated numerous times before, I am a Conservative, and I'm proud to be a Conservative and proud to be part of a government that is committed to the biggest reformation in workers' rights in the workplace in 20 years. And I'm proud to be a minister to be part of that. I will give way.
I thank the Minister for her speech so far. You know, we hear a lot about Brexit and workers' rights being eroded if we should leave the European Union. But aren't we demonstrating through the Taylor report that actually we're going further and faster than Europe in guaranteeing new rights to the lowest paid and vulnerable workers?
Well, I thank my honourable friend for raising that point. He is indeed correct. We have been very clear that when we leave the European Union, we will not be rolling back on workers' rights. That has also been further guaranteed by the introduction of the Good Work Plan, and as I was going on to later on in my speech, but we have already laid 3 SIs. We are going further with workers' rights, and we are increasing the wages for the lowest paid. We are sticking to our commitment, and I am proud to be part of a government that has put workers' rights and the lowest paid in our society at the top of their agenda. So I will not take lectures from the opposition in regards to that. The lowest paid workers. We have also raised we will raise the personal allowance to £12,500 in April. That will take 1.7 million people out of tax. Since 2015, the national minimum wage has risen at its fastest rate above average wages and inflation. The lowest paid have seen an 8% growth between April 2015 and 18 above inflation. So therefore, I will not listen to the accusations that we haven't indeed committed to our commitment to continuing to reach the median pay by 2020, 60% of median pay by 2020, and this government will continue to do that. I will give way.
Thank you, Madam Deputy Speaker. Could I just confirm with the Minister that the lowest paid will still get the same deal they're getting now, or better, if Brexit happens, which it will?
I would like to... absolutely, my honourable friend is quite right. The rates that will come into force in April will be paid at the same rate whether or not we leave the European Union, as we leave the European Union. We didn't see these increases under the last Labour government year on year, unlike the commitment that has been made by this government and delivered upon, and again has come forward this year with another plan, accepting the recommendations of the Independent Low Pay Commission, who take their job extremely seriously and produce great reports and consult with businesses, workers, and make sure that when they're making their independent recommendations to government, they are doing them in an objectively fair, assessed way. I'll give way, yeah.
The House, it was who introduced the national minimum wage and the low pay commission in the first place?
Well, I would also like to point out that we introduced the national living wage in 2016. And as I have reiterated, we have been year on year increasing and sticking to our commitment. So, in regards to, I would like to answer a few more, a few of the questions, and in particular, the question from the honourable lady from Newcastle upon Tyne in regards to base pay for security staff. And it is absolutely true. We value all the staff and they deserve fair and competitive wages. The department has agreed with its contractors that they will align the pay of cleaning, catering and mailroom and security staff to the median rates for those occupations, which will be effective from the 1st of March 2019. Also, I'd like to mention... I will give way, yeah.
So I thank the Minister for giving way and for that clarification. So is she saying that all staff at Bays will be paid the London living wage from this financial year?
I welcome the comment in regards to the London Living Wage, and we also value the work of the Living Wage Foundation. But it is government's responsibility to set the minimum rate that's paid. And as I have said, in regards to the wage rates, it has been agreed that they will be aligned. They will be aligned with the median rates, and that will come into effect on the 1st of March. In regards to young workers, I would like to touch on that point. And as a result of the increases coming in April, another 350,000 young workers will benefit from the increase in pay. And also I would like to point out that 9 in 10 workers between the ages of 18 and 24 are paid more than the minimum rate. Also, there's been a lot of criticism around why we have age-related rates. Well, actually, it's not a new thing. Age rates have been in place since the national minimum wage was in place, since 1999. So this is not a new thing. In actual fact, this government has asked the Low Pay Commission this year to review the youth rates and to see if they are fit for purpose, and they will be reporting later in the year. I will give way.
But surely she must concede that the government have made this situation worse by introducing the pretended living wage rate for those 25 or over, and does she not that has actually increased age discrimination and not reduced it?
As I've already highlighted, that age rates are not a new thing to this regulation. We have asked the Low Pay Commission. To review the age-related rates and report back later in the year to see if they are fit for purpose. But it has to be highlighted, and honourable members have raised this in the House. It is absolutely true that the younger workers are the most vulnerable workers in regards to employment. And I must point out that unemployment between September to November 2018, 16 to 24-year-olds, there was 11.7% unemployed, compared to 2.9% over 25. It is absolutely right that when these rates are set, they are being done so with the mind that we want young people to be in work, to be getting the experience, in order for them to have the earning capacity in the future to reach their full potential and be able to fly. And they can do that with work experience and getting into the place of work and gaining that experience and getting the, in some cases, entrepreneurialism they need to go on to do great things. Now, also, I just want to make one more point on the age-related models. They have been in place since 1999, and actually this model is used across OECD countries, so it's not specific just for the UK. In regards to, I now want to move on quickly to enforcement. And I have said at this dispatch box a number of times since I've had this role, that enforcement is something that we take extremely seriously. That is why we have doubled the enforcement to £26 million. We have, in 2017 to 18, there were 810 penalties that totalled 14 million. Now, this is 5 times more penalties that were imposed in the last 5 years under the last Labour government. So to to levy that we are not enforcement and taking that seriously is just factually incorrect. I will make some progress because I'm keen that there's other business to be getting on with. So, in regards to enforcement, we are committed to making sure that anyone who underpays on the minimum wage, they will be investigated and they will be penalised or prosecuted. As I have said, HMRC will always investigate every worker complaint and make sure that there is compliance at the national minimum wage. And this government, and I am clear, all the time I have this role, the enforcement of the national minimum wage is important to me and is central to delivering that. In regards to the levy that we are deliberately discriminating against young people in the workplace is pure fantasy. We are not discriminating. In actual fact, this government is taking forward work plans and progress to make sure that workers in this country are not discriminated against, and going as far as we can. In regards to the specific questions around the SIs that have been laid, there have been 3 SIs that have been laid, and the first one, in actual fact, Madam Deputy Speaker, will be debated on the 6th of March. So I'm looking forward to being able to bring that forward in the House. The national minimum wage, the national living wage make a real difference to the lives of millions of workers in this country. I am glad that there is agreement across this House that the lowest paid workers deserve a pay rise, which these regulations will provide. These regulations mean that on the 1st of April, over 1.7 million workers on the national living wage will receive a pay rise. A full-time worker will receive an additional £690 a year. The younger workers will also get more money through increases to the youth rate. And I hope that we can do more in the future. Our industrial strategy aims to build an economy that works for everyone. Whether you live, wherever you work, creating good jobs, increasing people's earning power is one of the pillars of our strategy. Having a UK-wide minimum wage recommended by the Independent and Expert Low Pay Commission makes sure that the lowest paid in society are protected in terms of pay. And it means that businesses compete on a level playing field. The increases for this year will mean that wages continue to rise above inflation, will remain on track for the national living wage to reach 60% of median earnings by 2020, and we have the highest employment rate since comparable records began. We can be proud of our labour market and we can be proud of these regulations. Madam Deputy Speaker, I commend these regulations to the House.
The question is motion number 3, as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Thank you. I now call the Minister to move motion number 4 on exiting the European Union medicines. Minister Jackie Doyle-Price.
Thank you, Madam Deputy Speaker. I beg to move that the House consider the Medicines for Human Use Clinical Trials Amendments EU Exit Regulations 2019. Before doing so, I think it's important to reiterate that we wish to retain the closest possible working partnership with the EU to ensure that those engaged in clinical trials can continue to develop innovative and cost-effective treatments, and that patients recruited in trials can continue to have timely access to medicines. However, we are bringing forward this legislation to continue the no-deal preparations in case we need to be prepared for that eventuality. In developing this amending legislation, my department's priorities have been to minimise any disruption to ongoing trials and to make sure that the UK regulator can still protect public health, and to ensure, importantly, that the UK's biomedical health and life sciences research sectors can continue to be world-leading. With that in mind, the MHRA has sought to take a pragmatic and proportionate approach in establishing the new regulatory requirements. Importantly, it also should be noted that this has been done through continued close cooperation with stakeholders. And after a period of informal consultation in August, the MHRA published an initial proposal and followed this up through a further consultation. The feedback from that consultation, which received over 170 responses, led to this SI before us now. Just to bring a few details to the attention of the House. Firstly, wherever possible, we've sought to maintain existing arrangements. And given that the system for clinical trials is currently based on national level decision making, both in the EU and globally, in some key areas we have not had to make any substantial change. In particular, on the ability of the UK to participate in multinational trials in the EU or the rest of the world, there will be no change. And also, the data gained from trials in the UK can still be deposited in international repositories and be accessed by others. I think the House will agree that that informs our approach, which is to continue multinational cooperation on clinical trials. In other areas, we've faced a choice regarding the UK's regulatory requirements, and in those instances, we've sought to maintain current arrangements, provided the regulator still has sufficient ability to protect public health. For example, we will continue to recognise existing approvals, so there will be no need to reapply for both regulatory and ethics approvals. We will require the same information requirements as the EU for any new applications for multi-state trials in the UK. And there is a requirement that a clinical trial sponsor or legal representative for clinical trials in the EU should be based in the EU. This will ensure the continuity of the existing clinical trials landscape and maintain the UK as an attractive, open environment in which to conduct clinical trials. The MHRA will continue to Yes, indeed.
I'm very grateful. She's making an important speech, but would she recognise there are concerns in the industry about an extra level of regulation being introduced through these proposals, through the qualified person requirement, which there is a worry that will make our country a less attractive place to conduct clinical trials, which is, of course, extremely important to my part of the world.
I absolutely appreciate the point the honourable gentleman is making, and perhaps if I could reassure him by emphasising the UK is committed to establishing a far-reaching science and innovation pact with the EU to facilitate the exchange of research and ideas so that we continue to maintain the competitiveness that he refers to. In bringing forward these proposals, we've been determined to obviously establish our pattern of regulation from outside the EU if need be. But as best as possible, we wish to continue with business as usual. But we will continue to engage with the sector in order that that competitiveness is maintained, because we fully appreciate the value of the life sciences sector to our economy. Indeed, yes.
In the explanatory notes in 7.6 and 7.7, it highlights that the EU makes public and transparent information and talks about the MHRA doing that. But it doesn't mention there that the MRHA would be publishing data within the upcoming EU system.
The regulations here are determined to facilitate transfer with not only EU bodies but internationally as well. We fully recognise in bringing forward these regulations that we are operating in an international landscape, and the regulations are designed to facilitate that cooperation as well as to establish the MHRA as the lead regulator. It's also worth noting that within the current system, the MHRA is the lead. In terms of the regulation that we're transposing, rather less is coming to the MHRA given the existing ownership they have in this field. Yes, indeed.
Given that our industry here is a world leader and very significant part of the European effort, does she see opportunities in the future for us to have world-class regulation where we lead and differentiate in a way which would strengthen our efforts?
Well, my objective this afternoon, Madam Deputy Speaker, is to make sure that we can continue with business as usual on exiting the European Union. But clearly, once we have left the European Union, that would be open to us. I think the ethos behind these regulations and the consultation we've had with the sector very much recognises that this is an international marketplace, and we must ensure that we remain competitive in taking forward these requirements. As I was saying, we will require the same information requirements as the EU for any new applications for multi-state trials in the UK. There is a requirement that a clinical trial sponsor should be based in the EU. Now, there are a few areas where it has been necessary to add a new requirement as a result of the UK no longer being part of the European regulatory framework. And that has been about the MHRA putting in place a new national IT system for safety reporting and submissions, and also that the investigational medical products, known as IMPs, being imported from the EEA will now obviously require an import licence, as they would no longer be part of the single market. As the Honourable Ladies referred, they will be overseen by a qualified person to ensure that those products are being appropriately certified. And this builds on the existing import licensing system, which allows the transport of IMPs direct from EEA to UK trial sites to continue. Recognising that this is a new system, we have provided stakeholders with a 12-month transition period from exit day before this new system comes into force. Now, whilst not specifically covered in this SI, I would like to reassure members that the Government is engaging with organisations running clinical trials to ensure that the continuity of supply continues and that those drugs continue to be received. The Government's undertaking a comprehensive deep dive into clinical trial supplies to gain detailed understanding of what's required, and is putting in place contingency plans in case the sponsors need them, and that would include access to the same prioritised shipping routes which will be available for all other medicines. As I mentioned in response to the Honourable Gentleman, the Government is committed to ensuring the UK remains one of the best places in the world for science and innovation. And right honourable members should note the Government's commitment to align with the EU's new clinical trials regulation as far as we possibly can, without delay, when it does come into force, subject to the usual parliamentary approvals.
Could the Minister also comment on the concerns raised by organisations like Cancer Research UK about future pan-European trials, where it would appear that the sponsor or lead would have to be from within the EU rather than within the UK?
Well, as I said to in response to earlier questions, I think the Government is approaching this, that this is an international marketplace. Clearly, we want to have access to the best possible medicines, and we do want to ensure that we can continue to cooperate and share that information as best as possible. I would fully expect the MHRA to be sharing that information with the European regulators, as it currently does. Regardless of EU exit, the MHRA and partners across the UK healthcare ecosystem are already taking steps to improve the UK clinical trials application process to ensure that it is as seamless as it possibly can be. So in conclusion, in the event of a no deal, these regulations will put in place a pragmatic solution that ensures that the UK's clinical trials legislation continues to function effectively after exit day. Essentially, we want this to be business as usual following exit, and I commend this statutory instrument to the House.
The question is motion number 4, as on the order paper. Shadow Minister Sharon Hodgson.
Thank you very much, Madam Deputy Speaker. I would like to start by thanking the Minister for bringing this legislation to the floor of the House and for providing us with a summary of this legislation. It helped immensely. I know that we are expecting many more health SIs in the weeks to come, so I must make it clear again, as I will do in the future, that it is incredibly concerning that we are now only 38 days away from the 29th of March and that we are still preparing for a no-deal Brexit. I hope it does not come to that, but this has taken up a considerable amount of Parliament's time and resources, and my preferred scenario would have been one where the Prime Minister did not run down the clock for 2 years, especially so now when we are closer and closer to Brexit Day. I do understand the need for just-in-case legislation, but I do believe that we should have secured a deal by now. Anyway, Madam Deputy Speaker, moving on to the legislation, clinical trials will probably not be in the forefront of people's minds. However, they are crucial for the safety and efficacy of medicines, as well as our health and well-being. Medicine is not something that we should get wrong. Although when we do, as in the case of Primitos and Valproate, with vaginal mesh also as a surgical procedure, we must hold our hands up and take urgent action. Whilst this may not be the most eye-catching statutory instrument, it is hugely important, and it's about patient safety and confidence. This amendment would mean that in a no-deal scenario, the Medicines and Healthcare Products Regulatory Agency, MHRA, would be able to operate as a regulator outside the EU system and would therefore take on roles formerly conducted by the European Medicines Agency, the EMA, and the wider EU regulatory framework. And I must put my disappointment on the record that the EMA is relocating from the UK to the Netherlands next month because of Brexit. Our loss is the Netherlands' gain, but we should not have let it come to this. However, this means that in the event of a no-deal Brexit, the MHRA will be able to regulate clinical trials to ensure that they continue to operate effectively. I would, however, like to ask the Minister some clarification on a few points. The new EU Clinical Trials Regulation, CTR, was introduced in April 2014 and expected to come into force in October 2018, and I understand that due to technical issues this has now been delayed. The Government's no-deal guidance says, and I quote, "We'll align where possible with the CTR without delay when it comes into force in the EU." So can the Minister please reinstate this commitment to the House today? If the UK does leave with a deal, which I hope we do, what will the arrangements be with regards to the CTR and the UK? Could the UK, no longer being a part of the EMA, delay the availability of new medicines in the UK? I'm aware of concerns raised that because the UK will be seen as a smaller market for new drugs compared to the EU, companies are therefore more likely to prioritise the authorisation of new drugs in the EU rather than in the UK. Has the Minister made any assessment of this? Can the Minister please tell the House what the implications of a no-deal will be on clinical researchers who are EU nationals? Will the UK also be eligible for EU funding for clinical trials with a no-deal scenario? The UK is currently one of the largest recipients of funding for clinical trials, and I'm concerned about the implications that this will have on future trials and opportunities. The MHRA will have the power to publish its own guidance on clinical trial applications and applications for an ethics committee opinion, as well as the declaration of the end of the clinical trial and the content of documents forming the trial master file. Can the Minister say whether the MHRA will be able to continue to work with the EU states in order to keep regulation in line with the EU? And will the Minister review important details such as ethics where concerns are raised? Now, in July 2017, the then Health Minister, Lord O'Shaughnessy, said that in the event of a no-deal, the Government would ensure that any system put in place would not impose any additional bureaucratic burdens. Can the Minister reaffirm this commitment today? I know that this piece of legislation was subject to a consultation and that because of concerns raised, amendments have been made to the instrument laid before us today. So can the Minister please say whether any further amendments are expected to this and whether there will be a further consultation period? Finally, can the Minister please confirm that any changes made by this instrument will be communicated effectively to stakeholders in a timely manner? And with those few remarks, I will leave my comments there. Thank you.
Dr Philippa Whitford.
Thank you very much, Madam Deputy Speaker. As all of us know, Europe is the biggest research network in the world. bigger than China or America, and the UK and within the UK, Scotland have been major beneficiaries. As the Shadow Health Minister drew attention to, the European Medicines Agency provides a single licensing system, and countries outside Europe that are not major economies, such as Canada and Australia, face 6 months to a year's delay in accessing and licensing new drugs. But the EMA are not just a licensing body, they fund and promote research particularly into rare conditions and particularly into childhood diseases. Europe created the Comprehensive Trial Regulation System with Clinical Trials Directive in 2001 and the Good Clinical Practice Directive in 2005. But as was mentioned in 2014, a new directive introduced the EU Clinical Trials Information System and the new Trials Regulation System. This will actually be under the control of the EMA when it comes into force next year. It provides a single portal for sponsors to register, collaborate, analyse their work, and also provides workspaces for authorities and a public site that can promote to patients what trials are going on and the benefit of trials. It also contains Vigilance database on medicinal products that are not yet licensed, and that is critical during initial trials. The Medicines and Healthcare Products Regulatory Authority, or MHRA, will take on the full role of clinical trial regulation, including legislative functions currently carried out by EU bodies. This will obviously mean additional work and costs by the MHRA. I do welcome the government commitment to align closely with the new European regulations, but this isn't the same as being part of a single collaborative system. I note the UK government plan to recognise sponsors in the EEA as an approved country, and this is one of the amendments that was made to minimise upheaval. But it does mean there won't be any compulsion to have a legal representative or lead researcher here in the UK. Clinical trial sponsors must report any suspected, unexpected, serious or adverse reactions, or SUSARs as they're known, to the EU database, and currently they can do that in a straightforward fashion from the UK. Similarly, any SUSARs registered elsewhere in Europe are entered into this database, highlighting concerns at the earliest point during trials. Many of us will remember safety trials carried out on human subjects that resulted in major damage. It is critical that the UK is not operating in a vacuum. Before licensing, particularly in the early stages of safety, dosage or phase 1 trials, investigational medicinal products are used, and these are unlicensed. They must be certified, as the Minister mentioned, by a qualified person based in the EEA. If they are made in the EEA or in a third country, it is critical that they are certified by a qualified person. For IMPs made in a third country, the importer must have a manufacturer's import authorisation, and they must QP certify the product before supplying it. Unfortunately, what this is going to mean is that bringing a drug into the UK to take part in a Europe-wide trial and exporting an IMP to Europe from a UK pharmaceutical firm is going to definitely introduce bureaucracy. So it is bizarre to talk about not having additional bureaucracy. This simply describes the extra licenses that will be required. MHRA will publish data on UK trials, but there is no promise that these will also be hosted on the EU Trials Information System. So simply creating something separate does not replace our collaboration across Europe. What we see is duplication, obstruction and expense. And I'm sorry, all of these are the enemies of collaboration. And this defines the loss that is Brexit.
Dr. David Drew.
Thank you, Madam Deputy Speaker. I shall make some very brief remarks. Can I just start by thanking the Department for an actual impact assessment I've been to too many SIs now where there is no impact assessment, so at least we know what we're talking about. So I congratulate the department for that. Now, I've just got 3 very brief points to make, which I hope that the Minister will be able to answer. I mean, firstly, we have 2 of the top 10 pharma companies who have HQs in the UK. That's GSK and AstraZeneca. And that matters because there's a lot of evidence that where you've got your HQ, that's where you put a lot of your investment into the clinical trials. So my first point is we need to maintain that hegemony, if you like, and make sure that we keep these trials in this place. So what is the government doing to make it very clear how it wants to guarantee both investment in the industry, but also into the clinical trials? The second point is that how concentrated this industry is. Now, I know more about animal medicines because of my involvement with the Shadow DEFRA team. I mean, the reality is that a decision, for example, the bovine TB vaccine that was needed to vaccinate badgers in the BTB trial, that had to end because you couldn't get the vaccines because they were needed for human use, and there was one major company in Paris. Now, that just shows up what this industry is really like, and that is why I'm fearful if we don't get this right, it will drift to other parts of the EU and we will lose out. And my third point is the one about barriers. It isn't just about resource, if you like, physical resources, the drugs themselves and the chemicals that are needed. It's about people. And we will need to make sure, particularly if we were to crash out, heaven preserve, but if we were to be in a very difficult position, how is the Minister intending to make sure that the key people are able to get transferability between the UK and the rest of the EU? And that will, of course, be heightened because there's an enormous pressure on the MRHA because of the nature of a crash out. So it would be useful to know from the Minister what we're going to do on the people side to make sure that we do genuinely defend this industry. Like many other members, I've got important health investment in my constituency in the terms of the farmer companies. So it really does matter to us all that we know that there is some certainty in what is a very uncertain process.
Minister. Thank you, Madam Deputy Speaker, and I thank all honourable members who participated in this debate, which is actually indicative of how vital we make sure that the legislative underpinning of clinical trials is continued safely, as the Honourable Lady outlined in her open comments. That's by far our biggest priority. We do need to continue business as usual. We need to continue to value our important pharmaceutical and life sciences sector and guarantee people's safety. I will just try and address some of the points that have been made today. The Honourable Lady mentioned the clinical trials regulation. And if it's implemented after March 2019, what that would mean in terms of adoption by the UK. We expect the clinical trials regulation to be implemented in late 2020, and the MHRA, the National Institute for Health Research and NHS have been working towards implementation of that regulation since it was agreed in 2014. The Withdrawal Agreement Bill will give effect to the implementation period in domestic law and will allow EU regulations to continue to apply directly in the UK for this time-limited period. If the clinical trials regulation comes into force during the implementation period, as is currently expected to, then we'd expect to apply that to the UK. If, however, we leave without a deal, which is why we have these regulations, the CTR will not be in force in the EU at that time, and so will not be incorporated into UK law on exit day. However, we intend to align where possible with the CTR without delay when it does come into force, subject, of course, to the usual parliamentary approvals, but that alignment will happen after the 29th of March 2019. The two key elements of the regulation that are outside of the UK's control, and this does not therefore cover, are the use of the shared central IT portal as the Honourable Lady mentioned, and participation in the single assessment model, both of which will require a negotiated UK-EU agreement regarding UK involvement post-Brexit. I think, again, it reiterates the wish expressed by the Honourable Lady and shared by myself that it would be by far preferable if we could leave the EU with a deal. Sadly, experience tells us that these things always go to the wire, but let's hope we get a resolution sooner rather than later. Mention was also made about patient safety by the Honourable Lady. Currently, a sponsor can report a suspected, unexpected serious adverse reaction at a SUSAR during the course of a clinical trial through the EU database. Similarly, all SUSARs originating outside of the UK, where the sponsor has an ongoing trial in the UK involving the same medicinal product, currently must be entered on the EU database. And clearly, we will need to find a way of ensuring that we can share those information arrangements and hold them on the MHRA database. Questions were also raised. Yes, indeed.
From the Minister's answer to that, does that mean that ability isn't there if the UK leaves without a deal for April of this year?
Being brutally honest with the Honourable Lady, and perhaps more honest than some people are in this debate, I don't think we can dictate terms to our EU partners. I think we can look forward to having constructive working arrangements with them, and it's in all our interest to do so. But ultimately, this is something we would have to seek agreements about. At this stage, this SI can only really cover the things that are in the gift of this government, and a lot will rest on good cooperation after the event, which again means it would be much more preferable to leave with a deal.
Grateful to the Minister for giving way. Given the great importance of joint venture companies and joint investment and joint activity across the Atlantic, will the government also be looking at changes in American regulation to see if any of that would be appropriate, or maybe a UK version could be better than both the American and the EU one?
My purpose this afternoon is to ensure that we have business as usual post-exit day and that we can maintain the patient safety at this time. And I wouldn't want to encroach into any debate beyond that this afternoon. Questions were raised regarding research funding, and I should advise the House that before the Brexit votes, the UK was involved in more EU-funded sciences projects than any other country. The UK has secured 14.3% of that total share of funding to date and is the second highest recipient of grant funding. But we are committed to remaining a world leader in science and research, and that's why our modern industrial strategy, we have committed to spend 2.5% of GDP on research and development by 2027 and have invested an extra £7 billion in research and development as a first step towards that.
I'm very grateful to my royal friend for giving way. Does she have figures available? And I don't blame her if she doesn't, to her hands. She said just over 14% was received by this country through EU funds. What percentage of funds did we give to the EU to be distributed around the bloc?
Well, I don't have a detailed knowledge of the accounts of the funding with regard to that. I answered the question about how much we'd received and how we are replacing it, which I think is really the crux of the matter. Mention was also made about what the government was doing to prevent the loss of EU nationals working in research, and we've been very clear that we do wish the UK to continue to be an open and tolerant nation and continue to attract the brightest and the best, and that would be equally applicable here. The Prime Minister told the House of Commons on the 21st of January that we've listened to concerns and that when we roll out the EU settlement scheme, we won't charge any application fee, and we want to give the very clear message that we are open to business and open for the brightest and the best. In conclusion, Madam Deputy Speaker, in bringing these regulations to the House, I think the central point is that the fundamentals of how clinical trials operate will remain the same, that wherever possible we've sought to maintain existing arrangements rather than create new ones, And whilst not the focus of this SI, the Government is working to ensure that the trials can have continuity of supply and will continue as planned. And I commend these orders to the House.
Yeah. The question is motion number 4 as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Now, we now come to the general debate on the NHS 10-year plan. Colleagues will notice that there is a bit of a time issue here. I know the front bench spokespeople are going to be considerate of this, but I think it's only fair to warn colleagues that I will impose an immediate 3-minute time limit on backbench speeches. I call the Minister to move. Minister Stephen Barclay.
Well, thank you, Madam Deputy Speaker.
Let me do that again. I call the Minister to move. Minister Stephen Hammond.
Thank you, Madam Deputy Speaker. You'll understand that I'm pleased with that rather than having to follow my predecessor's responsibilities. Last year's 70th anniversary celebrations prove that the NHS is one of the country's proudest achievements. And we all know that, judged by the number of people who want to contribute to this debate this evening. So I shall be as brief as I possibly can. The Government's top funding priority is the NHS. By 2023-24, budget will increase by £33.9 billion in cash terms, which is the equivalent of £20.5 billion in real terms. This means that in 5 years' time, the total NHS budget will be £148.5 billion. In January this year, the NHS published the long-term plan which sets out the priorities for the next 10 years of service. The additional funding has given the NHS the stability and the certainty it needs to make that plan for the decade ahead. And this plan is a historic moment for patients across the country. It was developed by NHS leaders and clinicians in consultation with patients and the public. And therefore, members can be assured that the plan focuses on the biggest priorities for patients in the next decade. It includes, very briefly,
Grateful to the Minister. Will they in the plan make sure that in an area like mine with very fast growth and lots of new housing, there will be adequate resources to put in new surgeries and additional capacity, because that hasn't happened in the past?
Well, my right honourable friend will notice that part of the plan is the transformation that we will bring to primary care, and that looks at not only how primary care is going to be developed and delivered, but also how much ensuring that there is enough money to deliver that as well. As I was about to say, the importance of this plan is it sets out a scheme that will show that the best support for patients throughout their entire lives, from getting the best start in their life to being supported into old age. The plan sets out transformation that is needed at every stage of the health system to ensure that it can continue to provide world-class care. And part of that, as I've just said to my right honourable friend, is a fundamental shift towards primary care and prevention. The plan aims to keep and will keep people healthy and out of hospital by boosting services closer to home. It commits... I'll give way.
The Minister giving way. The long-term plan acknowledges that life expectancy continues to improve for the most affluent 10%, but has either stalled or fallen for the most deprived 10%. In Sheffield, for the most deprived women, their life expectancy has fallen by 4 years in the last 9 years, whilst this government has been in power. Does the Minister have any analysis of why life expectancy has fallen for the most deprived women on his watch?
I'm sure there'll be an excellent number of questions and excellent interventions. That is a very good question. There is all local health systems will be expected to set out in this year how they are going to reduce health inequalities by 2023-24, which is set out in the plan. And so there will be an attention to look at exactly those health inequalities the Honourable Lady mentions. The additional funding will also, for the primary sector, ensure that primary medical and community health services such as GPs, nurses, physiotherapists, you'll see the spending on that increase by £4.5 billion in real terms in the next 5 years. And through this additional funding, there will be up to 20,000 extra health professionals working in GP practices, with more trained social prescribing link workers within primary care networks. And by 2021, all patients will be offered a digital-first option when accessing primary care. The plan also must look at the future of the health system. And so there are proposals for new proposals for integration, which offer the most deepest and most sophisticated ever proposed by the NHS. I will give way.
I thank my friend for giving way. In the plan, there's also a recognition that some of the 2012 legislation was made in error on some of the transference of powers to public health bodies and indeed to local authorities. The admission to that, though, from my reading of the plan, is addiction services. And if we're serious about mental health, if we're serious about improving the care and reducing health inequalities in areas like Sheffield, as was just raised, we need to get the commissioning of addiction services right and transfer that back to the NHS, because it's treating some of the most vulnerable patients. And at the moment, they're underfunded and they're failing to treat people, and the taxpayer is actually paying the price. And I wonder if my honourable friend could take that up and give that a bit of a push, because it's very badly needed for patients.
Well, my honourable friend makes a very good point, and he urges me to take the issue up, and I will. He is obviously an expert in this field. He will know that the government has asked the NHS to come forward with some proposals for legislative reform to support the ambitions of the long-term plan. And I will reflect his comments in my thinking on that. By 2021, every part of the country will be covered by integrated care systems, which will bring together local organisations, including local authorities, to redesign care and improve population health. They will become the driving force for coordination and integration across primary and secondary health. And any claims that these reforms might lead to privatisation are misleading. In fact, the Health and Social Care Committee chair has said that these proposals will not extend, and I quote, will not extend the scope of NHS privatisation and may effectively do the opposite. Madam Deputy Speaker, the NHS will invest more in preventing ill health and stopping health problems getting worse. This includes offering tobacco treatment services to all inpatients and pregnant women who smoke, establishing alcohol care teams and offering preventative treatments to more people with high blood pressure and other risk factors for heart disease.
My honourable friend, as he's probably slightly aware, I have another part-time job, and that part-time job is dealing with a preventable disease, which is caries. We spend 34 to 38 billion on dentistry, curing, helping a preventable disease. Would he consider looking seriously at the way in which we could persuade local authorities to put fluoride into the water supply to prevent it?
Well, my right honourable friend will know that in the plan there is much to do with prevention for primary care and also for public health. I will listen carefully and offer to meet my honourable friend, but he tempts me down a line tonight that I'd rather not go down. The long-term plan also marks a huge step towards the parity of esteem for mental and physical health. In the next 5 years, the budget for mental health services will increase by at least 2.3 billion in real terms. This additional funding will be used to fund a major expansion of mental health services for both children and adults. In addition to piloting 4-week wakes for children and young people, we'll also test waiting times for adult and older adult community mental health teams, and clear standards will then be set. Specific waiting times for emergency mental health service will take effect for the first time from 2020 and will be set to align with equivalent targets for emergency physical health services.
Very kind of him to give way. Could he please clarify? Currently, the mental health budget is 10.82% of the current NHS budget. So if the overall budget increases, that actually amounts to an equivalent rise. So actually the percentage allocated to mental health is not more. It is more overall, because the overall budget is increasing, but the percentage isn't. If we're serious about tackling mental health in this country, why isn't the proportion being allocated to mental health higher than what it currently is?
Well, the Honourable Lady will know, as I said a moment ago, that this plan sets out for the first time putting mental health and physical health on a parity, and it will be an increase of 2.3 billion by 2023-24. And of course, all of that we've been talking about here, Madam Deputy Speaker, needs to be supported by new innovations and technology. Patients can expect the radical reshaping of how the NHS delivers its health and care using technology so that services and users can benefit from the opportunities of advance in digital technologies. And those technologies include making care safer, enabling earlier diagnosis, giving more independence to those managing different health conditions. Additionally, it's vital that we build a more innovative NHS. This will help patients to be amongst the first in the world to benefit from life-changing new technologies. Last year, the Secretary of State announced his ambition to sequence 5 million genomes in the next 5 years, making the NHS the first national healthcare system to offer whole genome sequencing as a part of routine care. And most importantly, none of this would be possible without the dedicated staff who are properly trained and supported throughout their career. The long-term plan sets out a strategic framework to ensure that over the next 10 years, the NHS will have the staff it needs. To ensure that detailed plan can be implemented, Baroness Harding is leading an inclusive programme of work to set out a detailed workforce implementation plan, which will be published this spring. But this plan is not about numbers. I'll give way for the last time.
Thank you. I'd like to thank my honourable friend for giving way. And just on the issue of future workforce, may I thank the government for investing in our new medical schools. We are enormously proud of the new medical school in Chelmsford, which is training 100 doctors a year. I understand places are 12 times over subscribed for next year. And I'm also very pleased to hear nursing numbers are up. But can he explain what the government will do for targeted support for areas such as mental health nurses and adult nurses, where we've seen the numbers drop?
Well, my honourable friend is right. We need targeted support, and that's why we've looked at not only at the increasing the recruitment of nurses, but also the retention packages that might be offered, particularly for certain specialities. She mentions mental health nurses. We've looked at the possibility of issuing some golden hellos. We've also looked at targeted targeted support for childcare, and also some travel support. And I think, for the last time, one of my distinguished predecessors.
My honourable friend's being very generous. I welcome the Workforce Implementation Plan initiative, and that Baroness Harding, the chair of NHS Improvement, will be taking this work forward. Will my honourable friend ensure that she looks at one of the issues raised in a number of areas in relation to retention of senior staff, experienced GPs under the general practice forward view? We are losing too many of them too early in their career, and similarly experienced consultants in our hospitals. Would he please pick up with the Treasury one of the contributing reasons to this being the annual allowance for pension contributions, where tax payments take away the extra income that they get at a gross level as they progress through their later years?
I've listened very carefully to my right honourable friend's intervention, and he'll be pleased to know that the discussions with the Treasury are ongoing about certain potential incentives to senior serving staff. The plan also, Madam Deputy Speaker, it's not just about numbers. It's focusing on the right people with the right skills in the right place, ensuring that our dedicated staff are supported, valued and empowered to do their best, with clear commitments to tackle bullying, discrimination and violence, and a programme of work to sustain the physical and mental health of the staff who work under pressure every day and every night. The very last time.
I'm grateful to the Minister. And all good policy should be evidence-based. So can he tell us, in relation to the National Cancer Advisory Group, which prepares an annual report detailing the progress of the cancer strategy each year, that report was delayed. It was expected in October, November. When will that actually be published? It may well inform the work of the 10-year plan.
Well, the date for the publication has not yet been finalised. I understand it will be soon, but I will write to the honourable gentleman and confirm the date of publication. Madam Deputy Speaker, through the long-term plan, we will ensure the NHS continues to strive to be the world leader. It will continue to push the boundaries between health and social care and between prevention and cure. It will be at the cutting edge of technology and innovation while providing high-quality service for all patients. And more importantly, it will always be there in our hour of need, free at the point of use, based on clinical need and not on the ability to play. Madam Deputy Speaker, I commend the long-term plan to the House.
The question is that this House has considered the NHS 10-year plan. Shadow Secretary of State Jonathan Ashworth.
I'm grateful, Madam Deputy Speaker, and I thank the Minister for his brevity, and I'm sure the House will appreciate the way in which he both took a number of interventions but also made his remarks speedily, and I will try to endeavour to copy him as well. I can hear this from the opposite side. I start where the Minister almost concluded by thanking the NHS staff for the work that they do day in, day out. Now, he is a relatively new Minister to the post, so new that you, Madam Deputy Speaker, gave him a different surname, but we'll gloss over that. But he's still a relatively new Minister to the post, but he inherits his portfolio after a time in which the National Health Service has suffered the severest financial squeeze in its 70-year history. Indeed, at one point under the Conservative spending plans for National Health Services, on a head-for-head basis, money was set to fall. Indeed, they have now revised the spending plans. But because of that financial squeeze over many, many years, he inherits a portfolio where 4.3 million people are on the waiting list and 2,237 people wait beyond 12 months for treatment. He inherits a portfolio where over 2.9 million people waited beyond 4 hours in an accident and emergency department, where over 27 or nearly 27,000 people wait 2 months for cancer treatment. And what it means is that the 18-week referral to treatment target hasn't been met since February 2016. The cancer target hasn't been met since December 2015. The diagnostic target not met since November 2013. And the A&E target not met since July 2015. These are targets all enshrined in the NHS Constitution, contained in statute, and were routinely delivered under the last Labour government and now effectively abandoned under this. And these access standards, I will do, but okay. Yeah.
I thank him for giving way. People in Ashfield have to wait longer than most people in the country for a GP appointment. 23% waited over 2 weeks, 15% over 3 weeks. Does he agree with me that one of the many brilliant things the last Labour government did was introduce that 48-hour target to see a GP?
Well, I mean, the last Labour government introduced record investment in the National Health Service, voted against every step of the way by that party, which delivered some of the best waiting times on record and some of the highest satisfaction ratings for the last Labour government, and increased access to GPs in constituencies like Ashfield as well. Now, the A&E standard, which I've mentioned, is important not just maybe develop this point, is important not just for patients waiting in an overcrowded A&E, but because it tells us much about flow through the hospital. And yet last week we had the worst A&E performance data since records began, with 76.1% attending Type 1 A&E seen discharged or admitted to a ward in 4 hours. Behind these statistics are real stories of patients left waiting in pain and distress, stories of the elderly languishing on trolleys. In fact, we've seen trolley waits of 618,000 in the last year, of patients, their dignity, patients without dignity, at risk of cross-infection. And there is no roadmap at all in the long-term plan to restoring these access standards. And of course, the A&E standard is being revised in the long-term plan, even though the Royal College of Emergency Medicine have said, in our expert opinion, scrapping the 4-hour target will have a near-catastrophic impact on patient safety in many emergency departments that are already struggling to deliver safe patient care in the wider system that is failing badly. I hope when that review reports, we can have a full debate in the House. I'll give way to the Honourable Gentleman.
Thank the Honourable for giving way. And he's right to highlight the Blair's government's injection of cash into the NHS and the meaningful difference that made to many patients' lives. But on the point of waiting time targets, if we're serious about mental health and physical health having parity, we should reflect upon the fact that historically there haven't been targets in mental health for access of anywhere near the same standards that there are for physical health. And I wondered if he would join with me in urging a rethink of that and a much greater push for access targets for mental health services as a way of raising standards and improving time for patients to get care.
The Honourable Gentleman makes an important point, and there are actually elements of the long-term plan that we welcome, including the access targets for mental health. We would also welcome, for example, the commitment to save 400,000 lives, although there's no actual detail in the plan about how those lives are going to be saved. We welcome the rolling out of early cancer diagnostic and testing centres. After all, it was a policy I announced in the 2017 general election. We welcome the rollout of alcohol care teams in hospitals. Again, it's a policy I announced at the Labour Party conference last year. We welcome the commitments on perinatal mental health, again, because it's a policy that we have announced previously. We welcome the commitment for preferential funding allocated to mental health services. Again, it's a policy that the Labour opposition have announced, but we will need to study carefully the details of that, as the Honourable Lady from Oxford was mentioning. But this point about mental health, which the Honourable Gentleman who sits for an Ipswich seat is well made, because we face a situation where at the moment 3 in 4 children with a diagnosable mental health condition do not get access to the support they need. CAMS are turning away over a quarter of children referred to them for treatment by parents, GPs, teachers and others. This is quite disgraceful. So I hope the extra investment in mental health services reaches the front line quickly, and I hope perhaps the Minister, who in summing up at the end of the debate, could give us more details about when we can expect to see progress on that front. We do welcome the Honourable Gentleman from Bristol.
I thank my honourable friend for giving way. Does he agree with me that in hospitals like Southmead Hospital, one of the largest in Europe in my constituency, that all of this debate about delivery on the front line requires a workforce that's able to meet the demand? And does he therefore share the comments from the King's Fund that says that this government hasn't just failed the tests on the workforce, but didn't even turn up for the exam?
The Honourable Gentleman from Bristol makes a very well-made point. I'm going to come on to workforce in a few moments, but let me just pick up the point that my honourable friend from Sheffield was making, because there is recognition in this document that widening health inequalities is becoming a more important issue that we need to confront, because after years of austerity, with poverty rates increasing, with child poverty at 4.1 million, we now see a situation in this country where life expectancy is stalling for the first time in 100 years and actually going backwards in the poorest parts of the country, and that child mortality rates for children born into the most deprived of circumstances has actually increased. The truth is, poorer people get sicker quicker and die earlier. For me, as a socialist and a Labour politician, that is shameful. We should be creating the conditions where people live longer, healthier, happier lives, and it's why we need to end austerity across the board. So the focus on health inequalities is welcome, including the quite stark recognition that inequalities, that inequalities are costing the NHS £4.8 billion a year and admissions. That is remarkable. Honourable Gentleman.
I'm very grateful to my honourable friend for giving way, and I would just like to concur with the points that he's made about the benefits of our Labour health policy and how the government should do much more to fund healthcare in this country. Would he agree with me that there's a particular problem in many high-cost areas of retaining public sector workers, and that in areas like Reading and Oxford, indeed my honourable friend for Oxford is sitting in front of me, there's severe pressure on the NHS because of the relatively low pay for many skilled staff?
Absolutely, and I'm just going to come on to workforce in a second. But overall, there are welcome commitments in the long-term plan. We've counted up 60 commitments to improve, expand or establish new services, but sadly there's no detail on how they're going to be delivered. So the commitments around expanding access to general practice, which the Honourable Gentleman referred to, and yet where is the plan to recruit the workforce that we need in the National Health Service? When the previous Secretary of State came to the House last June, he said there would be a full workforce plan. Not an interim plan, chaired by Dido Harding, a full workforce plan to coincide with this long-term plan. It's been delayed, and there's no details about training budgets because they've got to wait for the spending review. We have 100,000 vacancies across the National Health Service. With think tanks warning, we'll have 250,000 vacancies unless we do something. We cannot wait for this workforce plan. We need action now. Also missing from the long-term plan was any serious investment in public health services. And this is picking up another point which the honourable gentleman from Ipswich made a few moments ago. Public health services are being cut again this financial year under this government. And when you take into account the cuts to public health services, the cuts to infrastructure, the cuts to training, there's actually a £1 billion cut to health spending this year. And the cuts to public health are equivalent to 1,600 fewer health visitors, 1,700 fewer school nurses, 3,000 drug workers. They mean our constituents become sicker and demands on the wider NHS become greater. So drug and alcohol services will be cut this year by 34 million when the unmet need for alcohol problems has risen to 600,000 and admissions to hospital where alcohol is a primary factor has increased by 13%. Smoking cessation, let me just finish this point. Smoking cessation services cut. Obesity services cut. Cuts to health visitors and early years initiatives correlating with a fall in vaccination rates and admissions to hospital for whooping cough up by 59%. And let me just finish, and then I'll let the gentleman come in. Deep cuts again to sexual health services at a time when infections like syphilis and gonorrhea are increasing. And these cuts to sexual health services are impacting on women's reproductive health, with experts expressing concerns that the use of long-acting reversible contraception is decreasing. We're seeing abortion rates amongst the over 30s increasing, and now 8 million women live in areas where funding for contraception has decreased. And let me just read the House a quick extract from the Health Select Committee from my honourable friend, and I will still call her my friend, from Liverpool Wavertree, and I am desperately sad that she feels that she's had to leave the Labour Party, and I hope the Labour Party will get on top of this anti-Semitism issue. But she asked at the Health Select Committee about the health consequences of delays in accessing sexual health services. And Dr Olwen Williams from the British Association for Sexual Health and HIV responds, quote, "We are seeing neonatal syphilis for the first time in decades in the UK, and neonatal deaths due to syphilis. We are seeing an increase in women presenting with infectious syphilis in pregnancy, and that has dire outcomes." And these public health cuts were endorsed in the long-term plan, not reversed. So I'll give way, and that's my final.
I'm grateful for the honourable gentleman giving way. He talked about a few different topics, but I think I heard him say that there was an overall cut in the health service, which when he was welcoming some of the moves of the government, in the 2017 manifesto, the Labour Party committed 2.2% increase, whereas this government has committed 3.4% increase. So I hope he would welcome that increase as well.
We committed more in the 2017 manifesto than the Tory party did, than the manifesto that you fought an election on. And the reason the Tory party have revised their spending plans is because of pressure from the Labour opposition, Madam Deputy Speaker. Now, Madam Deputy Speaker is wanting me to hurry up. So the final point I want to make is this. The most intriguing part of the long-term plan is the remarks that the Health and Social Care Act has created a complete mess, hindering integration, and proposes scrapping the so-called Section 75 provisions. Well, we don't want to say we told you so, but we did tell you so, Madam Deputy Speaker, and Tory MPs should apologise for voting that Lansley Act through the House of Commons. But if they are going to support NHS England's call to get rid of the Section 75 arrangements which propose privatisation, why don't they block the £128 million worth of contracts that are currently out to tender? Otherwise, if they don't, it will be clear that the Tory party is still committed to privatisation in their National Health Service. The truth is they've spent nearly 9 years running down the NHS, refusing to give it the spending it needs. They are privatising it still. There will be a £1 billion cut to the NHS this year. It's Labour who will rebuild the National Health Service.
Lucy Allen.
Madam Deputy Speaker, for calling me to speak in this very important debate, and I welcome the 10-year plan, and I particularly welcome the emphasis on delivering care closer to home. Now, the future of the NHS is the greatest concern to my constituents in Telford, because local health bosses have been deliberating for the last 5 years on whether to move our A&E and our women and children's services out of borough in a project that they have named NHS Future Fit. Now, on the 29th of January this year, local health bosses announced that they will indeed remove these services and transfer them 19 miles away to the other side of Shrewsbury, and that they plan to create, in addition, a new super hospital on the same site. The project is going to cost a record £312 million. Now, my opposition to this project has been long-standing because it does not meet the needs of local people. It does not improve health outcomes, and it does not focus on narrowing health inequalities. And I believe that if local hospital management understood the people of Telford better, they would not have come up with this plan. Telford is a rapidly growing new town with people coming to live here all the time, and it's an area with pockets of significant deprivation, and by any measure it fares significantly worse when it comes to health outcomes, life expectancy and numbers of children living in low income families than does the Shropshire area, which fares better than England's average and when it comes to measures of deprivation. There is, in my view, some very important points that we have to consider when making a transfer of assets from an area of need to an area of affluence, because such an action is wholly inconsistent with the ethos and obligations of the NHS. Now, some have called my opposition parochial and territorial, and if I somehow better understood the plans, then maybe I would view them in a different light. But as a former non-executive director of a hospital trust, and as someone who has been working with constantly changing senior executives of the local hospital trust, engaging in the detail of this plan since the inception in 2013, my opposition is based on the understanding of the healthcare landscape and local need. I would just like to make several points, 3 points, before I complete. We have to ask the question, does this scheme meet the needs of local people? Is there any evidence that health outcomes will be improved? Is there any evidence that we will narrow health inequalities? Will out-of-hospital care make up for the reduction in planned medical beds and hospital staff? Put simply, it may look good on paper, but will it work in Shropshire? So I have asked the Minister to call in this scheme for review, and I very much hope that he does so.
Dr Philippa Whitford.
Thank you very much, Madam Deputy Speaker. I welcome the principle of the long-term plan, as it certainly makes it easier for those who are running the health service, particularly after over 8 years of real terms cuts over the term of the last 3 governments. It is trumpeted that it will be 20 billion extra by 23-24, but that's still quite some time away. And if you look at it on an annual basis, that's 3.4% uplift. That's better than the real term cuts, but less than what the NHS got in every year from its inception to 2010, and actually less than the 3.6% promised by the Prime Minister last August. It has little recognition of the growing demand, and it should be considered per capita. In Scotland, we spend £163 per head more on health than is allocated in England. And just having an overall figure and not recognising the growing demand on those services is unfair. It again focuses all the money on NHS England, basically to make it sound good, with cuts for public health and insufficient funding to training or capital projects, and again insufficient funding for social care. Social care will get a 2.9% increase, but it's estimated the pressures are growing at nearly 4%, and it can't meet unmet need. Age UK estimate that 1.2 million people across the UK are not getting the care they need. And in England, although need has almost doubled since 2010, local authority-funded patients are down over a quarter. Again, in Scotland, we allocate £113 more per head for elderly care, which allows us to provide free personal care and keep people in their own homes as long as possible. If they are able to be in their own homes and not in hospitals or even care homes, that is actually more cost-effective. And we are still waiting for the Green Paper, which I seem to have been hearing about almost since I was elected. The Secretary of State talked about the prevention agenda and prevention being better than cure, but public health will be cut by £200 million. This comes on top of the £500 million it has already faced since 2014-15. An honourable member opposite already mentioned the issue around alcohol and addiction, and we've heard about cuts to sexual health services. But the long-term plan talks about reducing the burden of cancer, but it doesn't talk at all about the cuts to smoking cessation or an obesity strategy that does actually do something about advertising up to 9 p.m. of junk food to children. The Secretary of State has previously mentioned make every contact count. This has been in place for most of my career. And when I'm dealing with a breast cancer patient, I always get them to promise me that once we've got through the stress of their treatment, they and their partner will promise me they will try to give up. But I can't deliver their smoking cessation. I still need a service like Fresh Ayrshire that I can refer them into, where they will get the support to actually achieve it. As has been mentioned, the biggest challenge of all is workforce. It runs right through the long-term plan, and the long-term plan will not be deliverable unless workforce is dealt with. NHS England faces 100,000 vacancies, including 41,000 nursing vacancies. Yet Health Education England isn't facing an uplift in its funding and has previously faced a real terms cut. The Minister talked about the move to community, but there's a 50% cut in district nurses. And in 2021, there won't be any graduating because the course is being lengthened. That isn't going to support moving services into the community. The nurse vacancy rate is 11.6% in England. That's more than twice the rate in Scotland. Indeed, Scotland is already at the target, which is supposedly the target for NHS England by 2028. In actual fact, the RCN estimate that in the next 10 years, vacancies will grow to 48,000. That creates more stress on staff, encourages more people to leave, reduces quality of care, and increases waiting times. It is absolutely critical to tackle this. But what do? We have the removal of the nursing bursary and the introduction of tuition fees. We didn't do that in Scotland, and that's why we have a 14% increase in the number of students starting degree courses. In England, it's actually down 4%, and while the Minister may well respond about apprenticeships, there was only 300 apprenticeships taken up in 17-18 instead of the 1,000 that was trailed. So that doesn't replace the 900 drop in degree students. That means you're simply not producing enough nurses to ever fill this 41,000 vacancy rate. And with a 90% drop in those coming from the EU, this is only going to get worse. The Secretary of State loves to talk about digital. I have to say, to me, he seems to have a bit of an obsession with replacing GPs with apps. As a surgeon, I can't promise you that rubbing your mobile phone over your belly will diagnose your appendicitis, so good luck with your app. But there are things within the NHS where IT could really help. In Scotland, we have a system, PACS, where imagery can be looked at by radiologists elsewhere in the country. We have electronic prescribing that saves time and effort, as well as being a safety action, because you can't prescribe a drug to which the patient is allergic, and it will pick up interactions. And electronic records make cancer pathways easier. The government's response is integration, and I have supported this on multiple occasions within the chamber. But it's important how it's done. The NHS in England has gone round and round the loop of reorganisation. It is critical that these integrated care systems have a statutory body at the top. It is critical that Section 75 of the Health and Social Care Act is repealed to stop forcing contracts to be outsourced. And also the issue of tariffs. Tariffs reward hospitals for admitting. It is important that people are treated in the community. And finally, we're only going to make a difference when the government takes a health in all policies approach. Poverty is the biggest driver of ill health, so stopping the welfare cuts would be a good start.
Priti Patel.
Thank you, Madam Deputy Speaker. I welcome the Government's commitment to the 10-year plan, and I would like to commend ministers in particular for the way in which they've been presenting the plan, and importantly, how the additional funding will provide a strong foundation to transform the NHS and healthcare services across our communities. And one of the key challenges the NHS faces is how better to deliver primary care and, importantly, integrate services at a local and a community level. Of course, course, the NHS has to meet growing demand, changing demographics. And the Minister will know, across my constituency in Witham, there is considerable population growth. The town of Witham is set to grow by 20%, but as our healthcare services naturally are unable to keep up with this growth and demands. And amongst the 4 practices in Witham Town, the patient-GP ratio is a staggering 2,500 to 1, which is 50% more than the national average, while in other parts of my constituency, which are more rural, it is twice that level at 3,400 to 1. And of course, we all know the pressures of growing demand. All right honourable and honourable members will know about constituents contacting them when they struggle to get local appointments. So it is right that this plan looks to how we can rethink in terms of how we deliver primary care, bring new partners on board, integrate the services, inclusion mental health and other aspects of local delivery, provide more for one-stop shop for assessments, minor treatments and community services. And hence the Minister will know of my own local campaign in Witham Town to secure a new healthcare. But importantly, this plan speaks about how it will improve outcomes for patients. And that is something no member of this House can lose sight over, including reducing pressures when it comes to acute hospitals, integrating health and social care, mental health, and of course wellbeing services. So for my constituents, the key litmus test of this 10-year plan is naturally the delivery of a new facility in Witham Town, but also how we can ensure that that money can encourage better collaboration, investment in services, and importantly, make sure that we can improve the NHS across all our communities.
Mike Hill.
Madam Deputy Speaker, a couple of weeks ago in the train station cafe in Hartlepool, a constituent of mine told me that her husband had stood outside the GP surgery, their local GP practice, to get her an emergency appointment, only to be told there were no appointments that day. Madam Deputy Speaker, this is not an uncommon occurrence in Hartlepool, where it is becoming increasingly more difficult to access a GP. This is not the fault of the GP or the practice, but it is a consequential effect of too much of a burden being placed on GPs over the running of CCGs and a fall in GP numbers. The Government is calling for a major expansion of primary care and community services, saying that it is central to reducing the burden on hospitals and that they intend to introduce new 24/7 rapid response teams. While we are making great strides in Hartlepool to tackle community and primary care needs with ambitious projects in the pipeline, such as the creation of a Centre of Excellence, improving access to GPs is vital. I welcome the pledges and the plan to improve cancer care and diagnosis. I welcome also a greater focus on childbirth. In 2017, there were only 3 deliveries in the midwifery unit at Hartlepool Hospital, put it under great threat. Now there are positive plans to bring about return of full maternity services there, including a maternity hub, and guarantee the right of future citizens to be born and registered in our town. Madam Deputy Speaker, a lot of cross-party and multi-agency work has gone into this, and I hope that under their 10-year plan, the Government pledges to support these initiatives. Finally, Madam Deputy Speaker, I welcome the admission that we need to see improvements to mental health services, considered for far too long to be the Cinderella service. Particularly for people in crisis, I would like to see improvements to emergency and urgent care, including the creation of local walk-in centres. There is a growing need also to tackle mental health problems for children and young people, and the announcement of a new NHS mental health workforce dedicated to supporting children in schools has been welcomed by many, including Bernardo's. But the charity has concerns about early intervention and waiting times for assessment and treatment. Javed Khan, their Chief Executive, said the Government does not show enough action on how, as a society, we are going to stop sleepwalking into a children's mental health crisis. Madam Deputy Speaker, I completely agree with him.
Henry Smith.
Madam Deputy Speaker, thank you very much for calling me to speak in this debate on the NHS long-term plan. I have the privilege of being the chair of the all-party parliamentary group on heart and circulatory disease, which I took over the chairing of last year, and I was very pleased to set up in 2016 the all-party parliamentary group on blood cancer, and I'd like to briefly speak on both of those in turn. With regard to blood cancer, there are over 130 types of blood cancer, each with their own unique symptoms, treatments and side effects. It is the 5th most common cancer in the UK, and sadly the 3rd biggest cancer killer, with around 40,000 people diagnosed with blood cancer each year. And its rate of affecting people is far greater than breast cancer or prostate cancer combined. Indeed, 1 in 19 people will be diagnosed with a blood cancer in their lifetimes, and there are around 240,000 people currently living with blood cancer in the UK. The NHS long-term plan sets out a number of areas that affects blood cancer. On early diagnosis, the ambition is to have 75% of all cancers diagnosed by stage 1 or stage 2 by 2028, and that is welcomed, as many blood cancers are very difficult to diagnose at an early stage. A recent parliamentary answer from my honourable friend, the member for Winchester, to my honourable to the honourable member, the member for Scunthorpe, stated that there are 17 cancer sites for which no staging system exists, and 67 cancer sites which are unstageable. Some blood cancers fall into these categories, and I'd be grateful for clarification and assurances that these will be addressed. Again, very briefly, turning to heart disease. Heart and circulatory disease still causes a quarter of all deaths in the UK, on average killing 1 person every 3 minutes or 420 people each day. The number of people living with heart and circulatory diseases also remains high at 5.9 million people across England, and there are over 42,000 premature deaths from cardiovascular disease each year in the UK. The NHS long-term plan, I'm delighted to see, has renewed focus on prevention and early detection of the risk factors of heart and circulatory diseases. 4 in 10 adults with high blood pressure remain undiagnosed, and among those who have been diagnosed, it's estimated that 1 in 5 are not being optimally treated. By identifying more people who have these conditions, we can help manage their risk and save more money and, of course, crucially, lives. I welcome the work that the voluntary sector does in supporting the NHS, and I'm grateful to the government for investing £20.5 billion more each year for the next 5 years into this much important service.
Thank you, Madam Deputy Speaker, and thank you for calling me in this debate. It's a pleasure to follow the honourable member for Crawley, and I'd like to declare an interest as one of the vice chairs of the APPG on radiotherapy, and also as a cancer survivor who was successfully treated with both chemotherapy and radiotherapy thanks to an early diagnosis. About 1 in 4 people receive some form of radiotherapy during their lives, and almost half of us in the UK will be diagnosed with cancer at some point in our lifetime. These stark facts will, I hope, remind the government of just how important it is that we invest in modern and accessible cancer diagnosis and treatments. I want to talk in the brief time that I have about Chapter 3, Section 3.62 of the NHS 10-year plan, and more precisely about treatments using advanced radiotherapy techniques. On investment, the government have promised to complete the £130 million investment in radiotherapy machines and to commission the proton beam machines at University College Hospital London and the Christie Hospital in Manchester. However, I must point out respectfully to the Minister, this is simply a recycling of existing announcements that had already been made. So it is not a comprehensive 10-year plan for radiotherapy. As set out in the APPG's manifesto for radiotherapy, far more is needed over the next 10 years. Initially an investment of £250 million and then an ongoing investment of £100 million each year, re-announcing previous expenditure commitments falls far short of what is required, and it will not meet the stated objectives mentioned by other members of improving cancer patient outcomes through improved survival rates. Although it's needed in over 50% of cases, Madam Deputy Speaker, access to advanced radiotherapy in England is very patchy, varying from 25 to 49% depending on the region, far worse in some regions in the South West and indeed in the Westmoreland and Lonsdale constituency. The average is about 38%. Ideally, patients should not have to travel more than 45 minutes to access this form of treatment, and considerable additional investment is going to be required to achieve this. At the moment, there's nothing specific in the plan to address this very serious issue. The government says that they're going to increase increase the diagnosis of patients with stage 1 and stage 2 cancers. Again, we need more investment to do that. I would encourage all members of the House and indeed the Minister to read the manifesto for radiotherapy, which highlights the importance and the important benefits of increasing the percentage spend on radiotherapy.
I would encourage colleagues, the wind-ups will start at 10 to 7. If people are less than 3 minutes, it will help others. Nigel Huddleston.
Madam Deputy Speaker, if we're asking the NHS to be speedy and agile, I'm sure we can do so today in the House. I'm glad today to stand to talk about the great British institution that is the NHS and how we can improve and protect it under this plan. And of course, we do need to constantly transform and improve the NHS as our population grows and ages and treatment costs soar as we discover new but ever more expensive ways to treat previously untreatable diseases. Now, in Worcestershire, our acute hospitals are under immense pressure, with 10,500 A&E visits in January alone, and overnight bed occupancy rate of 93.7%. And this fits into a wider national trend of a 28% increase in hospital admissions over the last decade, and an NHS in England that deals with 1.4 million patients every 24 hours. And this is where the 10-year plan really comes in, with a £20.5 billion cash increase, funding on primary and community care increasing by £4.5 billion a year by 2022 or 2023-24, and an ambitious target to make sure that in 10 years' time, 55,000 more people will survive cancer each year. And my ask of the Minister is that as we increase this funding, please can Worcestershire get its fair share. But of course, it's not all about hospitals and it's not all about funding. And I welcome the renewed focus on prevention, which of course we all need to take some personal responsibility for, as do the food and drink manufacturers, as well as advertisers. And I welcome the renewed focus on mental health and the parity on mental health, £2.3 billion in extra funding, which will give 350,000 more children and 370,000 more adults the support that they so desperately need. And in contrast to the Honourable Member for Central Ayrshire, I welcome all the changes that we will have with digital and technology investment, which isn't to replace humans, but to be able to enhance their productivity. And I think that's a fantastic improvement that we should all welcome. Madam Deputy Speaker, I will keep my comments short. I have further comments to make. I'm sure I can write to the Minister, and I'm confident, as always, he will respond. I really welcome these plans and welcome the focus we've had today.
Thank you, Madam Deputy Speaker. In May 2018, I introduced my private member's bill on palliative care, and I know that investment in palliative care will help save the NHS billions. Whilst the long-term plan does deal with some aspects of end-of-life care, it does not go far enough. There is still a postcode lottery when it comes to hospice funding, with some areas getting up to 50% of their funding from CCGs, whilst other areas get as little as 1%. We'll all be living longer, and it's vital that we put in place proper funding for hospices and end-of-life care. I'm very lucky to have North London Hospice Health and Wellbeing Centre in my constituency. They provide excellent services for users, but I'm still staggered that they have to constantly fundraise to keep these services going. These services are vital and should not be dependent on people's charity, and I ask the Minister to commit to making all CCGs assess the need for palliative care in their area and provide funds accordingly to meet the need. Another area we need additional investment in is the NHS workforce. In order to address the anticipated rise in cancer with a rise in life expectancy, the Government needs to ensure that measures are in place to deal with training, recruitment and retention of staff. Macmillan Cancer Support state that there are presently 2.5 million people living with cancer in the UK, and that figure is expected to reach 4 million by 2030. This will put huge pressure on the NHS cancer workforce for the foreseeable future. There is particular concern for breast cancer specialists. For every 3 breast radiographers that retire over the next 5 years, only 2 are expected to replace them. Breast Cancer Now have called on the Government to invest £39 million into recruitment to the breast imaging diagnostic workforce as part of this plan to cover the cost of training to fill clinical radiologist vacancies and to address the current shortfall of radiographers. The problem has also been compounded by the delay in the production of the Phase 2 of the Cancer Workforce Plan, which should have been an integral part of the long-term plan. Health Education England must produce Phase 2 of the Cancer Workforce Plan, which looks at how many staff are needed to meet growing patient demand, which can then be set out in the 10-year cancer workforce. Unless the government get the workforce planning right, I have serious concerns that patients will suffer. I urge the Minister to take action to deal with these matters urgently.
Thank you, Madam Deputy Speaker. Colchester Hospital has always been a good hospital with caring, compassionate staff. And it has not been without its difficulties, being in special measures 2013 to 2017. But I'm pleased to report that our hospital really has turned a corner. It took hard work, determination and passion to get Colchester Hospital out of special measures. And I must pay tribute to all of those that made that happen: the doctors, the nurses, healthcare assistants, porters, cleaners, administrators and managers. In particular, I would like to praise Nick Hume, the Chief Executive, who displayed incredible leadership, helping change the culture of the organisation, moving the emphasis away from getting out of special measures and instead simply concentrating on improving care. And, Madam Deputy Speaker, the future of our hospital looks really bright. We've got a merger with Ipswich Hospital, creating resilience of the organisation, world-class radiotherapy centre, a new imaging centre, the first of its kind in the country. It is now one of the best performing hospitals in delivering the A&E 4-hour standards. It is one of the best in the east of England for ambulance handovers, and we have one of the lowest nurse vacancies for years. Staff want to come and work in Colchester, and that is fantastic. Now, as for the future, we have a new cancer centre currently being built, and I would like to thank all of those kind donors and members of the public in Colchester and beyond that are helping to fund that. We still have around £200,000 to go, so I'd encourage people to support COHOC. But in terms of further investment, we've got the merger with Ipswich, which will create economies of scale, potential for specialism, resilience, and it will make our hospital trust more attractive to staff in terms of current staff and recruitment. We've also had, and I thank the Minister for the £35 million of capital investment, the largest and most significant investment in decades, which will see open, modern, spacious entrance and additional space in our A&E and an urgent care centre. But of course, the key to the future of Colchester Hospital is investment in primary care. We want fewer people having to go to our hospitals, instead being able to be treated locally at super GP practices. My final comment, Madam Deputy Speaker, is that please can we want to see real demonstrable improvements in primary care, not just richer GPs, and we want to make sure that we're not taking staff from our hospitals and ambulance service and that we are getting new people into our NHS, because otherwise it'll be counterproductive. Thank you.
I shall be very brief. I'll make one point. I'm pleased that the government has seen the light of previous governments where they made mistakes going for large-scale reorganisation. This government seems to have learned from that, and I'm very pleased. The problem is trusts now seem to turn their attention to community hospitals. I've got two excellent community hospitals in Stroud and the Vale in the Stroud constituency, and we're now facing the loss of radiography time. Minor injury units are facing not closure but restricted opening hours, and the operating theatres are frequently left empty. Now, all this results in is more pressure on the acute hospitals, so it's counterproductive. So if the Minister would look at the impact on community hospitals, which are really important to rural areas, it is vital that we see them playing an integral part in our NHS. Otherwise, as I say, we will just see the acute A&E just snarling up, and that is not acceptable in any way. So I hope that the government will really invest time and effort and encourage trusts to re-evaluate the value of community hospitals.
Shadow Minister Justin Madders.
Thank you, Madam Deputy Speaker. Well, with 5.5 minutes per year of the plan, I suspect we haven't done it quite justice tonight. We did, however, manage to hear from 9 backbenchers during the debate, and whilst I can't refer to every one in the time I've got, I would draw particular attention to the contributions from my honourable friend, the member for Hartlepool, who spoke about the importance of improving GP access, something we can all relate to, and of course the importance of mental health, a big driver in the 10-year plan. My honourable friend, the member for Stroud, makes important points about threats to services in his constituency, which is something we heard from across the chamber. And I was particularly pleased to hear from my honourable friend, the member for Easington, who of course speaks from personal experience experience about cancer treatment. He rightly pointed out the deficiencies in the 10-year plan in relation to this. My honourable friend, the member for Enfield Southgate, was absolutely right to highlight the postcode lottery in palliative care. As it is in other areas such as neonatal care and IVF, it does vary depending on where you live in the country. And he also made a very important point about the cancer workforce. And I just want to say a few words, Madam Deputy Speaker, about the workforce, because in recognising the hugely invaluable work that they do, which we thank them for, we also recognise on these benches at least that without a fully staffed, respected and motivated workforce, the NHS simply will not be able to deliver the service that our constituents deserve. Last June, there was at last some government recognition of the importance of the workforce when it was announced that there was going to be a 10-year plan. And the Foreign Secretary, who was Health Secretary at the time, said, and I quote, "Alongside the 10-year plan, we will also publish a long-term workforce plan recognising that there can be no transformation without the right number of staff in the right settings and with the right skills."
Where is it?
But now we know the workforce plan will not be with us until sometime later this year. So isn't it the case that without a workforce plan, we simply do not know how much of the 10-year plan is actually achievable? Indeed. And as we know, the House of Lords Committee on the Long-Term Sustainability of the NHS said the lack of a workforce strategy represents the biggest internal threat to the sustainability of the NHS. But amazingly, the 10-year plan makes no reference to the actual numbers of staff expected to be employed during this period. And so I put in a written question to the Minister about how many staff the NHS expects to employ by the end of the 10-year period of the plan. And I was told in response, the Department does not hold the data it requested. So there we have it in black and white. The government do not have a clue. I will briefly. Yeah.
I thank you for giving way. Does that not just underline the point, though, that this afternoon, this evening's debate has been so short, so ridiculously short, on such an important subject? We need more time. We need another debate.
Yeah. I thank my honourable friend for his contribution. Of course, we weren't actually meant to be here this week at all, but I think it's absolutely right that this debate took place tonight, and actually we do need another one very shortly. We need a debate on the social care green paper when that comes forward as well. We also need a debate on actually what we're going to do about some of these legislative changes that have been promised by government, because all these things need to take place in the public eye. Yep.
I'm very grateful to my honourable friend for giving way. Very, very briefly, does he agree that we also need a debate, of course, around privatisation, where we're seeing no public consultation around very, very significant changes, like, for example, what is purported to happen to the PET scan centre at Oxford University Hospital's NHS Trust, causing a huge amount of local concern?
I thank my honourable friend for her intervention. She's absolutely right. We know the Secretary of State has been on the record that he wants to stop privatisation, but we have identified a number of very important contracts lasting many years, costing millions of pounds, which should be halted if the government are going to stick to their word. It hasn't happened, and it should do. And actually, the timetable for the publication of the plan itself hasn't gone to plan. Again, I'll quote the Foreign Secretary, who, when he was Health Secretary, said, "We now intend to publish the social care green paper in the autumn, around the same time as the NHS plan." Well, I'm not sure which autumn he was talking about for the social care green paper, but the intention was right, because, as he also said, it is not possible to have a plan for one sector without a plan for the other. But here we are. So, in conclusion, Madam Deputy Speaker, whatever the fine words, gimmicks and spin we have in this 10-year plan, we know the reality is that the NHS is on its knees and it cannot survive another decade of Tory government. It's time for Labour to come to the rescue again.
Last time.
Thank you, Madam Deputy Speaker. I'd like to start by thanking honourable members from across the House for their contributions to the debate today. It is really clear that there is agreement across the House on the importance and the value that we place on our National Health Service, and that is exactly why this long-term plan is such an historic moment for the public, for patients, and of course for the staff that work tirelessly to make our NHS one of the most enduring British success stories. I will try and get to as many of the speakers who we've heard from today. I do agree that we need a much longer debate to fully give justice to this really important subject. But I think it's been quite a collaborative, quite a collegiate debate in many senses. So many backbenchers from across the House have welcomed so many of the promises in the long-term plan. Not quite so much from the front bench, Madam Deputy Speaker. If I could just quite quickly sum it up. They don't like it unless they thought of it first. We aren't putting in enough money, although it's considerably more than they were going to put in their 2017 manifesto, until they had the back of a fag packet recalculation. Why can't they celebrate our NHS, Madam Deputy Speaker? Why can't they celebrate that this government is making the biggest single cash investment in our NHS in its history. And of course, some will question whether the funding is enough for the health service to implement this vital transformation, but I will remind them that this is a fully costed plan developed by NHS leaders and clinicians within the budget agreed by the NHS and with government. We must also remember the future of the NHS isn't just about the additional £33.9 billion cash injection by 2023-24, but spending every single penny of taxpayers' money wisely. That's £148.5 billion in the NHS budget in 5 years' time. And this is important because our NHS is under more pressure than ever before. As the Honourable Gentleman from Mid-Worcestershire said, the increased demand in A&E for Type 1 attendances was 6.8% higher in January this year than in January 2018. That's 2,700 more people through the doors every single day. And of course, publishing one document alone will not translate all of the long-term planned objectives into reality, and that's why the NHS will develop a clear implementation framework by the spring to set out how the commitments should be delivered by local systems and ensure transparency for patients and the public. And that's why, of course, the Secretary of State has commissioned Baroness Harding and working closely with Sir David Behan to lead a number of programmes to develop a detailed workforce implementation plan. The first stage of that will be revealed in the spring, with the rest of it coming forward in the autumn. A key focus is on the long-term plan is the importance of improving patient experience, safety and flow through hospitals. And the long-term plan will support with reforming urgent and emergency care services to ensure patients get the care they need quickly, relieve pressure on A&E departments and manage winter demands. Improving out-of-hospital care will also ensure that people are treated in the most appropriate setting to avoid unnecessary visits to hospital and support quicker discharge too. A number of, I'm not going to give way unfortunately because I've got to try and make a bit of progress. A number of members have spoken about the importance of local provision and community hospitals and local GP services. It's so important that these services are decided and led by local NHS organisations who understand the local community healthcare needs. However, of course, we expect the NHS to work collaboratively to ensure that both urgent and routine care needs are met in a way that ensures the very best possible use of NHS resources. Investment in primary and community services, Madam Deputy Speaker, will be at least £4.5 billion higher, and spend on these services will grow faster than the rising NHS budget. Funding will be provided for an extra 20,000 more other staff working in GP practices. With regard to, I'm not going to because I've got literally a minute left, the long-term plan sets out how we improve prevention, detection, treatment and recovery of major diseases, including cancer, heart attacks and strokes. A number of members have mentioned those today. Patients can expect the introduction of new screening programmes, faster access to diagnostic tests and new treatments, and the use of technology such as genomic testing. Already, NHS England has been testing innovative ways of diagnosing cancer earlier, with sites piloting multidisciplinary diagnostic centres for patients with vague or non-specific symptoms, such as those common in blood cancers. The government has pledged to roll out rapid diagnosis centres nationally to offer all patients a range of tests on the same day with rapid access to results. Mental health has also been raised today, and the long-term plan renews the commitment to grow investment in mental health services faster than the NHS budget overall, with at least £2.3 billion in real terms. Madam Deputy Speaker, this government's commitment to the health service is absolutely clear and undeniable. Our historic funding settlement has enabled the NHS to create a plan for the future of the system which will benefit patients now and indeed in generations to come. I thank members who've spoken, and I haven't been able to get to their points. I will write to those who I didn't cover, but we will continue to support this system as it begins to put this plan into practice.
The question is that this House has considered the NHS 10-year plan. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 6, Speaker's Committee for the Independent Parliamentary Standards Authority. Minister or whip to move?
I beg to move.
The question is as on the order paper. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 7, Joint Committee on the Draft Registration of Overseas Entities Bill. Minister or whip to move?
I beg to move.
The question is as on the order paper. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it.
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Siobhan McDonough.
Thank you, Madam Deputy Speaker. Oh, Mr Deputy Speaker. I'd like to start by putting on record my respect and my admiration for every single doctor, nurse, clinician and staff member at both St Helier and St George's Hospital for their outstanding service and dedication to the health and welfare of my constituents. These remarkable individuals go above and beyond despite facing such extraordinary testing circumstances with 9 years of austerity, leaving our treasured NHS desperately short of staff, services and supplies. And that yet the biggest threat for my constituents to our local hospitals is found far closer to home. For it's in the wild west of South West London NHS who are once again pursuing desperate attempts to close all acute services, including the major A&E and the consultant-led maternity unit at St Helier Hospital. This impact the impact this would have on St George's Hospital, I believe, would be devastating. In this evening's debate, I'd like to outline the reality behind the latest threat to St Helier, branded Improving Healthcare Together 2020-2030. I'd like to challenge every foundation that this programme has been built upon, and I'd like to appeal to the Minister to step in before we see the decomposition of vital health services for my constituents in Mitcham and Morden. But first, I'd like to start with some history. Over almost 2 decades, the NHS in South West London has pursued several irresponsible attempts to close the acute health services at St Helier Hospital on the border of my constituency and move the services to leafy, wealthy Belmont in Sutton. Under different titles and brands and under the guise of countless NHS-funded marketing consultants, the proposal is on repeat with an estimated £50 million now wasted on almost identical consultations and programmes. Each one starts afresh, portraying to the public a neutral outlook when deciding where acute health services should be placed across South West London. The Minister may remember back in 2015 when secret proposals to close St Helier and build a new super hospital in Sutton were overheard by a BBC reporter on a train, bringing those plans to an embarrassing end. Fast forward to 2017 and the programme was repeated, this time titled Epsom and St Helier 2020-2030, and once again professing to assess the pros and cons of where to base acute health services. The public support issued by Chief Executive Daniel Elkeles, the man running the programme, to remove the services to Sutton, somewhat clouded the neutrality of the process.
Lady not agree, I'm grateful for her giving way. Would the Honourable Lady not agree with me that actually the immediately previous proposal actually talked about closing facilities at St Helier and moving them to St George's in Tooting, which was universally unpopular, whereas this current proposal that's on the table that I certainly want to get towards a public consultant talks about one of 3 sites, including relocating a new facility at St Helier Hospital.
Mr Deputy Speaker, my recollection of that particular consultation was that was really the scorched earth strategy of deciding that St Helier and Epsom were going to close and St George's would take the strain. I thank God that that never happened, because we could be in an extraordinarily difficult position had that ever happened. I may sound cynical when I talk about the NHS and their bias against my constituency and against services being on St Helier Hospital, but I have been here several times before. A Freedom of Information request revealed that those running the programme only distributed consultation documents to targeted areas around their preferred site and to just a handful of roads in my constituency. But my constituents care passionately about their local health services, and they will not be ignored, with 6,000 local residents responding to the programme by calling for St Helier to retain all of its services on its current site. Of course.
I thank you for giving way, and I did seek her permission beforehand because anything to do with health, I'm always very interested. I'm here to support the Honourable Lady as well. To centralise the health service means that ill, vulnerable and pregnant women are expected to travel for miles to get medical assistance is totally absurd. Surely it always has to be the health of the patient first and foremost.
With the honourable gentleman, but it also has to do not just distance travelled, but who is travelling that distance. Do they have access to a car? Do they have public transport? The NHS constitution requires that they take into account equalities legislation, that they particularly look at disadvantaged people who are in poor health and how they access services, because they access services differently. As I said, my constituents care passionately about the local health services. And when they responded to the consultation, 6,000 of them sent in cards explaining how they felt and how they wanted St Helier to retain all of its services on its current site. Can you imagine the anger when I found out that the responses had been discounted by the programme? Why? Because they were not on the official documentation. The same documentation that had been disseminated in those targeted letterboxes far away from my constituency. To the public, the Trust portrayed a neutral stance whereby a suitable site would be selected across South West London for their acute services. To the stakeholders in Belmont, they confessed their desire to move the services to their wealthy area. And to mine, they pretended that the consultation would genuinely seek the views of the public. But as my mum always says, much gets more. I'd like to put on record that while I fundamentally disagree with the desire to want to take services away from my constituents, I do recognise that Mr Elkaler's hard work and dedication in leading St Helier Hospital. Fast forward to the present day and the latest brand of Improving Healthcare Together 2020-2030, a programme that is built upon the unstable and unscrupulous foundation of its predecessors, and that once again considers the pros and cons of moving St Helier Hospital's acute services 7 miles away west to Epsom or south to Lethe Belmont in Sutton. The programme was launched last summer. They always choose the summer, Mr Deputy Speaker, undertaking an initial public engagement that is expected to transition to a public consultation this coming summer. But, Mr Deputy Speaker, just 837 people responded to the public engagement, and that's including hundreds of NHS staff and 169 comments on Twitter or Facebook. That is an utterly abysmal response, considering the £2.2 million of taxpayers' money squandered on the programme already. Does the Minister agree with me that it's a complete misuse of taxpayers' funds at a time when our NHS is under such overwhelming pressure? But this is about more than just the future of St Helier Hospital. Because if St Helier Hospital were to lose its acute services, my constituents tell me that they will not turn to Epsom or Sutton, but east to Croydon University Hospital or north to St George's. This is a completely terrifying prospect. Before my Christmas, my constituent Marion was left queuing outside St George's Hospital with her left leg badly infected because the A&E was full. And that was the calm before the storm, with St George's A&E facing its busiest ever week just a fortnight ago. We all remember the winter crisis last year, but the first full week of February this year was 16% higher than last year's equivalent, with a simply staggering 600+ visits every single day. And this is a hospital that already relies on St Helier as its safety valve. The maternity unit at St George's had to temporarily close both in 2014 and 2015, directing women already in labour to St Helier Hospital. That's why a letter sent in November from the chair of St George's Trust to those running the programme is completely astonishing. In the letter, the chair expresses her concern, and I quote, that there is no formal requirement to take account of the impact on other providers when deciding where to relocate acute health services across South West London. It's hard to put into words just how dangerous that disregard is. I'd like to pause briefly to thank the Chief Executive of St George's Hospital, Jacqueline Totterdell, for her hard work and her tenacity in steering one of London's largest hospitals at a time of such difficulty. Because St George's is a hospital under already immense pressure. The plumbing, ventilation and drainage facilities are at breaking point, leading to a bid for £34 million of emergency capital from the Treasury. Does the Minister agree with me that a recent outflow of sewage in a hospital A&E is a clear sign that such emergency funding is justified and, more importantly, urgent? How busy does the Minister think the same A&E will be if the local NHS gets their way and moves St Helier's major A&E to wealthy, leafy Belmont? And will she step in today and require that any proposal to reconfigure health services wholeheartedly takes into account the impact that such a decision would have on all other nearby health providers? Merton Council recognise the devastating impact these proposals could have, and I'd like to put on record my thanks to the leader of Merton Council, Stephen Allen Brittas, the Cabinet Member for Social Care, Tobin Byers, and Ms Hannah Doody, Director of Community and Housing, for their unflinching support. It is so disappointing that those at Sutton Council can so idly stand by. By law, when deciding where acute services should be based across a catchment area of this size, it is fundamental that the level of deprivation and local health needs are acutely understood and thoroughly assessed. And so I read from cover to cover the deprivation and equality analysis produced by a range of external consultancy services as part of their £1.5 million programme fee. At a time when the NHS is so strapped for cash, it's extraordinary that my local NHS seemed to have carte blanche to employ so many consultants on such extraordinary rates. But even I was absolutely astounded by the monumental gaps in the analysis that these consultants have delivered. In the pieces of analysis on deprivation and equality, areas that rely on St Helier Hospital are either absent from the documents or are actively described as falling outside the catchment area. Take Pollard's Hill in my constituency, an area that would be considered deprived in comparison with much of Sutton or Epsom. Wideway Medical Centre is the largest GP surgery here and directs 34% of its patients to St Helier Hospital. But Pollard's Hill is deemed outside St Helier's catchment area. Why does this matter? Because if areas that rely on St Helier Hospital are not even considered in the analysis, how can the potential impact of moving acute services from the hospital be adequately assessed? And Pollard's Hill is not alone. There is no mention in the report of Lavender Fields, despite almost a fifth of Collier's Wood surgery patients and Mitcham family practice patients being directed or referred to St Helier from this ward. Now, of course, I urgently brought the gaps in analysis to the attention of those operating this programme and to the attention of Jane Cummings, Chief Nurse of the NHS. I was pleased that everyone agreed that such significant analysis shortfalls would be addressed and rectified.
For the Honourable Lady being very generous in giving way. would you not agree with me that Collier's Wood is pretty well smack bang next to St George's, and that the proposals that the public engagement was based on last year was that 85% of current patients would still be treated in their current hospital, whether it's St Helier, the new Sutton proposal, or Epsom Hospital?
There's no reason why the honourable member should know, so I'm not trying to be tricky in any way. But Collier's Wood Surgery is the title of a split-site GP surgery, one of which is based in the heart of Lavender Avenue on Western Road, which he probably does know very well, probably drives up and down it a lot, in the heart of one of the most deprived areas in my constituency. And it's where so many people go to St Helier Hospital. And the idea that you can remove an A&E and a maternity unit and keep what's left is a complete nonsense. Because all the testing, all the blood testing facilities, the other tests, all the talented doctors and nurses simply don't stay there. They go. And Chase Farm, in my right honourable friend's constituency of Enfield North, is a wonderful example of that members may want to have a look at. So I'd raise the issues that the areas in my constituency and the very large surgeries had not been included, and I was promised that they would. But months have since passed and the process has proceeded unscathed, with no indication of when such significant gaps will be remedied. The icing on the cake in December, when 3 behind closed doors workshops were run by the programme on the grounds of this deficient evidence, they were designated, I quote, to inform the governing body's decision-making process about how the community and professionals ranked each of the 3 potential sites for acute hospital services. Let me be clear. Hand-picked professionals and members of the public used incomplete evidence to rank Sutton as the preferred site for acute services. The Minister won't be surprised to hear that more participants in the workshop were from Sutton than Merton or Epsom. How can a fair, balanced and rounded opinion be accrued from workshops based on flawed evidence with disputable criteria and participated by an unrepresentative group of people? For these findings to be used in any capacity in the decision-making process would be completely unacceptable. Of course, I understand figures and analysis can always be skewed in one direction or another. If you want to disguise the 76.5-year life expectancy of men in Mitcham West in my constituency, then you include the 84.4-year average in Wimbledon Park and classify your figures by the borough of Merton as a whole. You count cancer rates, stroke rates, mortality rates by borough rather than by ward or lower super output area. You ignore deprived areas of the catchment and proceed full steam ahead with your programme. When will all the gaps in the analysis be completed? When will taxpayers' money stop being splurged on flawed and biased consultations? And when will the madness end? Because here's the reality. Within a mile of St Helier, there are over twice as many people with bad or very bad health compared to those living within a mile of the Sutton site, and almost 4 times the number within a mile of Epsom. Around St Helier, the local population is significantly larger, with considerably more dependent children and more elderly people. Furthermore, the local population to St Helier is far more reliant on public transport, with residents statistically less likely to have access to a car. And despite all of this, when I secured, and I can hardly believe it myself, £267 million from the Department of Health and the Treasury under both the Labour government and the coalition government to rebuild St Helier Hospital, guess what happened? The local NHS sent the money back. Can the Minister confirm whether they will again receive their funding this time round? It's time for some accountability and for the government to step in before even more money is wasted and the future of both St Helier and St George's is thrown into jeopardy. Leave these vital services where they are most needed at St Helier Hospital on its current site.
Caroline.
Thank you very much, Mr Deputy Speaker. I'd like to start by congratulating the Honourable Member for Mitcham and Morden on securing this incredibly important debate on the future of St Helier and St George's hospitals. I'd like to thank her for her continuing interest over what appears to be a period of many years on in healthcare services in South West London, and she's been a incredibly passionate and highly motivated and I would say extremely effective advocate for the interests of her constituents, and I'm sure a lot of the points that she's made today, Mr Deputy Speaker, will be heard beyond these four walls. She's rightly concerned about the future of services at St Helier Hospital, which is run by Epsom and St Helier University Hospitals NHS Trust, and in particular the future of its A&E service. She's absolutely right that the organisation of acute services in South West London does appear to have been discussed for a number of years. In the interest of time, I won't set out the timescales and all the different things that seem to have occurred over this period, but she's already articulated it quite well anyway. In 2018, June 2018, Mr Deputy Speaker, the CCG's published an issues paper which and the challenges faced by local healthcare system and the four key local aims, which were 1, improving the health of the population, 2, delivering care as close to patients' home as possible, 3, ensuring high standards of healthcare across all providers, and 4, maintaining the provision of major acute services within their combined geographies. And the issues paper set out a provisional shortlist with 3 potential options for acute care, which you'll be aware of: locating major acute services at Epsom Hospital and continuing to provide all district services at both Epsom and St Helier Hospital, or locating major acute services at St Helier Hospital and continuing to provide all district hospital services at both Epsom and St Helier Hospital, or locating major acute services at Sutton Hospital and continuing to provide all district services at both Epsom and St Helier Hospitals. The CCG invited comments and suggestions from local stakeholders over a period of 3 months, and the CCGs have stressed that these proposals don't involve closing any hospitals. At this stage, they say that they don't have a preferred local proposal. I understand they are continuing to work with local partners to further develop these proposals, which will include full options appraisal and an impact assessment, and the development of a pre-consultation business case, which of course will have to undergo NHS England assurance, and I'm sure she will make her thoughts known to NHS England about this. Of course.
I'm grateful to my honourable friend for giving way. Would you not agree with me that one thing that a lot of people in Sutton and indeed Merton don't really respect, because St Helier is such an old hospital, is the benefit of actually having a possibly up to £400 million brand new facility, and the benefits that themselves will bring, no matter where it's located?
Well, my honourable friend makes an excellent point, and I think this is clearly, and that's why it's really important that these significant changes aren't made without a consultation, so local people's views can be taken into consideration. And something like a new hospital or changes to the configuration of acute services, the CCG will need to fully consult with the public before making any decisions, but clearly investment in any form is very welcome. And of course,
lists of capital NHS capital programmes in London have appeared in various newspapers, with Imperial Healthcare Trust at the top of those lists, Charing Cross, and other hospitals in that group. St George's is desperate. The sewage came through their sinks, their toilets, in their A&E only a few weeks ago. They're not sure whether the electric's going down, whether the plumbing, the water system has caused considerable health problems to patients. Who's getting the money? And is it all going to South London? Because it certainly would have to all go to South London if there's going to be a brand new hospital anywhere.
Well, she asks an excellent question. What I do know is that the CCGs are working closely with NHS England and NHS to develop the programme's capital scheme prior to the next spending review, with a view to NHS E&I presenting this scheme for funding. And they currently expect that public consultation on proposals that they're talking about not to take place until after the next round of capital bids is concluded, which is likely to be after the autumn. And of course, she's spoken about travel times, and there is a duty to do a travel times analysis when developing proposals, and that will be included in the consultation. And they also have duties, CCGs have duties to reduce inequalities as well. She spoke a lot about the inequalities in her area, and so they need to do impact analysis on that too. I understand that the Honourable Lady is also concerned that any potential changes could increase pressure on St George's Hospital, and she's absolutely right to raise this important point. The Department's very clear that NHS England and local NHS organisations must think about potential impacts on other services, which is why we're developing a more strongly regional approach to design NHS services. And CCGs must consider the impact on neighbouring hospitals that are close to the CCG boundary, such as St George's. Changes to accident and emergency services at any one hospital potentially impact a number of surrounding hospitals. So the 3 CCGs have to engage with neighbours throughout this process. And in addition, the neighbouring CCG can respond to any public consultation, and their response must be taken into account. With regard to the next steps, the Honourable Member will be aware the reconfiguration of services is a matter for NHS England and local NHS bodies. They have to be addressed at a local level rather than in Whitehall, because any local organisations understand the needs of their community. But no changes to the services people currently receive can be made without formal public consultation. They have to have support from GP commissioners. They have to demonstrate strengthened public and patient engagement, clear clinical evidence base. They must be consistent with the principle of patient choice. And the NHS England test on the future use of beds requires them to assure NHS England that the proposed reduction is sustainable over the longer term. The Department's very clear throughout the service change process that local NHS organisations have got to engage with the wider public, also engage with the local MP on these issues, and so I'm sure that her and her constituents will take part in any local engagement as plans move forward. I understand the challenges facing the health economy in South West London have been widely understood for a number of years now, and I recognise and appreciate that the potential changes to local health services are often a cause for great worry and inspire impassioned debate from those involved, and it is time for local partners to work together to find a solution which, as she said, has got to be right for the people of South West London and will secure a sustainable configuration of health services moving forward. And Mr Deputy Speaker, I would like to thank the Honourable Member again for her continued dedication to these health matters.
Honourable friend would give way.
Of course I will.
I'm grateful for giving way just before she concludes. As the Honourable friend mentioned earlier on about the fact that the consultation might be done after the spending review, I've written to the Secretary of State asking him if he'd consider looking at that again, because with the mayoral election coming up next year, a PERDA period would actually mean that it would be delayed effectively for a whole year. So anything more that can be done to bring it forward would be very helpful.
In the nick of time, Mr Deputy Speaker, he made that point very well, so we will definitely make sure that that is passed on. And in that same spirit, I will take another intervention.
Could I ask the Minister to unequivocally put on the record that any consultation document has to go everywhere or nowhere, and that there must be some consideration of how much things cost? I am amazed that the NHS gets so few people to turn up to events they spend so much money on.
Minister. Makes an excellent point, Mr Deputy Speaker. That always amazes me as well, how few people engage in some of the consultations which are often discussing huge sums of money and affect some really important day-to-day provision of essential care services in their area. So yes, of course, consultation has to go to the whole area, and I've already spoken about how it needs to go beyond the area as well and look at the impact on other local services and those that use them. So she's absolutely right to say that consultation has to be effective, and it has to ask everybody that might be impacted by any changes. And with that in mind, Mr Deputy Speaker, I'd like to thank her again for her continued dedication to her constituents in Mitcham and Morden.
The question is, this House to now adjourn. As many of that opinion say aye. Aye. The ayes have it. The ayes have it. Order. Order.
The proceeding has ended. 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 The proceeding has ended.